Tanya Iser, I'm an investigative reporter here at Channel 8. Thank you for joining us on day one of Ken Paxton's impeachment trial in the Senate. The Texas Senate, they are going to be deciding if he will be removed from office and furthermore, whether or not he will be barred from ever serving again as a Texas elected official. He is being tried on 16 impeachment counts, most of them revolving around a friend and campaign donor, Nate Paul. He's accused of using his office systematically to benefit Nate Paul and also allegedly taking bribes and other benefits from Paul. We'll be starting the morning with pretrial motions, and it remains to be seen at this point how soon we will be getting to opening statements, but it seems clear from what we've seen that we'll be getting to them fairly quickly. I'm joined this morning by WFAA's political analyst, Bernadine Sept. She's going to be helping us today walk through what we're going to be seeing. Bernadine, what do you think?
You know what? I'm ready. I think the people of Texas are ready. We're ready to decide what we're going to do about Ken Paxton, our Attorney General. And I think that the senators are ready. And the first part of this trial, when we go through the pre-trial motions, will determine a lot as to where we're going to go in terms of the trial. But I think we're ready. And I think that we want to get past what's going on with Ken Paxton.
Absolutely. I want to start by giving a little bit of background. The road to what we're going to see today began 3 years ago. It was when senior members of Ken Paxton's office came forward. They were upset by his entanglements with Nate Paul. They filed a whistleblower complaint. They went to the FBI, and ultimately that led to a whistleblower lawsuit. And then there was a $3.3 million settlement, which put us on the path that we are set to start today. Now let's take a listen to a story that will explain some of this background.
This vote is expected to take place Saturday at 1 p.m.
As we near Ken Paxton's impeachment trial.
He's in trial for corruption and bribery. The number 3 guy in the state. This hasn't happened in more than 100 years for a statewide official.
I hope the House makes the right decision, but if not, I look forward to a quick resolution of the Texas Senate.
The suspended Attorney General of Texas will face a jury of senators.
There have been 121 ayes and 23 nays. The resolution is adopted.
We should all care if somebody who's elected to represent every single one of us is misusing his office, and that's what the allegation is.
At WFAA, we have the most experienced reporters to cover it.
And we should all care about that.
I agree.
Anchor and senior reporter Teresa Woodard.
So many different controversies.
Anchor and Yolitics co-host Jason Wheeler. He'll be live in Austin from the trial.
Big Republicans.
Senior political reporter, Yolitics co-host, and Inside Texas Politics host Jason Whiteley.
We'll have the live stream. We'll have legal guests on every day.
And investigative reporter Tanya Iser.
And offering analysis.
Every night, 6 and 10 o'clock, we're going to make sense of what has happened that day.
Paxton is facing 20 charges, but he'll be tried for 16.
10 of those 16 relate to one person, a guy named Nate Paul. He's an Austin real estate developer. He's gotten into some issues, into some trouble. The allegations are that Paxton gave Nate Paul special access in exchange for having Paxton's house repaired and renovated in Austin.
It was Paxton's hand-picked deputies who blew the whistle on the Attorney General. He fired them. They then sued and agreed on a $3.3 million settlement.
He had to get that money from the state legislature.
If this legislative body does not vote to pay that, then what would be the next steps? What will happen then?
And that sparked the committee to investigate, at first quietly.
Lawmakers have said if Ken Paxton would not have asked us for that $3.3 million settlement, we wouldn't be here.
I'm just trying to get some clarity. Is the case against the state of Texas, or is it against General Paxton?
The case is against the state.
I don't think that anyone really expected the Republicans in the House to go after the Republican Attorney General.
All 31 senators will have a vote.
If Paxton is found guilty of even one charge, he will be removed from office.
Then they're going to have to take another vote after that could potentially bar him from future office.
Our team has covered it from the beginning.
I'm real curious to see what that witness list looks like when we actually get there.
And we will see through this trial that impacts every Texan.
It matters because democracy.
All right, guys, we had a minor microphone issue. I hope we've gotten it fixed. They've switched out my mic, and we'll see if that's going to work. You know, it's the fun part of doing this live. You know, there's always going to be some kind of technical issue. But Bernadine, let's talk about just the historic nature of what's about to start. It's the first time since 1976 that a sitting elected official has faced removal from office, and in that particular case it would as a district judge, and it's more than 100 years since we've seen a statewide elected official face removal. In that case it was Governor Ferguson in 1916, I believe. It was a really long time ago. And of course this is the first time we've seen an attorney general face removal, the state's top law officer. It's kind of amazing that we've gotten to this point, and this is led by his fellow Republicans, right?
Well, and I think that's why we have not seen so much of this. And where you had the elected officials who were doing things that could be questionable or impeachable, you had a Republican body. The Republicans ran all branches of government, and they were not interested, or it did not come to this level, if you want to look at it, where they were willing to look at removing one of their own, which is going to be very interesting with this trial, because the Republicans would vote to either convict or acquit one of their own. And not only one of their own, one of the highest elected officials in the state of Texas.
Well, and in the Texas House, it wasn't even close. It was the vast majority of the Republicans that voted to impeach.
Which I think was a surprise too, of those who...
I know, I was surprised.
Well, quite frankly, I was not. And I was not only because when you running up to that vote, you know, they were asking our Attorney General to come, suspended Attorney General, to come before the committees and explain why he wanted this $3.3 million, and he refused to do it.
Yeah, and I knew there were people that were upset about it. I mean, Representative Leach, who oversaw the committee in the House that oversees the Attorney General's office, he was very upset. Yeah. About it.
So what in essence, what they said was, okay, if you don't want to come in and explain it, then we'll just impeach you, and they did. So now we're at the situation where it's going to be the Senate, if they're willing to actually convict him and remove him.
So let's take a look. We're looking at a live look from the Senate chambers. You can see Ken Paxton, suspended Attorney General Ken Paxton. People are rising. It looks like maybe things are starting to get underway. Are we getting sound yet from the chamber? Not yet. Okay, so we're not, like I said, we're not getting sound yet from the chamber, but it looks like things are going to get underway here pretty soon. They have said that there's Lieutenant Governor Dan Patrick.
Good morning, everyone. Bailiff, will you bring in the jury?
The judge is in the house.
Yep. Well, let's take a listen to this. Well, okay, it looks like he's preparing to get started here. There we go. It's really, you know, Bernadine, just watching this, I mean, it's so historic. I mean, and typically Patrick and Paxton, they would be considered allies, right? So this would be, I mean, this is pretty amazing. And
you know, when the last time that Paxton ran for re-election, Patrick was reluctant to endorse him.
Interesting.
So, but after the grassroots, look at them.
Yeah, I think we're really
and
about
this
to
is actually occurring in Texas.
It's kind of stunning, really. There's his wife.
There's
Angela Paxton.
Watching online. Every day we begin the Senate session with a prayer, and we will do so every day during this impeachment process.
Look at the gallery hasn't filled up yet, has it?
Well, you know, they only have 40-something tickets for the gallery.
First come, first serve.
Yeah. I know we were able to get one of our photographers in there in the gallery.
Morning, if you would just bow with me, please. Father, we wanted to start off today putting first things first.
Are we getting sound yet? Ryan, are we getting sound yet from the chamber?
Yeah, it's incredibly. We're going to take your mic down.
Okay. Okay. All right, we're gonna listen to what's going on in the chamber.
Occasion, and none of us have ever been a part of a trial of this nature, and really, it's only happened a handful of times in Texas history. So as we come to it this morning, we just first pray that you would just give us wisdom in all the presentation and all the deliberations and just everything that will go on. For those of us who are going to be making the decisions at the end, we just pray for your wisdom and insight. We know the truth is always at the top of your agenda with justice, and we pray that we would see what that is and that we would make decisions in accordance with that. Just want to pray for the Lieutenant Governor. This is a new role for him as presiding officer. We pray for your help for him in that task. I just pray for all of us members of the Senate. We've been here most of this year. And insight. We know that truth is always at the top of your agenda with justice, and we pray that we would see what that is and that we would make decisions in accordance with that. Just want to pray for the Lieutenant Governor. This is a new role for him as presiding officer. We pray for your help for him in that task. I just pray for all of us members of the Senate. We've been here most of this year. We all have a lot of responsibilities back home that are piling up, and we just pray that you would just keep everything moving smooth at home with our families and our businesses and just all our responsibilities so that we can focus all our efforts on this task. But also just pray for good health so that we can all be here every day, all of us who are part of this trial. We pray that we could be here every day, be healthy, be attentive, sleep well, just all those things we need to do the job that you've put us here to do. And Father, again, we just ask just for your guidance, your direction, and we just pray that when all this is over, that all of us will walk away knowing in your eyes that we did the right thing. We ask this in Jesus' name. Amen.
Thank you, Senator King. I will now have, you may be seated, everyone be seated. We will now have our Chief Justice, Nathan Heck, give the oath of office to myself and Judge Lana Myers.
I, Dan Patrick, do solemnly swear
I, Dan Patrick, do solemnly swear
that I will impartially try
that I will impartially try
William Kenneth Paxton, Jr.,
William Kenneth Paxton, Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
submitted
by the House of Representatives. So help me God.
So help me God. Now, Judge Myers.
I, Lana Myers, do solemnly swear
I, Lana Myers, do solemnly swear
that I will impartially perform
the
duties of legal counsel and jurist
the duties of legal counsel and jurist
in the impeachment of
William Kenneth Paxton, Jr.,
Attorney General of Texas. So help me God.
So help me God.
Thank you, Chief Justice. For those in the gallery and again, watching online, we seldom bring out the Sam Houston Bible. We do it at inaugurations and other special occasions. And this is a very significant and serious occasion that will be in the history books. And I thought it appropriate to bring out the Sam Houston Bible, not just for Judge Myers and myself, but for each member of the Senate, the jurors. So we're going to take a few minutes instead of swearing in everyone at one time. And our clerk of the court, Patsy Spa, who I might mention has not missed a session day in 54 years, is dedicated to her service, will present the Bible to each member. I will swear them in. You may choose to put your hand on the Bible or not. That is your decision. And we present the Bible to you. We will do it one by one, starting with Senator Blanco. Repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
I will impartially try Warren Kenneth Paxton Jr.,
I will impartially try Warren Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges submitted to me
upon the impeachment charges submitted to me
by the House of Representatives,
by the House of Representatives,
and a true verdict render according to the law
true verdict rendered according to the law
and the evidence.
and the evidence.
So help me God.
So help me God.
Thank you, Senator. Senator Lamantia. Please repeat after me. I do solemnly swear and affirm
I do solemnly swear or affirm
that I will impartially try Warren Kenneth Paxton Jr., Attorney General,
that I will impartially try Warren Kenneth Paxton Jr., Attorney General,
upon the impeachment charges submitted to me by the House of Representatives,
upon the impeachment charges submitted to me by the House of Representatives,
and a true verdict render
and a true verdict render
according to the law
according to the law
and the evidence.
and the evidence.
So help me God.
So help me God.
Thank you, Senator. Senator Parker. Repeat after me. I do solemnly swear or affirm
Do solemnly swear or affirm
I will impartially try Warren Kenneth Paxton Jr., Attorney General of Texas,
I will impartially try Mr.
Warren?
Paxton, Attorney General of Texas,
upon the impeachment charges submitted to me by the House of Representatives,
on the impeachment charges submitted to me by the House of Representatives,
and a true verdict render
and a true verdict rendered
according to the law and the evidence.
according to the law and evidence.
So help me God.
So help me God.
Thank you, Senator. Senator Hughes. Senator Hughes, repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr., Attorney General of Texas,
Warren Kenneth Paxton Jr., Attorney General of Texas,
upon the impeachment charges submitted to me by the House of Representatives,
upon the impeachment charges submitted to me by the House of Representatives,
and a true verdict render
and a true verdict render
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you, Senator. Senator Springer. Repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
I will partially try
that I will impartially try
Warren Kenneth Paxton Jr., Attorney General of Texas,
Warren Kenneth Paxton Jr., Attorney General of Texas,
upon the impeachment charges submitted to me
upon the impeachment charges submitted to me
by the House of Representatives,
by the House of Representatives,
and a true verdict render
and a true verdict rendered
according to the law and the evidence.
according to the law and evidence.
So help me God.
So help me God.
Senator Johnson. Please repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr., Attorney General of Texas,
Warren Kenneth Paxton Jr., Attorney General of Texas,
upon the impeachment charges submitted
upon the impeachment charges submitted
to me by the House of Representatives,
to me by the House of Representatives,
and a true verdict render
and a true verdict render
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you, sir. Senator Gutierrez. Please repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton, Jr., Attorney General of Texas,
Warren Kenneth Paxton, Jr., Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
submitted to me by the House of Representatives
submitted to me by the House of Representatives,
and a true verdict render according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you, Senator. Senator Miles. Repeat after me. I do solemnly swear or affirm
Do solemnly swear and affirm
that I will impartially try
I will impartially try
Warren Kenneth Paxton, Jr., Attorney General of Texas,
Warren Kenneth Paxton, Jr., Attorney General of Texas,
upon the impeachment charges
upon impeachment charges
submitted to me by the House of Representatives
submitted to me by the House of Representatives,
and a true verdict render
and true verdict render
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you, Senator. Senator Swertner. Repeat after me. I do solemnly swear and affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Jr., Attorney General of Texas,
Warren Kenneth Paxton, Jr., Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
submitted to me by the House of Representatives,
submitted to me by the House of Representatives,
and a true verdict render
a true verdict rendered
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you. Senator Campbell. Please repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton, Jr., Attorney General of Texas,
Warren Kenneth Paxton, Jr., Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
submitted to me by the House of Representatives,
submitted to me by the House of Representatives,
and a true verdict render
and a true verdict rendered
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you. Senator Nichols. Please repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton, Jr., Attorney General of Texas,
Warren Kenneth Paxton, Jr., Attorney General of Texas,
upon the impeachment charges
on the impeachment charges
submitted to me by the House of Representatives,
submitted to me by the House of Representatives,
and a true verdict render
and a true verdict rendered
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you. Senator West. Please repeat after me, Senator. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try that I will impartially try Warren Kenneth Paxton, Jr.,
Warren Kenneth Paxton, Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges brought to me by the House of Representatives, and a true verdict render according to the law and the evidence. So help me God.
So help me God.
Thank you, Senator. Senator Zaffirini. Please repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton, Jr.,
Warren Kenneth Paxton, Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges brought to me by
upon the impeachment charges brought to me by
the House of Representatives,
House of Representatives,
and a true verdict render
and a true verdict render
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you, Senator. Senator Hinojosa. Senator, repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
brought to me by the House of Representatives
brought to me by the House of Representatives
and a true verdict render
and a true verdict rendered
according to the law, the evidence,
and the evidence.
so help me God.
So help me God.
Thank you, Senator. Senator Huffman? Please repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of Representatives,
a true verdict render
a true verdict render
according to the law,
the evidence,
so help me God.
so help me God.
Thank you, Senator. Senator Whitmire. This oath is being taken by all qualified jurors today on the floor who have a vote. Senator Whitmire, repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of the State of Texas,
upon the impeachment charges
on the impeachment charges
brought to me by the House of
brought
Representatives,
to me by the
House of Representatives, and a true verdict rendered
true verdict rendered
according to the law
according to the law
and the evidence,
and the evidence,
so help me God.
so help me God.
Thank you, Senator. Senator Flores? Repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
submitted to me by the House of Representatives
submitted to me by the House of Representatives,
and a true verdict render
and a true verdict render
according to the law
and the evidence,
so help me God.
so help me God.
Thank you, Senator Flores. Senator Sparks. Repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges brought to me
upon the impeachment charges brought to me
by the House of Representatives,
by the House of Representatives,
and a true verdict render
and a true verdict rendered
according to the law
according to the law
and the evidence,
so
help me God.
So help me God.
Thank you, Senator Sparks. Senator King. Please repeat after me. I do solemnly swear or affirm
I do solemnly swear
or affirm
or affirm
I will impartially try
I will impartially try
Warren Kenneth Paxton Jr., Attorney General of Texas,
Warren Kenneth Paxton Jr., Attorney General of Texas,
upon impeachment charges brought to me by
upon impeachment charges brought to me by
the House of Representatives,
the House of Representatives,
and a true verdict render
and a true verdict render
according to the law
and the evidence,
so help me God.
so help me God.
Thank you, Senator. Senator Eckhart. Please repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of Representatives,
and a true verdict render
and a true verdict render
based on the law
based on the law
and the evidence, so help me God.
so help me God.
Thank you. Senator Betancourt. Please repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of
and a
Representatives,
true verdict render
and a true verdict rendered
according to the law
according to the law
and the evidence.
and the evidence.
So help me God.
So help me God.
Thank you. Senator Creighton. Repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of Representatives,
and a true verdict render
and a true verdict rendered
according to the law
according to the law
and the evidence.
and the evidence.
So help me God.
So help me God.
Thank you, Senator Creighton. Senator Middleton. Please repeat after me. I do solemnly swear or affirm
I do solemnly swear and affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
on the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of Representatives,
and a true verdict render
and a true verdict rendered
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you, Senator Middleton. Senator Alvarado. Please repeat after me, Senator. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of Representatives,
and a true verdict render
and a true verdict rendered
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you, Senator Alvarado. Senator Colcourse. Please repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of Representatives,
a true verdict render
a true verdict rendered
according to the law and the evidence.
according to the law and evidence.
So help me God.
So help me God.
Thank you, Senator. Senator Perry. Repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of the State of Texas,
Attorney General of the State of Texas,
upon the impeachment charges
upon the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of Representatives,
a true verdict render
a true verdict rendered
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you, Senator. Senator Hall? Please repeat after me. I do solemnly swear or affirm
Solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of Representatives,
a true verdict render
true verdict rendered
according to the law
according to the law
and the evidence.
and the evidence.
So help me God.
So help me God.
Thank you. Senator Hancock. Repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of Representatives,
a true verdict render
a true verdict rendered
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you. Senator Menendez. Repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
Attorney General of Texas,
Attorney General of the State of Texas,
upon the impeachment charges
on the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of Representatives,
a true verdict render
a true verdict render
according to the law
according to the law
and the evidence.
and the evidence.
So help me God.
So help me God.
Thank you, Senator Menendez. Senator Birdwell. Please repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will impartially try
that I will impartially try
Warren Kenneth Paxton Jr.,
Warren Kenneth Paxton Jr.,
the Attorney General of Texas,
the Attorney General of Texas,
upon the impeachment charges
upon the impeachment charges
brought to me by the House of Representatives,
brought to me by the House of Representatives,
to a true verdict render
and a true verdict rendered
according to the law and the evidence.
according to the law and the evidence.
So help me God.
So help me God.
Thank you, Senator. Senator Birdwell, thank you. Court reporters, would you please stand? If you'll repeat after me. I do solemnly swear or affirm that I will correctly transcribe and report all of the proceedings on the trial of Warren Kenneth Paxton Jr. On impeachment. So help me God. And thank you for being here. Thank you. Officers of the court, if all officers of the court who are assisting in the trial, please step next to our clerk of the court. Raise your right hand. Repeat after me. I do solemnly swear or affirm that I will impartially serve the court during the proceedings of the trial of Warren Kenneth Paxton Jr. On impeachment. So help me God. And thank all of you for preparing over the last several months the Senate for today. Thank you. For the record, I want to announce the counselors for the House of Managers. Please rise when I announce your name. Representative Andrew Murr, Representative Ann Johnson, Representative Briscoe Kane, Representative Terry Canales, Representative Aaron Gamez, Representative Charlie Guerin, Representative Jeff Leach, Representative Oscar Longoria, Representative Morgan Meyer, Representative Joe Moody, Representative David Spiller, and Representative Coney Basut, Dick DeGuerin, Rusty Hardin, Justice Harriet O'Neill, Brian Benkin, Jenny Bravorka, Therese Boyce, Donna Cameron, Isha Dennis, Mark Donnelly, Daniel Dutko, Aaron Epley, Ross Garber, Leah Graham, Lisa Hobbs, Laura Hollingsworth, Megan Moore, Mark White, and Jim Burrow. Did I miss anyone? Thank you. Thank you. Sorry? Mr. Lewis? Armstead Lewis. Thank you, sir. And now, counselors, for the record, I will announce let me get my list here. Attorney General's Counsel, please rise when I call your name. Tony Busby, Dan Cogdell, Ellison Collins, Anthony Dolcefino, Amy Hilton, Christopher Hilton, Colby Holler, Caitlin Jackson, Mitch Little, Joseph Mazzara, Anthony Oso, and Judd Stone. Did I miss anyone? Thank you. You may be seated. I want to first introduce Judge Lana Myers, who is sitting next to me. She will be my legal counsel. I'm neither a lawyer or a judge, so I appreciate her giving of her time to be here today. She served with distinction in the Dallas area as a prosecutor on a criminal court and on the Fifth Court of Appeals. So I want to thank you for being here today. Thank you, Judge Myers. Once again, good morning. For those of you attending today, just a couple of brief remarks in the gallery. All cell phones must be turned off. Other than the media, no recording may be made of the proceedings by those present. We must maintain decorum and no distractions in the gallery, as we will on the floor at all times. We're glad to have you here, but any outburst by anyone in the gallery will result in your removal. So I hope you're with us for the whole time. Our first order of business is to address 24 pre-trial motions submitted by the parties. The deadline for the parties to file pre-trial motions was August 5th. Answers to the motions from the other party were due August 15th. The rules that were written by the senators and passed 25-3 require any motion that could result in dismissal of an article of impeachment to be voted on by the members of the jury, the senators. There are 16 such motions that could result in dismissal of articles of impeachment. Unlike regular session, where members speak and debate on the floor, the members passed rules which do not allow questions, discussions, or debate from the floor. As you know, in a regular trial, a jury does not make public comments during a trial, and neither will this jury. After the members of the court vote on the 16 dispositive motions, I will rule on the remaining 8 motions, which the rules require the presiding officer to do. It is possible that through certain votes by members of the court, some or all of impeachment could be dismissed. If the articles are dismissed, the court will enter a finding that they are dismissed with prejudice, thereby satisfying Article 15, Section 5 of the Constitution, reinstating Attorney General to office. However, if any articles remain after votes on pretrial motions, the rules require we move forward with a trial. We will now take up pretrial motions under the rules. It takes a majority of members present, that is 16 voting members, who are eligible to serve as jurors to grant a motion for dismissal. Per the rules, all motions and answers are required to be filed prior to the trial, and the arguments of the counsel for both sides are contained therein. Members, you have read the pretrial motions and the answers to the motions. For each motion, you will indicate on your voting form, yea or nay. A yea vote is to grant the motion, a nay vote is to deny the motion. The bailiff, as you know, will collect your votes. The clerk will then announce them, each vote and the tally. And after she has tallied the votes, I am required by the rules to confirm your vote is accurate, so I will call each of you one by your name and you will rise in place and state how you voted, yea or nay. As previously mentioned, a motion is considered granted if it receives yea votes from a majority of the members present, which is 16, and who are eligible to serve as jurors. Members, we will now take up motion 22, submitted by respondent Attorney General Paxton. The motion is entitled, No Evidence Motion for Summary Judgment on All Articles of Impeachment. A yea vote is to grant the motion. A nay vote is to deny the motion. Please mark your vote on the voting form. Bailiff, will you collect the votes and bring them to the clerk? Are all of the votes collected, Bailiff? Thank you, Austin. Thank you, Matt. The clerk, Ms. Spa is our Secretary of the Senate. The clerk will now pull the votes at random and read them into the record.
Flores, no. Eckhart, no. Colcourse, yay. Betancourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. King, nay. Sparks, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Perry, nay. La Mantilla, nay. Parker, yay. Hughes, nay. Miles, nay. Gutierrez, Schwartner, nay. Campbell, yay. Nichols, nay. Blanco, nay. Twen- 24 nays, 6 yeas.
I will now confirm the vote of the jury in alphabetical order. Senator Alvarado, you vote. Senator Betancourt,
Yay.
Senator Birdwell,
Nay.
Senator Blanco, Senator Campbell,
Yay.
Senator Creighton,
Yay.
Senator Eckhart,
Yay.
Senator Flores, Senator Gutierrez,
Yay.
Senator Hall,
Yay.
Senator Hancock, Senator Hinojosa,
Yay.
Senator Huffman,
Yay.
Senator Hughes, Senator Johnson, Senator King,
Nay.
Senator Colcourse, Senator LaMantia, Senator Menendez,
Yay.
Senator Middleton, Senator Miles, Senator Nichols, Senator Parker,
Yay.
Senator Perry, Senator Schwertner,
Yay.
Senator Springer,
Yay.
Senator Sparks, Senator West,
Yay.
Senator Whitmire, Senator Zaffarini, 24 nays, 6 yeas. The tally is confirmed. The motion is denied. Members, we are now taking up motion 9, submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Exclude Evidence of Any Alleged Conduct That Occurred Prior to January 2023. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your voting form. Bailiffs, please pick up the votes. Are all votes collected? Thank you, Bailiff. Clerk will pull the votes at random.
Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yea. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, yea. Alvarado, nay. Campbell, yea. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Perry, yea. Colkhorst, yea. Betancourt, yea. Creighton, yea. Middleton, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yea. Eight yeas, 22 nays.
I'll confirm the votes. Senator Alvarado? Senator Betancourt?
Nay.
Senator Birdwell?
Nay.
Senator Blanco? Senator Campbell?
Yay.
Senator Creighton?
Yay.
Senator Eckhart?
Yay.
Senator Flores?
Nay.
Senator Gutierrez? Senator Hall?
Yay.
Senator Hancock? Senator Hinojosa?
Nay.
Senator Huffman? Senator Hughes? Senator Johnson? Senator King?
Nay.
Senator Colkhorst? Senator La Mantilla?
Nay.
Senator Menendez?
Nay.
Senator Middleton? Senator Miles? Senator Nichols? Senator Parker?
Yay.
Senator Perry?
Yay.
Senator Schwertner?
Yay.
Senator Sparks? Senator Springer?
Yay.
Senator West?
Yay.
Senator Whitmire? Senator Zaffarini? Being 22 nays and 8 yeas, the motion is denied. Members, we are now taking up motion 8, submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Articles of Impeachment 1 through 7 and 9 through 20. A yea vote is to grant the motion. A nay vote is to deny the motion. Please mark your ballots. Bill, if you will collect the ballots. All ballots collected. Thank you. Clerk will pull at random and read the votes.
Johnson, nay. Springer, nay. Wortner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Parker, yay. Hughes, nay. Miles, nay. Gutierrez, nay. Zaffarini, nay. Blanco, nay. Lamantia, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Perry, yay. Colcourse, yay. Betancourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Eight yeas, 22 nays.
Members, please confirm your votes. Senator Alvarado?
Nay.
Senator Betancourt?
Yay.
Senator Birdwell?
Nay.
Senator Blanco? Senator Campbell?
Yay.
Senator Creighton?
Yay.
Senator Eckhart?
Yay.
Senator Flores?
Yay.
Senator Gutierrez?
Yay.
Senator Hall?
Yay.
Senator Hancock? Senator Hinojosa?
Yay.
Senator Huffman? Senator Hughes? Senator Johnson? Senator King?
Nay.
Senator Colcourse. Senator Lamantia. Senator Menendez. Senator Middleton. Senator Miles. Senator Nichols. Senator Parker.
Yay.
Senator Perry. Senator Swertner. Senator Sparks. Senator Springer.
Hey.
Senator West. Senator Whitmire. Senator Zaffarini. 8 yeas, 22 nays. The motion is denied. We are now taking up motion number 6, members, submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Quash Articles of Impeachment or Grant Request for Bill of Particulars. A yea vote is to grant the motion, a nay vote is to deny the motion. Mark your ballot. Bailiffs, please collect the ballots. All ballots collected, thank you. The clerk will read the ballots at random.
Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwertner, nay. Campbell, yea. Nichols, nay. West, nay. Blanco, nay. La Mantilla, nay. Parker, yea. Hughes, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yea. Perry, nay. Colcourse, yea. Betancourt, yea. Creighton, yea. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Zaffarini, nay. Six yeas, 24 nays.
To confirm the vote, Senator Alvarado? Senator Betancourt?
Yay.
Senator Birdwell?
Nay.
Senator Blanco? Senator Campbell?
Yay.
Senator Creighton?
Yay.
Senator Eckhart?
Nay.
Senator Flores?
Yay.
Senator Gutierrez?
Yay.
Senator Hall?
Yay.
Senator Hancock? Senator Hinojosa?
Yay.
Senator Huffman? Senator Hughes? Senator Johnson? Senator King?
Nay.
Senator Colcourse? Senator LaMantia? Senator Menendez?
Nay.
Senator Middleton?
Nay.
Senator Miles? Senator Nichols?
Nay.
Senator Parker?
Yay.
Senator Perry? Senator Swertner?
Nay.
Senator Sparks?
Nay.
Senator Springer? Senator West? Senator Whitmire? Senator Zaffarini? There being 24 nay votes and 6 yea votes, the motion is denied. Members, now we are taking up motion 7 submitted by the respondent, Attorney General Paxton. The motion is entitled Request for a Bill of Particulars. A yea vote is granting the motion. A nay vote is denying the motion.
We're doing 7.
Anyone else pick up the votes? All votes collected. Clerk will call the votes.
Campbell, yea. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yay. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Terry, nay. Colkhorst, yay. Betancourt, Betancourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Zaffarini, nay. Six yeas, 24 nays.
Members confirming the vote. Senator Alvarado? Yay. Senator Betancourt?
Yay.
Senator Birdwell? Senator Birdwell, I'm sorry, I didn't hear you.
Nay.
Senator Blanco?
Yay.
Senator Campbell?
Yay.
Senator Creighton?
Yay.
Senator Eckhart?
Yay.
Senator Flores?
Yay.
Senator Gutierrez?
Yay.
Senator Hall?
Yay.
Senator Hancock? Senator Hinojosa?
Yay.
Senator Huffman?
Yay.
Senator Hughes? Senator Johnson? Senator King?
Yay.
Senator Colkhorst? Senator LaMantia?
Nay.
Senator Menendez?
Yay.
Senator Middleton?
Yay.
Senator Miles? Senator Nichols? Senator Parker?
Yay.
Senator Perry? Senator Schwertner? Senator Sparks?
Yay.
Senator Springer? Senator West? Senator Whitmire?
Yay.
Senator Zaffarini? There being 24 nays and 6 ayes, the motion is denied. Oops, sorry. Members now taking up motion 13 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 1. A yea vote is to grant the motion, a nay vote is to deny the motion. Please collect the ballots. All votes counted, all votes picked up further. Thank you. Clerk will read the votes.
Birdwell, nay. Hall, yay. Perry, yay. Colcourse, yay. Bettencourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yay. Hughes, nay. Hancock, nay. Menendez, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Eight yeas, 22 nays.
Confirming the vote, Senator Alvarado,
Yay.
Senator Bettencourt,
Yay.
Senator Birdwell,
Yay.
Senator Blanco, Senator Campbell,
Yay.
Senator Creighton,
Yay.
Senator Eckhart, Senator Flores,
Yay.
Senator Gutierrez,
Yay.
Senator Hall,
Yay.
Senator Hancock, Senator Hinojosa,
Yay.
Senator Huffman,
Nay.
Senator Hughes,
Yay.
Senator Johnson, Senator King,
Yay.
Senator Colcourse, Senator LaMantia, Senator Menendez, Senator Middleton, Senator Miles, Senator Nichols,
Yay.
Senator Parker,
Yay.
Senator Perry,
Yay.
Senator Schwertner,
Yay.
Senator Sparks, Senator Springer,
Yay.
Senator West, Senator Whitmire, Senator Zaffarini.
Yay.
There being 22 nays and 8 yeas, the motion is denied. Members, you have 9 more to vote on. Members, we're taking up motion 14 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 2. You may pick up the motions. All votes collected. Thank you. Clerk will call out the votes.
Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Perry, yay. Oakhorst, yay. Bettencourt, yay. Brayton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yay. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Wortner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Eight yeas, 22 nays.
Confirming the vote, Senator Alvarado. Senator Bettencourt.
Yay.
Senator Birdwell.
Yay.
Senator Blanco. Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart. Senator Flores.
Yay.
Senator Gutierrez.
Yay.
Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman.
Yay.
Senator Hughes. Senator Johnson. Senator King.
Yay.
Senator Colcourse. Senator LaMantia. Senator Menendez.
Yay.
Senator Middleton. Senator Miles.
Yay.
Senator Nichols. Senator Parker.
Yay.
Senator Perry. Senator Swertner.
Yay.
Senator Sparks. Senator Springer.
Yay.
Senator West.
Yay.
Senator Whitmire. Senator Zaffarini. There being 22 nay votes, 8 yea votes, the motion is denied. Members, we are now taking up motion 15 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 3. A yea vote is to grant the motion, a nay vote is to deny the motion. Please pick up the votes. All votes collected. Clerk will call out the vote.
Parker, yay. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Blanco, nay. La Mantilla, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Perry, nay. Colcourse, yay. Betancourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. Ing, nay. Sparks, nay. Flores, nay. Seven yeas, 23 nays.
Confirming the vote, Senator Alvarado,
Nay.
Senator Betancourt,
Nay.
Senator Birdwell,
Nay.
Senator Blanco, Senator Campbell,
Yay.
Senator Creighton,
Nay.
Senator Eckhart,
Nay.
Senator Flores,
Nay.
Senator Gutierrez,
Nay.
Senator Hall,
Nay.
Senator Hancock, Senator Hinojosa,
Nay.
Senator Huffman,
Nay.
Senator Hughes,
Nay.
Senator Johnson,
Nay.
Senator King,
Nay.
Senator Colcourse,
Yay.
Senator Lamantilla, Senator Menendez,
Nay.
Senator Middleton, Senator Miles, Senator Nichols,
Nay.
Senator Parker,
Yay.
Senator Perry, Senator Schwartner,
Yay.
Senator Sparks, Senator Springer,
Nay.
Senator West, Senator Whitmire,
Nay.
Senator Zaffarini.
Nay.
23 nay votes, 7 yea votes. The motion is denied. Members, we're now taking up motion 16 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 4. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your ballot. Please pick up the ballots. All ballots collected. Clerk will read the votes.
Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yea. Airy, nay. Colkhorst, yea. Betancourt, yea. Creighton, yea. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yea. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Wortner, nay. Campbell, yea. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Six yeas, 24 nays.
Confirming the vote, Senator Alvarado. Senator Betancourt. Senator Birdwell.
Yay.
Senator Blanco. Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart. Senator Flores. Senator Gutierrez.
Yay.
Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman. Senator Hughes.
Yay.
Senator Johnson. Senator King. Senator Colkhorst. Senator LaMattia. Senator Menendez.
Yay.
Senator Middleton. Senator Miles.
Yay.
Senator Nichols. Senator Parker.
Yay.
Senator Perry.
Yay.
Senator Swertner.
Yay.
Senator Sparks.
Yay.
Senator Springer.
Yay.
Senator West. Senator Whitmire.
Yay.
Senator Zaffarini. 24 nay votes, 6 yea votes. The motion is denied. Members, we're now taking up motion 11 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 5. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your ballots. Please collect the ballots. All ballots collected? Clerk will read the votes.
Flores, nay. Johnson, nay. Springer, nay. Schwartner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Blanco, nay. Lamantia, nay. Parker, yay. Hughes, yay. Miles, nay. Gutierrez, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Perry, nay. Colkhorst, yay. Betancourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Eight yeas, 22 nays.
Confirming your vote, Senator Alvarado. Senator Betancourt.
Yay.
Senator Birdwell.
Yay.
Senator Blanco. Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart.
Yay.
Senator Flores.
Yay.
Senator Gutierrez.
Nay.
Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman.
Yay.
Senator Hughes.
Yay.
Senator Johnson. Senator King.
Yay.
Senator Colkhorst. Senator Lamantia. Senator Menendez. Senator Middleton. Senator Miles.
Yay.
Senator Nichols. Senator Parker. Senator Perry.
Yay.
Senator Schwertner.
Yay.
Senator Sparks.
Yay.
Senator Springer.
Yay.
Senator West.
Yay.
Senator Whitmire.
Yay.
Senator Zaffarini.
Yay.
22 nays, 8 yeas. The motion is denied. Members now taking up motion 17 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 6. The yea vote is to grant the motion, and nay vote is to deny the motion. Please mark your voting form. This is motion 17, Counselor. Motion 17. If you cannot hear, let me know. Both sides, if you cannot hear clearly, let me know. Please collect the votes. All ballots collected. Clerk will read the vote.
Perry, yay. Colkhorst, yay. Bettencourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, yay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yay. Hughes, nay. Miles, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Gutierrez, nay. Johnson, nay. Springer, nay. Shortner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Nine yeas, 21 nays.
Confirming your vote, Senator Alvarado.
Yay.
Senator Bettencourt.
Yay.
Birdwell.
Yay.
Senator Blanco. Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart. Senator Flores.
Yay.
Senator Gutierrez. Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman.
Yay.
Senator Hughes.
Yay.
Senator Johnson. Senator King.
Yay.
Senator Colkhorst.
Yay.
Senator LaMantia.
Nay.
Senator Menendez.
Yay.
Senator Middleton. Senator Miles. Senator Nichols.
Yay.
Senator Parker.
Yay.
Senator Perry. Senator Swertner.
Yay.
Senator Sparks.
Yay.
Senator Springer.
Yay.
Senator West.
Yay.
Senator Whitmire.
Yay.
Senator Zaffarini.
Yay.
21 nay votes, 9 yea votes. The motion is denied. We're now taking up motion 18 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 8, excuse me. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your ballot. Collect the ballots, please. Members, we would normally take a break about this time, but we will continue. We have 4 more motions, and then I have my 8 motions, which will not take as long to announce, and then we'll take a break at that point. And after that point, we will come back and begin the trial. All ballots in, thank you. Clerk will read the votes.
Hancock, nay. Menendez, nay. Birdwell, yay. Hall, yay. Perry, yay. Oakhorst, yay. Betancourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, yay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yay. Hughes, yay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, nay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Ten yeas, 20 nays.
Confirming the vote. Senator Alvarado?
Nay.
Senator Betancourt? Yay. Senator Birdwell?
Yay.
Senator Blanco? Yay. Senator Campbell?
Yay.
Senator Creighton?
Yay.
Senator Eckhart? Yay. Senator Flores?
Yay.
Senator Gutierrez?
Yay.
Senator Hall?
Yay.
Senator Hancock? Senator Hinojosa?
Yay.
Senator Huffman? Senator Hughes? Senator Johnson? Senator King?
Yay.
Senator Colcourse?
Nay.
Senator LaMantilla?
Nay.
Senator Menendez? Senator Middleton? Senator Miles? Senator Nichols?
Yay.
Senator Parker?
Yay.
Senator Perry? Senator Swartner? Senator Sparks?
Yay.
Senator Springer?
Yay.
Senator West?
Yay.
Senator Whitmire?
Yay.
Senator Zaffarini?
Nay.
There being 20 nays and 10 yays, the motion is denied. We are now taking up motion 19, submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Articles 7 and 15. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your ballots. You may collect the ballots. All ballots collected. Clerk will call the vote.
Senator Blanco, no. Senator LaMantia, no. Senator Parker, yay. Senator Hughes, nay. Senator Miles, nay. Senator Gutierrez, nay. Senator Johnson, nay. Senator Springer, nay. Senator Schwartner, yay. Senator Campbell, yay. Senator Nichols, nay. Senator West, nay. Senator Whitmire, nay. Senator Huffman, nay. Senator Hinojosa, nay. Senator Zaffarini, nay. Senator Hancock, nay. Senator Menendez, nay. Senator Birdwell, nay. Senator Hall, yay. Senator Perry, yay. Senator Colcourse, yay. Senator Betancourt, yay. Senator Creighton, yay. Senator Middleton, nay. Senator Alvarado, nay. Senator Eckhart, nay. Senator King, nay. Senator Sparks, yay. Senator Flores, nay. Nine yeas, 21 nays.
Confirming the vote, Senator Alvarado. Senator Betancourt.
Yay.
Senator Birdwell.
Yay.
Senator Blanco.
Yay.
Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart. Senator Flores.
Yay.
Senator Gutierrez. Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman. Senator Hughes. Senator Johnson. Senator King.
Yay.
Senator Colcourse. Senator LaMantia. Senator Menendez. Senator Middleton. Senator Miles. Senator Nichols.
Yay.
Senator Parker.
Yay.
Senator Perry.
Yay.
Senator Schwartner.
Yay.
Senator Sparks.
Yay.
Senator Springer. Senator West. Senator Whitmire.
Yay.
Senator Zaffarini. There being 21 nays, 9 yeas, the motion is denied. We're now taking up motion 20, submitted by the respondent, Attorney General Paxton. The motion is entitled, Motion to Dismiss Articles 9 and 10. A yea vote is a grant to grant the motion, a nay vote is to deny the motion. Please mark your vote on your voting form. Please pick up the ballots. All votes collected. Clerk will read the vote.
King, nay. Sparks, nay. Flores, nay. Blanco, nay. Lamantia, nay. Parker, yea. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, nay. Campbell, yea. Nichols, nay. West, nay. Whitmer, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yea. Perry, nay. Colcourse, yea. Betancourt, yea. Creighton, yea. Middleton, nay. Alvarado, nay. Eckhart, nay. Six yeas, 24 nays.
Confirming the vote, Senator Alvarado.
Yay.
Senator Bencourt.
Yay.
Senator Birdwell.
Yay.
Senator Blanco.
Yay.
Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart.
Yay.
Senator Flores. Senator Gutierrez. Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman.
Yay.
Senator Hughes.
Yay.
Senator Johnson. Senator King.
Nay.
Senator Colcourse. Senator Lamantia. Senator Menendez. Senator Middleton. Senator Miles. Senator Nichols.
Yay.
Senator Parker.
Yay.
Senator Perry. Senator Perry. Senator Perry. Nay, we can't hear you. So, Senator Schwartner. Senator Sparks.
Yay.
Senator Springer.
Yay.
Senator West.
Yay.
Senator Whitmire. Senator Zaffarini. 24 nay votes, 6 yea votes. The motion is denied. We're now taking up motion 21, submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss or Hold in Abeyance Articles 16 through 20. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your ballot. Please pick up the votes. Members, you have one more motion after this to rule on, and then I will rule on my 8 pretrial motions. Yes. Pardon? Senator West, do you want to approach the bench or the clerk? You may come up.
Find it. Oh,
You may read the votes.
okay. Colkhorst, yay. Johnson, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Perry, yay. Springer, nay. West, nay. Wertner, yay. Campbell, yay. Nichols, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Betancourt, yay. Brayton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Parks, yay. Juarez, nay. Blanco, nay. Lamantia, nay. Parker, yay. Hughes, nay. Miles, nay. Gutierrez, nay. Nine yeas, 21 nays.
Confirming the vote, Senator Alvarado.
Yay.
Senator Birdwell. Senator Birdwell, go ahead. I called you.
Yay.
Senator Betancourt.
Yay.
Senator Blanco. Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart. Senator Flores.
Yay.
Senator Gutierrez. Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman. Senator Hughes. Senator Johnson. Senator King.
Yay.
Senator Colcourse.
Yay.
Senator Lamantia.
Nay.
Senator Menendez.
Yay.
Senator Middleton. Senator Miles.
Yay.
Senator Nichols.
Yay.
Senator Parker.
Yay.
Senator Perry. Senator Swertner.
Yay.
Senator Sparks.
Yay.
Senator Springer. Senator West. Senator Whitmire.
Yay.
Senator Zaffarini. 21 nays, 9 yeas. The motion is denied. Members, this is your last motion to take up. This is motion number 10, submitted by the respondent, Attorney General Paxton. The motion is entitled, Motion to Exclude Evidence Gathered in Violation of the Law. A yea vote is to grant the motion. A nay vote is to deny the motion. Please mark your ballot. Please pick up the ballots. All ballots collected. The clerk will call out the votes.
King, nay. Sparks, yay. Flores, nay. Blanco, nay. Lamantia, nay. Parker, yay. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Swartner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Perry, nay. Colcourse, yay. Bettencourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. Eight yeas, 22 nays.
Confirming the vote, Senator Alvarado. Senator Bettencourt.
Yay.
Senator Birdwell.
Yay.
Senator Blanco. Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart. Senator Flores. Senator Gutierrez.
Yay.
Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman. Senator Hughes.
Yay.
Senator Johnson. Senator King.
Yay.
Senator Colcourse. Senator LaMantia. Senator Menendez. Senator Middleton. Senator Miles. Senator Nichols. Senator Parker.
Yay.
Senator Nichols was nay. I didn't mean to speak over you. Senator Perry. Senator Swertner.
Yay.
Senator Sparks.
Yay.
Senator Springer.
Yay.
Senator West.
Yay.
Senator Whitmire.
Yay.
Senator Zaffirini. Being 22 nays and 8 yeas, the motion is denied. Members and those in the gallery and watching, the senators voted on the rules 25-3, and part of those rules say that all other pretrial motions shall be ruled on by the presiding officer, which is myself. I'll begin with motion 2, submitted by the House Board of Managers. This motion is entitled Motion to Clarify Certain Senate Rules Governing the Impeachment Trial of Warren Kenneth Paxton Jr. This motion was partially addressed by my August 9th exhibit production order. Additionally, the manager's request for clarification on timing has been addressed through an agreement of the parties last week. For those watching, I'll clarify the timekeeping for the trial moving forward. There has been much discussion on the impeachment rule, especially number 17 on time limitations. Each side of the House managers and the Attorney General Paxton has 1 hour for opening statements, 24 hours for presentation of evidence, 1 hour for rebuttal evidence, and 1 hour for final arguments. That's a total of 27 hours for each side. Both parties, the managers and Attorney General Paxton, are in agreement on this issue, which pleases the court. Managers, in this motion, you state, at a minimum, you seek clarification that the time spent by an opposing party on cross-examination will be counted only against the party conducting the cross-examination. Attorney General Paxton's team, you responded that time spent questioning a witness, whether via direct or cross-examination, is charged against the side conducting the questioning. Based on your agreement of last week, this is how the clock will run. For example, House managers, when you call a witness, any direct questioning of the witness counts against your 24 hours. When Paxton's team questions the witness on cross, time will be counted against your clock. I also want to note that the clock will keep running through routine objections. However, if I find that it's being abused by either side, I can always use my discretion to give back the time to the other party. To summarize, so we're clear, what everyone has agreed to, both parties have a total of 24 hours for presentation of evidence, which includes direct, cross-examination, redirect, and recross. Anytime a party questions a witness, whether via direct cross, redirect, recross, the clock will continue to run. And again, in addition to the 24 hours, each party has 1 hour for opening statements, if they choose to make those, 1 hour for rebuttal, and 1 hour for closing arguments. I've also told both sides, if they do not use the full hour allotted for their opening statement, Any remaining time will be added to their 24 hours for presentation of evidence. For example, if one side only uses 30 minutes, they will have 24 and a half hours of time. Finally, managers requested to change the rules regarding the use of wireless mobile devices. A rule change must be submitted in writing during trial and requires a 24-hour layout period. Accordingly, this motion has been addressed and no further action shall be taken. Now I will take up motion 24 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Compel Discovery from House Managers. This motion was addressed by my July 12th discovery order and August 9th exhibit production order. Therefore, no further action on this motion will be taken. Now I'll take up motion 12 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Exclude Inadmissible Evidence. This addresses the issue of political contributions. Because this information is readily available from the Texas Ethics Commission for everyone to read, this motion is denied. Now I will take up motion 23 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion for Notice of Brady Material and Notice of Trial Exhibits. The motion was addressed by my July 12th discovery order and August 9th exhibit production order. Accordingly, no further action is needed on this motion. Now I will take up motion 3 submitted by the House Board of Managers. The motion is entitled Request to Clarify the July 12th discovery order, or alternatively, motion for protective order regarding documents produced to Warren Kenneth Paxton Jr. pursuant to the Senate July 12th discovery order. This motion was addressed by my July 20th reiteration of the orders of the court. Accordingly, no further action on this motion. Now I will take up motion 1 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion for Pretrial Scheduling Order or Pretrial Conference. This motion was addressed by my July 12th discovery order and August 9th exhibit production order. Accordingly, no further action is needed. Now I will take up motion 4 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Preclude Attorney General Warren Kenneth Paxton Jr. from being compelled to testify. This court notes that many factors and circumstances in this proceeding lean more on criminal in nature. The rules require a standard of beyond a reasonable doubt, which is reserved for criminal cases. Exculpatory evidence was required to be produced consistent with criminal cases. The rules require a plea to the court to be guilty or not guilty, which are the pleas exclusively used in criminal cases. Judgments of the court of impeachment are entered as acquittal or conviction, which are operative terms for judgments in criminal cases. And the House of Managers have repeatedly compared the actions of the House of Representatives to a grand jury, as they prefer the articles of impeachment. Grand juries are utilized only in criminal cases. Therefore, the motion is granted. The Attorney General cannot be compelled to testify. This is consistent with the reasoning and judgment in the United States Supreme Court, Boyd versus the United States. The court's ruling is clear. You may not call the Attorney General as a witness. Finally, I will take up motion 5 by respondent Attorney General Paxton. The motion is entitled Motion Challenging Jurors for Cause. That motion is denied. To both parties, what we will do at this point is, and to the members, it's a little odd today because we have a break coming close to the lunch break. So we'll take a short 10-minute break at this one because we're going to break around 12:15 for lunch. We'll take a 10-minute break. Be back in 10 minutes. Before you leave, wait a minute, I haven't dismissed you yet. Okay? To both parties, when we come back, I'll have a short statement about the rules. Then we will read the articles of impeachment. Attorney General Paxton will be asked how you plead after each article. And then we will swear in witnesses, those who are here, and then we will break for lunch. And after lunch will be when the opening statement for those parties that choose to make that will be given. So that's the schedule. It's 11:20. Be back on the floor, ready to go at 11:30. Thank you.
Okay, so we've been watching here almost a little over 2 hours since this started around 9 a.m. They started off by swearing in each a senator, and then we've gone systematically through a number of motions. I think there were 15 or 16 that the senators voted on, and in each case, they agreed to allow them to continue. And I think the takeaway there is that we will have a trial. I mean, there was an effort by Attorney General Paxton's team to try to make it all go away, and the senators clearly did not agree to do that. So let me start by reintroducing Bernadine, our WFAA political analyst, and we're joined by Matt Yarbrough, who is a former federal prosecutor, and you also worked in the U.S. Attorney's Office under John Cornyn, and you were a special counsel in that office, so you know a lot about how that AG's office runs.
That's right.
I want to start with Matt. What's your takeaway from what you saw?
Well, today I found this very interesting. This is not like your normal trial. In most cases, jurors do not get the opportunity to basically rule on motions before the court. The judge handles these motions in these sorts of cases. In this case, we had the jurors sworn in that they would follow the law, they would keep their minds open to see all the evidence and consider that evidence, but yet here they were ruling on pretrial motions to exclude evidence, to knock out articles of impeachment. I do think this gives us a real precursor into how the voting may go, because it kind of bounced between 6 to 8 of the votes against or to exclude this evidence. But this is very unusual. This is not what you saw in the federal impeachment trials on Donald Trump, but it's an interesting rule, the way they took this up today.
Bernadine, what do you think?
It's very obvious that the senators or jurors, they want a trial, they want the evidence presented, they want to see the evidence, and also I think that they want all that evidence out there because depending upon how they vote, they can go back and look at that evidence. But it's clear that these senators want to hear, I was not surprised by Patrick's ruling that the Attorney General would not testify. That was not surprising to me. But he doesn't have to if they're presenting all this evidence.
Right.
And that his team has the opportunity to refute it or look at it or however they want to, but it's very clear that these senators want you to put that evidence on and prove why we should acquit or convict General Paxton.
Well, because if they had voted to approve these motions, basically it would have stopped the trial in its tracks. We wouldn't have a trial.
That's right. It would have stopped everything. But I think it gives us some inside baseball as to what's going to be happening here over the next 2 weeks.
Well, and another thing that was so interesting is the number of Republicans who voted to move this thing forward.
Right.
And if you look at those numbers now, keep in mind I'm not saying how it's going to end because it's too early. But if you look at how these votes were cast, there are enough Republicans to convict. But I'm not saying that that's what's going to happen because it's obvious that they want to look at the evidence. Right.
And let's talk. I want to Jay, can you get those two graphics pulled ready? I'm gonna kind of talk about this. So obviously, this is a political trial, so there are some real differences from a criminal trial. The only punishment in this case, of course, would be removal from office, and that Paxton could be barred from running again for elective offices. But obviously there are some similarities. The court is the Texas Senate, and they're the jurors. The judge is Lieutenant Governor Dan Patrick. Of course, the jury, members of the Texas Senate, and the prosecutors are the House Board of Managers. And now let's pull up this graphic that's going to show what it'll take to convict. There are 31 senators in the Senate, and Paxton's wife is a sitting senator, so she's in the chamber, but she is not allowed to vote. But she'll be counted as present but not voting. And as you're going to see, it'll take 21 senators voting to convict, or 2/3 to remove him from office. And so it's just all very interesting how this both is different and similar. I thought the vote, well, first of all, let me talk about this. There were 6 senators who consistently voted yes. That's Colcourse, Betancourt, Creighton, Campbell, Parker, and Hall. you know a lot more about those 6. Do those 6 surprise you?
No, I did. No. And then Campbell. You know, she is a very good friend, and she also employed the mistress, and it's not alleged mistress because he has admitted to having an affair with her. So she's close to this impeachment as well, and so I was definitely not Hall. No, no, I was not surprised.
You weren't surprised by
but
any
I
of
was
that?
watching. Who I was watching was Parker. See, Parker was one of those yes votes, and he's new.
And he's pretty consistently.
And
I think he was consistent throughout.
Oh, he was.
Yeah.
He was. And the reason I was watching him is because some of my sources and Republicans were watching him as well because he's new.
Mm-hmm.
He's one of the newer senators, and I think that's one of the reasons why he did vote the way he did, because he hasn't been in the district long enough.
Let me talk about this, Matt. What do you think we're going to hear? If let's start with if you were on the House Board of Managers, if you are giving opening statements, what are you going to say?
Well, first off, I think what you're going to see is that they're going to lead in with a theme from the very beginning. They'll probably open the first 30 to 60 seconds. Rusty Roden's the lead prosecutor for the House managers, or the outside attorney that's going to be their trial lawyer, and he will come in with a great theme. They'll start off with that. I imagine they'll probably go through the evidence chronologically from that point on and build up as they go along, and then finish with a great closer at the end of that opening statement. Now, a lot of this will be the evidence will show. You'll see this evidence be coming in. At this point in time, they're not going to really be able to argue conclusory statements.
Right.
But they will be filling in the timeline. But it's going to be interesting to see what will be the theme that they will be leading off, because they practice this. They
you
know
want to
what
tell
they
a story.
present. You want to tell a story, and you know, is this going to be abuse of trust? Is this going to be an abuse of the voters' rights to know and have information before they cast their vote? And of course, things such as bribery and these relationships that were a breach of trust, as well as, you know, in his position. But to me, that theme has probably been set for weeks now, and they'll carry that theme through closing and rebuttal all the way through. They may modify it depending on what DeGuerin does for Paxton, his defense. But overall, that'll be the most interesting thing I'll be watching for.
And if you're Paxton's folks, what do you say? I'm asking you because you're the attorney. I
don't know, and I'm and I'm listening.
It'll be interesting because remember, this is not a courtroom, a traditional courtroom. So they may have a lot of political themes in their opening statement. We've already heard arguments from a number of the PACs that are backing Paxton that all this evidence are wrongdoing, he should be absolved for, because the voters voted on him in 2022. Therefore, he gets papal dispensation, he can move on, and he's done nothing wrong. Mm-hmm. I think that's going to be something they're going to continue to hit. If you noticed on the votes, on the motions, that's where Paxton got the most votes from his Republican fellow senators.
Was that,
and so I think that's going to be a theme that they're going to hit over and over again, is that this information's been out there, the voters considered this, they voted him in. But that really flies in the face, especially of a number of the articles in the impeachment document that the House brought out, which was Paxton actually concealed that information from the lawsuit and the settlement of the $3.3 million to the whistleblowers, who worked in the AG's office. So I think you'll see that counterbalancing, going back and forth with that evidence. But that's what I kind of see them leading off with. I think DeGuerin's going to stay away from things like the mistress, countertops in his house.
Well, those are not things you
like
really
that.
want to talk about if you don't have to.
That's right. And remember, you've got Paxton's wife in the chamber. And so I've got a feeling they're going to stick with the voters voted him in, which is interesting because that would be something in a real federal trial that more than likely a federal judge would put a motion in limine in, which would disallow that evidence from coming in or from either party arguing that point.
Well, it is interesting that, you really can't, the fact that his wife is in the Senate and she counts in the vote totals. I mean, she can't vote, but she affects how many votes they have to get to convict or to acquit.
Yeah, Paxton gets that one vote bump
gives him an
edge
extra bump,
by her being present in the chamber.
And we have a person who's in the chamber, one of our photojournalists, and he has noted that throughout the voting, Angela Paxton was writing down names and how they
Taking
voted,
notes.
and taking notes and checking it twice, I guess. And so, what are your thoughts on that, Bernadine?
Well, you know what is interesting, because she cannot cast a vote, but her mere presence is a vote. So she's helping her husband in that regard, that the mere presence, and of course she probably would get that information, but to preoccupy her mind,
right?
She's taking those votes, she's looked at those votes, and in her mind she's thinking about, they voted to do this and they voted to do that. So it's very interesting. And I always have called her the winner and the loser senator, because she's a winner in the sense that they're not forcing her to vote, but then she's losing too because she has to sit there. You know, she has to sit there. And then and I was listening to an interview that she did a couple of weeks ago, and she was, you know, and quite frankly, you would expect her to defend him, defend his Christianity. But then you look at it and you're saying, I'm listening to you, but he cheated on you. So she's put in that position as well.
That's a hard position to be
in.
in.
So to me, she's a winner and she's a loser. So let's see how she comes out of it. But she just, my heart goes to her if no one else.
But I do think that's interesting, because that, you know, there was a point where Paxton began to get more votes in his favor for some of these motions to dismiss the articles of impeachment.
And we got as high as 10 on one of them.
High as 10, but it started coming back down, and he started losing votes when they got closer to the bribery articles 9 and 10 that deal with the mistress, the girlfriend, the employment of her through Nate Paul, the real estate developer, the countertops, the benefits that he received from this donor, Nate Paul.
Well, and these votes have ensured we're going to hear everything.
We sure are.
We're going to hear it all. Nothing got excluded, and it's all going to be heard. And I thought, but also by having such strict timelines, it's, you know, my math is not great, but it kind of feels like I don't see how it could go much more than 2 weeks. I mean, unless deliberations take a really long time. I mean, who knows? I mean, you know, I've in every trial I've ever covered, every time I thought I knew what might happen, I was always wrong. I never guessed correctly. So, but it feels like if each side has 27 hours total, then, you know, you're looking at about 7 days for the trial, and we're about a half a day in. So, depending on how long deliberations goes, you're looking at maybe 2 weeks.
Well, I think this is critical. At the very end, there were two motions that Patrick ruled on himself. And the ones that I thought were really key were, one, that Paxton would not be compelled.
Were you surprised by that?
No, I wasn't, because, you know, he does have a right against self-incrimination. So one, but to me what that says is the defense counsel is going to try to use more of their cross time. And so basically, if I was DeGuerin or a defense lawyer in this case, what I would do is want to be messing up the manager's case. So they'll go first as the prosecutors or as the House managers, and the plaintiff in the case, they'll go first. And I suspect you'll see DeGuerin and Paxton's team to really try to attack those witnesses through cross-examination. And that's where I think it was very smart for the House managers to make sure that time of their 24 hours that they would receive would not be counted against them. Because DeGuerin might decide he wants to cross a witness for a full day. And when he gets to his case in chief, once the plaintiff or the House managers pass it back to Paxton and they get to put on their case in chief, they would have used up a bulk of a lot of their time in that cross-examination. So it's not like they get to play around and mess up the House manager's case and then hopefully get their 24 hours. It's going to be counted against them if they decide to spend too much time with each witness.
You know, this idea of each side has 1 hour of rebuttal, that's very, I mean...
That's not typical.
No, I mean, that's one area where this really does differ from a criminal trial. I mean, a criminal trial, you do have timelines on opening and closings. That's pretty standard, but timelines on the amount of testimony and presentation of evidence, that's really rare.
That's correct. So when I was a federal prosecutor, you know, a federal judge would say, you know, Mr. Yarborough, you've got 30 minutes for closing, or you get an hour. So I got to choose how much I wanted to put in my upfront closing and how much I wanted to reserve for my rebuttal piece. So typically you might use 30 minutes and reserve 10 or 15 minutes for rebuttal. But you get a full hour for rebuttal on top of your closing. That's a lot.
Well, they want to make sure too that they're given opportunities. Keep in mind now that, and as far as I know, and a lot of times I don't sit in a lot of trials, so you all are the experts in this. And typically these, the lawyers are talking to the jury. But in this case, because you have people who are attending these trials, they're going to go live. These attorneys are talking to their base as well. So they're giving them enough time to grandstand and do whatever they need to do because they have more than one juror. They have the senators, and then they have their base, and then the general public. So, and I think that they were very smart and thoughtful in how they structured this jury. I mean, this trial. If it's political, if it's not civil, and it's not criminal, it's still a trial, and they did an excellent job ensuring that both sides has an opportunity to present what they need to present.
And that's a very good point that you make, is who are they speaking to? Who's the audience?
Right.
Because in my trials, whether they're civil or criminal, typically we have done a lot of trial prep and we've done mock trials or focus groups, wanting to see what did land, what didn't land. I wouldn't be surprised if both teams had their own shadow juries who are watching this direct
Mock
feed.
trials? You think they did mock trials, like mock juries, that kind of thing?
They could have done mock focus groups, mock trials, and furthermore, throughout this process, they might have on a daily basis what's known as a shadow jury who's watching this. And once they get that intel every night, you know, did you like this witness? Did you like the cross-examination? Who was weak? Who was strong? What themes do you think landed for you? We might see that begin to get woven in day after day if something lands, like you said, that speaking to the audience beyond the chamber.
And also,
hold on a second.
polls. You're going to see a lot of polling coming out.
Okay, so it looked like they were.
First, the Texas Constitution
Okay, let's listen.
and the law
Let's take a listen.
require the Senate to receive articles of impeachment preferred by the House of Representatives and try them in the Senate. For the general public, the articles of impeachment are the charges brought by the House. The Senate is committed to...
We're moving forward based on the pretrial motions. I'd like to comment on several of the key rules and procedures for the trial, particularly so we are totally transparent for the public and that everyone knows what is about to happen. First, the Texas Constitution and the law require the Senate to receive articles of impeachment preferred by the House of Representatives and try them in the Senate. For the general public, the articles of impeachment are the charges brought by the House. The Senate is committed to conducting a fair and impartial trial where eligible senators will serve as jurors. We will start each day at 9 a.m. and continue until at least 6, possibly a bit later. Of course, today we started on Tuesday because of the holiday, but next week it will be Monday through Friday and potentially could go to Saturday next week. We will not do Saturday this week. We will break probably every 90 minutes or so for the jurors and the parties to stretch. We'll do it for 20 minutes and we'll be timely and come back. We'll break for lunch about 12:15 most days for 45 minutes till 1. And then we will come back for the afternoon. I'd like to place a couple of things on the record. Officially, the parties have agreed to provide the court and the opposing party with 24 hours of advance notice on witnesses. They plan to call to testify, is that correct? Both sides? Thank you. Additionally, the party said they would agree to the admissibility of certain exhibits. Is that correct? Yes? Hold on one second. We cannot hear. Is that mic on?
Well, we got. Thank you, Your Honor. I apologize.
Start at the beginning. Start at the beginning.
It's a good trial run of screwing up on the technology. I think what I said was Mr. Busby suggested last Wednesday that we decide to get together and agree what could be pre-admitted. We thought that was a great idea. The president thought so, and we assumed that's what was going to happen. On Thursday, we were asked what our position was about their exhibits, and we said we would agree to pre-admit all of their exhibits. They could put in anything we wanted that was on their witness list, and we would not object. They wrote back, they came back and said, is that a precondition? And I said, no, that is our position. We will not object to any of your exhibits. Now, what is your position about ours? We'll get back to you. We didn't hear. We didn't get back. And finally, they wrote back and said, we will not agree to pre-admit any of your exhibits. So that means, in light of what the court said earlier, by the way, do I say court or what do I say? I can handle Mr. President, but I don't know what to refer to the facility.
Court is fine.
Thank you. What that means is that anytime they seek to introduce an exhibit, it's going to come in unobjected to because that was the word we gave them. When we seek to introduce any exhibit, there may be continued objections which are going to slow it down. And so I welcome the court's observation that if that starts taking away somebody's time unfairly, the court has the ability to acknowledge that. And I'm just simply asking at this stage, no action on the part of the court, but an awareness is we thought we were playing fair with what they got in here and represented to you, and we're not taking our word back. These guys wouldn't even negotiate it with us. They wouldn't even talk to us about, we'll agree to some, we won't agree to others. I stand up as a matter of privilege in a House of privilege or Senate of privilege. I just want the court to know, no, we did not have an agreement on pre-admitting.
Any response?
We'll take a look at them and we'll object if it's appropriate. If it's not appropriate, we will not object. We'll do it like we're supposed to do it. Thank you, Your Honor.
I've heard you both. Okay, I've heard both. Members, if you're watching at home, also know that you may attend in person if you wish. Go to senatetexas.gov for public access guidelines and more information in case you're watching at home and want to come in person. I want to remind the jurors and everyone watching that the juror senators may not consider any evidence unless taken under oath in this chamber. Their decision, your decision, must only be based on the facts and evidence presented here in this chamber, and by considering the credibility of the witnesses testifying here and here only, under oath. No evidence whatsoever outside of this chamber shall be considered for any purpose. This includes anything said in the House impeachment proceedings where no testimony was given under oath. Senators cannot consider anything reported in the news, anything on social media, or anything they have been told by anyone outside of this trial in this chamber, only what you hear under oath testified to in this court, and your belief in those who are testifying. Senate jurors may only consider evidence given under oath in this chamber as you are the sole determiners of the credibility of the witnesses called to testify. One unique aspect of this proceeding is that one senator is the spouse of the accused. The senators adopted rules that make the spouse of the accused ineligible to vote as a juror. They could find no instance where a spouse of any defendant in any type of trial was allowed to be a juror. However, even though Senator Paxton cannot vote, the threshold to convict remains the same. The members kept the threshold at 2/3 of 31 senators, which would still require 21, even though only 30 members are voting. So the threshold is still 21 votes. At the end of the trial, the members will deliberate in private as any jury would. To be clear, the presiding officer, I do not have a vote on guilt or innocence. I will not give any member my opinion on how they should vote. In deliberations, the senator jurors will consider the following. Did the House managers prove beyond a reasonable doubt any article of impeachment against Attorney General? And if so, shall that article be sustained, which would result in removal from office? Therefore, it's a two-part question. Even if a member believes the House managers have proven an article beyond a reasonable doubt, the member may only sustain the article if they also believe Attorney General Paxton should be removed from office based on that article. If any one of the 16 articles is sustained against Attorney General Paxton, he'll be removed from office. The jury would then vote one last time on whether he can hold public office again, if that were to occur. Members at home watching, if you wish to read the 31 rules voted 25-3 by the senators, which govern this trial in more detail, they are posted on our website. These are just a few of the rules that will guide this trial, but I hope my statements today clarify some questions that the public may have had or have. After I swear in witnesses who are present, each party may make an opening statement, and after the articles are read, the impeachment articles are read. With that, Attorney General Paxton, please rise. Clerk, please read the articles of impeachment, one at a time, preferred by the House of Representatives.
Articles of impeachment. Article 1, disregard of official duty, protection of charitable organization. While holding office as Attorney General, Warren Kenneth Paxton violated the duties of his office by failing to act as public protector of charitable organizations as required by Chapter 123 Property Code. Specifically, Paxton caused employees of his office to intervene in the lawsuit brought by the Roy F. and Joanne Cole Mitt Foundation against several corporate entities controlled by Nate Paul. Paxton harmed the Mitt Foundation in an effort to benefit Paul.
Senator Paxton, how do you plead?
Attorney General Ken Paxton is innocent and therefore pleads not guilty.
Clerk will read the next article.
Article 2, disregard of official duty, abuse of the opinion process. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to issue written legal opinions under Subchapter C, Chapter 402 Government Code. Specifically, Paxton caused employees of his office to prepare an opinion in an attempt to avoid the impending foreclosure sales of properties belonging to Nate Paul or business entities controlled by Paul. Paxton concealed his actions by soliciting the chair of a Senate committee to serve as straw requestor. Furthermore, Paxton directed employees of his office to reverse their legal conclusion for the benefit of Paul.
Those allegations are untrue, therefore he pleads not guilty.
I didn't mean to step on you. You want to repeat that?
The allegations that I just heard are untrue, therefore Ken Paxton pleads not guilty.
Thank you.
Article 3, disregard of official duty, abuse of the open records process. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to administer the Public Information Law, Chapter 552 Government Code. Specifically, Paxton directed employees of his office to act contrary to law by refusing to render a proper decision relating to a public information request for records held by the Department of Public Safety, and by issuing a decision involving another public information request that was contrary to law and applicable legal precedent.
Attorney General Paxton, how do you plead?
Everything she just said there was false. Therefore, Attorney General Ken Paxton pleads not guilty.
Clerk will read the next article.
Article 4, disregard of official duty, misuse of official information. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to administer the Public Information Law, Chapter 552 Government Code. Specifically, Paxton improperly obtained access to information held by his office that had not been publicly disclosed for the purpose of providing the information to the benefit of Nate Paul.
Attorney General, how do you plead?
Your Honor, those are all untrue. Therefore, Ken Paxton pleads not guilty.
Clerk will read the next article.
Article 5, disregard of official duty, engagement of CAMIC. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem. Specifically, Paxton engaged Brandon Camick, a licensed attorney, to conduct an investigation into a baseless complaint during which Camick issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities.
Attorney General Paxton, how do you plead?
The Attorney General is innocent and therefore pleads not guilty.
The clerk will read the next article.
Article 6, disregard of official duty, termination of whistleblowers. While holding office as Attorney General, Warren Kenneth Paxton violated the duties of his office by terminating and taking adverse personnel action against employees of his office in violation of this state's whistleblower law, Chapter 554 Government Code. Specifically, Paxton terminated employees of his office who made good faith reports of his unlawful actions to law enforcement authorities. Paxton terminated the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. Furthermore, Paxton engaged in a public and private campaign to impugn the employees' professional reputations or prejudice their future employment.
Attorney General Paxton, how do you plead?
Everything she said there, sir, is legally and factually incorrect, and therefore Attorney General Ken Paxton pleads not guilty.
The clerk will read the next article.
Article 7, misapplication of public resources, whistleblower investigation and report. While holding office as Attorney General, Warren Kenneth Paxton misused public resources entrusted to him. Specifically, Paxton directed employees of his office to conduct a sham investigation into whistleblower complaints made by employees whom Paxton had terminated, and to create and publish a lengthy written report containing false or misleading statements in Paxton's defense.
Attorney General Paxton, how do you plead?
The allegations she just referenced are untrue. Therefore, the Attorney General pleads not guilty.
The clerk will read the next article.
Article 8, disregard of official duty, settlement agreement. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by concealing his wrongful acts in connection with whistleblower complaints made by employees whom Paxton had terminated. Specifically, Paxton entered into a settlement agreement with the whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts and testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General.
Attorney General Paxton, how do you plead?
The Attorney General is innocent of those charges and pleads not guilty.
The clerk will read the next article.
Article 9, constitutional bribery, Paul's employment of mistress. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul's employment of a woman with whom Paxton was having an extramarital affair. Paul received favorable legal assistance from or specialized access to the Office of the Attorney General.
Attorney General Paxton, how do you plead?
Those allegations are flat out false. The Attorney General pleads not guilty.
The clerk will read the next article.
Article 10, Constitutional Bribery. Paul's providing renovations to Paxton home. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul providing renovations to Paxton's home. Paul received favorable legal assistance from or specialized access to the Office of the Attorney General.
Attorney General Paxton, how do you plead?
Those allegations are offensive and false. The Attorney General pleads not guilty.
Clerk will read the next article.
Article 15, False Statements in Official Records Whistleblower Response Report. While holding office as Attorney General, Warren Kenneth Paxton made false or misleading statements in official records to mislead both the public and public officials. Specifically, Paxton made or caused to be made multiple false or misleading statements in the lengthy written report issued by his office in response to whistleblower allegations.
Attorney General Paxton, how do you plead?
Stand by that report and therefore plead not guilty.
Your Honor, objection is simply that if he wants to take the stand and testify, we'll welcome that. But otherwise, this is supposed to be a plea from the client. He can enter a plea of not guilty for his client. He can't make speeches as he's doing now, and I object. I ask that he just be instructed to plead not guilty or guilty, whichever he chooses, but not to be making speeches through his lawyer.
Sustained. Clerk will read the next charge.
Article 16, Conspiracy and Attempted Conspiracy. While holding office as Attorney General, Warren Kenneth Paxton acted with others to conspire or attempt to conspire to commit acts described in one or more articles.
Attorney General Paxton, how do you plead?
Absolutely not guilty.
Clerk will read the next article.
Article 17, Misappropriation of Public Resources. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by causing employees of his office to perform services for his benefit and the benefit of others.
Attorney General Paxton, how do you plead?
Again, Your Honor, not guilty.
Clerk will read the next article.
Article 18, Dereliction of Duty. While holding office as Attorney General, Warren Kenneth Paxton violated the Texas Constitution, his oaths of office, statutes, and public policy against public officials, acting contrary to the public interest by engaging in acts described in one or more articles.
Attorney General, how do you plead?
Not guilty.
Clerk will read the next article.
Article 19, Unfitness for Office. While holding office as Attorney General, Warren Kenneth Paxton engaged in misconduct, private or public, of such character as to indicate his unfitness for office, as shown by the acts described in one or more articles.
Attorney General, how do you plead?
Not guilty, Your Honor.
Clerk will read the following article.
Article 20, Abuse of Public Trust. While holding office as Attorney General, Warren Kenneth Paxton used, misused, or failed to use his official powers in a manner calculated to subvert the lawful operation of the government of the state of Texas and obstruct the fair and impartial administration of justice, thereby bringing the office of Attorney General into scandal and disrepute to the prejudice of public confidence in the government of this state, as shown by the acts described in one or more articles.
Attorney General Paxton, how do you plead?
Your Honor, the Attorney General is innocent and we plead not guilty.
You may be seated. Bailiff, do we have witnesses to be sworn in? Please bring them into court.
what we saw just now was they walked through each of the articles of impeachment, and they, one of his attorneys pleaded not guilty, but it was interesting. We had to get to, I believe it was Article 10 before, because he was giving a bit of a extra.
That's right. Tony Busby, who is his counsel, along with Dan Cogden, were using this opportunity to start testifying or arguing as the charges were being led, and started off sort of a little bit, not overly charged with false or that's factually false, but Busby kept escalating and escalating till things such as flat out false or absolutely offensive. And it was great that I think Rusty Roden appropriately and properly stood up and brought it to the judge's attention, or the court's attention, this being Patrick. Patrick did a good job sustaining it.
Okay, let's take a listen.
That the evidence I give upon this hearing by the Senate of Texas of impeachment, charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, and nothing but the truth. So help me God. Ladies and gentlemen, pursuant to Rule 24, the rule has been invoked. The rule means that witnesses, except the members of the court, the parties, and their counsel, must remain outside the hearing of the courtroom at all times while testimony is being heard, except when testifying or until discharged. If you are a witness, please remain in town and available to promptly appear at the Capitol if the court or either party calls on you. You must not converse with each other or with any other person except counsel for the parties concerning the proceedings before the court, and are not to read any report, watch any live stream or broadcast of the proceedings, including news reports or social media, or comment on testimony before the court. Any witness violating this instruction may be punished for contempt, up to 6 months in jail, or a $500 fine. Do you all understand? Thank you. You're dismissed. Members, at this time, we'll break, just because this is the perfect break point, for lunch. Be back at 1, and then we will have opening statements when we return. Thank you. Thank you, pardon.
Okay, so they have broke for lunch, and we're going to have opening statements at 1 o'clock. But let's talk some more about what we just saw. So they went through they read each article of impeachment, and Dick DeGuerin.
So, Steve Busby.
Steve Busby, sorry, I'm getting all the lawyers. Steve Busby. This was
Tony
interesting.
Busby,
Let's talk
Tony
about how that differs from a normal criminal trial. What we saw there with Tony Busby, that's really unusual.
Right. He was using this opportunity to be argumentative and testify on his client's behalf, saying things like absolutely false, this is offensive. That would not happen in a real courtroom in a real trial. What would happen is the defendant would stand, the indictment would be read, the charges, and the defendant would have to acknowledge and say guilty or not guilty. No other words would be spoken. So at this point in time, Tony Busby was really using this opportunity to sort of start infecting the jury pool by giving testimony. And that's the reason why you saw House Counsel Rusty Roden say, Mr. Busby wants to get up on the stand and wants to testify in this case. He's welcome to later on, but either his client needs to say it, guilty or not guilty, or Mr. Busby needs to say that. But this is unusual. You usually don't see that. The other thing I thought was very important was when they swore in the witnesses. If you heard Lieutenant Governor Patrick invoked the rule. When you invoke the rule as to witnesses, what that means is that these third-party witnesses who are not a party to the case, not the defendant or the plaintiff, they're sequestered. They can't talk to each other. They can't be in the courtroom. It's to prevent that witness from hearing another witness statement and begin to change or gain their testimony. Right. By sequestering them and keeping them apart, not allowing them to talk to each other. You heard the court or Patrick instruct them not to read any news reports or discuss this with other third parties. That's really important because a lot of this is going to be, a political show trial, and you're going to have a lot of feedback on a nightly basis. As I mentioned before, I'm sure that both sides have their own shadow juries and focus groups who will be watching this live feed every night, and I'm sure those lawyers are going to be desperate to hear what those folks are saying at the end of the evening as to what happened, what were the positives, what were the negatives, where can they improve their case as they go along.
And that's what kind of makes this kind of quasi-criminal, quasi-political, because it has some hallmarks of a criminal trial, but it's not.
Well, and then I'll say this too, that you're going to see a lot of polling because they're going to get the pulse of what's going on out among the base as well as the general public. But I must say this too, that as of today, because remember we're looking at possibly 2-3 weeks, Patrick is doing an admirable job. He's doing an exceptional job in terms of presiding over these proceedings.
Calling balls and strikes.
I mean, you cannot accuse him of favoring any side. You can't. He even ruled against one of Paxton's motions, but he's doing. It's amazing because, and he does have his team with him, but it's amazing because he is not an attorney. He has never been a judge, but I think that he recognizes that this is part of his legacy, that this is going to be written in the books that Patrick did this, and I think that he wants to do an exceptional job.
Well, I think there were two things for Patrick that was very interesting in this opening round, which is, one, he did make a great decision on that first objection by the House managers and Rusty Roden. Patrick sustained that objection. And that way he shut down Busby from arguing.
I would have been surprised if he hadn't, actually.
Yeah, and it was the right call for sure. I'm sure folks were maybe tugging on the back of his jacket there saying, you need to do something about this. But also remember, Patrick has recused himself. He doesn't get a vote in this. So as the actual judge of this proceeding, he doesn't have a vote in this. He's already said that once the senators deliberate as jurors, he will not influence them or talk to them. So he's got some political cover here. You know what I mean?
Right.
He gets a step back and doesn't have to be a vote. And if you remember, one of the motions put in was political contributions. Because remember, Paxton has made multi-million-dollar contributions from his PACs to Lieutenant Governor Patrick. So, but I do think this puts him in a good position politically, that he doesn't have to make a guilty or not guilty vote when this is all over.
Oh, and also I think the move that you mentioned when he sustained the House managers, I think that it was an extra move to wait until they made that move, because it could have been perceived that he was favoring the House managers by just jumping in. As I say, I'm not the attorney over here, but he's in a good position and he's playing that position very well.
And I want to be clear on some of the names of these attorneys. So the attorneys, the main attorneys for the House Board of Managers, is Dick DeGuerin and Rusty Hardin, and so those are the two main ones for them. And then, of course, Dan Cogdell and
Tony Busby.
Tony Busby, yes. And Tony Busby was the one that was doing the speaking and getting. That's right. But they're known for this, right? I mean, this is kind of these two sets of attorneys, coming out of Houston.
Well, that's the reason why, if the court gives you room, especially as a defense counsel, push it as far as you can. Take the opportunity, because that's what you want to do. Is especially in a case like this where we're not going to see the defendant, they're not going to take the stand. Busby and Cogdell are going to have to speak on his behalf, and they're going to have to be trying to argue and testify for him and do as best as they can to infect that jury pool with their theories without having to put on direct statements or testimonies or incriminate Paxton.
Right. Do you, so you worked in that office and years ago, but still, I mean, you worked in the Attorney General's office. Just talk about the nature of these allegations and just how different the way that office is, in terms of how it's being described and the way it was run, differs from what you recall during your time there.
Right. Now, I mean, I think I had one of the most ethical, outstanding Attorney Generals the state's ever had, in John Cornyn. He had an amazing staff, people from both sides of the aisles, our political views on his staff. Mike McCall was on that staff. He's a great congressman now for Texas. Linda Eads ran the civil section of the Attorney General's office for Texas. She's a fantastic law professor here who taught ethics at SMU. So it was definitely a different place than what we're seeing now with Attorney General Paxton's group. But I think it shows that there were a number of people on his team that were ethical because they were the first people to wave the flag and raise these issues and bring it to public knowledge that Paxton was choosing outside lawyers to investigate the FBI, grand juries, search warrants, judges, all on behalf of his largest donor in Nate Paul. And that's incredibly unusual. I've never seen that at the U.S. Attorney's Office level or at the state level for an Attorney General's office, where the Attorney General is weaponizing his department on behalf of a donor.
Yeah, that's.
But keep in mind, that's why he's impeached. That's why he's impeached, because he's doing the things that are not expected of an Attorney General. And keep in mind too that Ken Paxton is nothing like you've ever seen.
No.
You know, he goes to Washington and stands up with former President Trump and trying to not have this transfer of power. He goes and speaks in front of the Supreme Court trying to overturn an election. So what do you expect? Now, I get what you're saying, but this is how he runs everything in his life. But he has won elections.
But Bernadine, you know politics pretty well in the state of Texas. He's got to be surprised at where he's at right now.
He is. And let me tell you why I think he's even more surprised. He never thought he would have been impeached.
Much less facing
this. And then I think, too, let me tell you something else that surprises him, the fact that he lost on all his motions.
You think he thought he was going to win?
At least one.
Well, you know, I kept
at least
writing down.
one.
Yeah.
He even lost a motion that Patrick ruled on. So I think that he's in a position that he never thought that he would be in, because he has been a winner. You know, he's been a state representative. He's been a state senator. He's been in the same position where he's sitting now. He was never part of an impeachment trial. And then how many times has he won Attorney General? So I think that you get, you know what, you could almost, well, anyway, I don't want to go into that term limited situation, but you have to wonder, when did he think it would stop? And obviously he didn't think it ever would, because they kept voting him in. But I want to point out one more thing before we leave, that keep in mind keep in mind that he did not win this last election outright. He won it during a
they had a runoff.
Runoff.
Yeah.
He had a runoff, and he won the runoff because it became apparent during that time that the primary voters did not want another Bush in office.
Right.
Because you had, so it's not like all these elections that they have just loved him, the Republican Party. But he won in a runoff. But of course he didn't think that he would find himself in this position.
Folks out there who are watching on YouTube or elsewhere, if you've got any questions, I'm watching comments right now on YouTube, so if there's anything you want to ask Bernadine or Matt, we're happy to try to answer it. You know, one of the things that also, I did a story on this last week, was that there were 6 attorneys that worked in Paxton's office, as well as an administrative assistant, that all took temporary leave. And in order for them to work for his defense team, they had to waive ethics rules, specifically for the attorneys, because the ethics rules would have precluded this. And they also had to waive conflict of interest rules. Brent Webster did that, the first assistant attorney general. And then they also were able to draw down their paid leave, which collectively was, I believe, about $120,000. Matt, what are your thoughts on that? I mean, you worked in that office. Does that?
You would think that, just like you don't want the Attorney General of the United States representing or you don't want the Department of Justice Criminal Division representing the Attorney General of the Department of Justice. That's the reason why, whether it's a president or a situation like that, we've had special counsels. And in this case, you would think that his entire defense team would be folks outside of that department who wouldn't have any connection to him. That's what I would hoped would have happened.
It's very unusual, and all the experts I spoke to were, one expert said basically, how can you waive an ethics rule? That was kind of...
I was going to say, I mean, it's remember, they serve at the taxpayers' benefit and the voters' benefit. They're there to represent the state of Texas and Texas residents, not there to defend Ken Paxton.
And by them representing Ken Paxton, taxpayers are paying them to go out and represent someone who has been impeached. It's just amazing, but only in Texas politics.
Well, they exhausted the leave time in June and July, so technically right now
they were trying to say they're doing it on their own dime.
Right.
Right?
Well, but they're still employed.
Yeah, it's a very unusual situation. Hey, Jay, can you cue up that story that I'm talking about, and then just let me know when you're about to play it, and then we'll because I want folks to understand fully what I'm talking about. This was a story we aired last week on these attorneys and how this kind of came about. Yeah, go ahead and play it.
Excellent story.
At the Attorney General's office, there's some of Ken Paxton's staunchest defenders.
There's no court in America that would tolerate a process like this one.
General Litigation Chief Chris Hilton. They're saying my mic is not on. Is my mic up?
Notwithstanding Section 1.
And his Solicitor General, Judge Stone.
I got it on.
In late May, Hilton and Stone both left the AG's office to join the defense team for their former boss, suspended AG Ken Paxton.
Chris Hilton.
But they didn't quit their old jobs Texans pay for. They took a temporary leave of absence. 4 other attorneys and an executive assistant also took temporary leave. You see, it's normally against internal ethics rules for a lawyer employed by the Office of the Attorney General to represent someone other than the state of Texas. But the man who briefly took over when Paxton was suspended, First Assistant Attorney General Brent Webster, waived those rules, writing, "I authorize you to represent Attorney General Paxton in your individual capacity in all matters related to impeachment proceedings."
How do you waive an ethics rule?
Will Pryor served as First Assistant Attorney General under Dan Morales.
Something's either a violation of an ethics rule or it's not.
It's certainly an unusual circumstance.
Jim McCormick served as the State Bar's Chief Disciplinary Counsel.
I'm really struggling to try to figure out why this seems like such a workable arrangement for these lawyers, given their role day in and day out in representing the state of Texas and its taxpayers.
This is about ending the political theater and allowing the Attorney General to get back to the crucial work of fighting for Texans. Thank you.
And here's one fact to know. While they've been on leave, taxpayers have still been paying them. Records show in June and July, Texas taxpayers collectively paid almost $121,000 in paid leave to Hilton, Stone, and the others. Again, that's after they stopped doing their jobs at the AG's office and began defending Paxton against charges he abused his office and took bribes from a friend and political donor.
They shouldn't be paid by the public.
Chase Untermeyer is a former chairman of the Texas Ethics Commission.
They're certainly at liberty to defend him and to be compensated by private sources for defending him, but not on the public payroll.
So how did we get here?
We are beginning with breaking news.
On May 27th, the Texas House impeached Paxton. 3 days later, on May 30th, Stone, Hilton, and 4 other attorneys requested to take a leave of absence to work on Paxton's legal defense. Webster's response? This is approved. We dug through the AG's office employee manual. It says, except in limited circumstances, employees may not accept any employment for legal representation that is in addition to their official position, and employees are generally barred from accepting fees. It also says employees shall not participate in any outside legal activities that could constitute a conflict of interest.
I mean, it does have state consequences, certainly, because he's an elected official, although suspended. You're essentially adverse to the Texas House of Representatives that brought these articles of impeachment.
But Webster wrote in a May 31st memo that he'd concluded their outside legal representation poses no conflict. He wrote that they were not precluded from accepting monetary compensation. The same day Webster wrote that memo, Hilton and Stone started their own law firm called Stone Hilton. That firm employs the other attorneys who took leave.
If someone else is funding this private law firm for these state attorneys to go work in, who are those people?
We reached out to the 6 lawyers on leave to ask, are you being paid by outside sources? If so, what are those outside sources? They have not responded to our questions.
I would encourage them to just resign. I don't know why they handled it this way.
Which brings us to the revolving door statute. That law prohibits former employees from representing or receiving compensation on matters they participated in while working for the state.
The process here has been completely lacking.
Before they went on leave, both Stone and Hilton helped defend Paxton against the claims that led to the impending impeachment trial. But experts say there's a loophole in the law. The law applies to former employees. And right now, Hilton and Stone aren't former employees. They're current employees on leave, defending Paxton.
They need to be one thing or the other. Either they are employees of the Attorney General's office or they are not employees of the Attorney General, in which case they're totally free.
In Dallas, I'm Tanya Iser.
That was very good.
Yeah, thank you. I wanted to make sure that folks understood what we were talking about. And actually, when they were introducing the attorneys for Ken Paxton, Chris Hilton and Judd Stone, and I think maybe 1 or 2 of the others was introduced. So they're clearly directly involved in these proceedings. Your thoughts? I mean, that's so unusual.
It's highly unusual. Like a number of the Jim McCormick from the State Bar is fantastic.
Oh, he was great. He was so helpful.
And if you can't waive a conflict, either you have no conflict or you do. The client waives the conflict. In this case, they're not either one of them.
It's, yeah. And nobody that I talked to could recall any situation that even bore a remote similarity to this. And Hilton and Stone were already very involved in the whistleblower case in their role within the Attorney General's office. And that was what was interesting to me about this whole Revolving Door Act situation, was that if they had, what would have happened? So if they had quit their jobs, then the question would have been, would the Revolving Door Act have come into play? Because that says if you've been involved in a matter, a particular matter, in your job, then you're not supposed to turn around. You're legally precluded from going out and being involved in that matter for good reason. But they didn't quit, so there's kind of seems to be a loophole in that statute. So it was just interesting.
Never contemplated before.
Exactly.
And I talked to a number of experts about it, and like I said, nobody could think of anything. And again, just the general consensus was, if it's ethical, you can't waive the ethics. That was what the experts were telling me. So. Just kind of a wild situation.
Set up a law firm while you're on leave? I don't understand.
And you're employing the others.
Right.
And waive something to benefit you. Just makes no sense.
And then we don't know what kind of outside money they're being paid with.
Who's funding the firm and who's funding the lawyers and their efforts?
Really, because those were really my key, the questions I really wanted to know from them. Who is funding this? Who is paying you? Who is giving you money? Because those are questions. You are still working for the Attorney General's office, and those are questions that taxpayers deserve answers to.
And you're receiving paid leave from the taxpayers.
Yes, and I think, again, it was about $120,000. And we got that information directly from the comptroller's office, office, and then as of the end of July, they had all exhausted that leave. Of the 6 attorneys, one of them had already exhausted her leave, so she never drew anything during that period. 5 of the attorneys did, and then the administrative assistant. And so and then the administrative assistant was actually the person that was part of the paperwork with the Secretary of State's office. So just all very odd and unusual. You just don't see stuff like this.
I'll say again, that's why the head of that organization is being impeached. It's just take liberty. You know, that I'm in control of everything. There are no checks and balances at all. But anyway, we'll see.
Well, somebody asked, I want to make sure before we, because we're going to take a break pretty soon for lunch, and then we'll be back. But one of I want to answer a couple questions from the viewers out there. Somebody asked, what about Governor Abbott? Have we heard from Governor Abbott on any of this? You're the political person. I'm going to ask you, Bernadine.
And we won't, because keep in mind, your Republican Party is pretty much split in this. You have those Paxton supporters who don't think he needs to be impeached. Then you have those who want the process to play itself out. So however Abbott would weigh into it, it's not a win-win for him. And if you know Abbott, he usually does not jump into something that he doesn't see a win-win for himself.
Well, there's no good that comes of it for him, right?
No, there's no positive. If Paxton is convicted, he will appoint someone until either a new election or however he chooses to deal with it. Now, if he's acquitted, he still has to deal with Paxton as an attorney general. So, no, you're not going to see Abbott at all. Not at all.
So go back to one of the questions somebody asked, can Paxton be pardoned by the Republicans in Texas? No, this is not a pardon situation. That was a chat.
Well, and then also,
I mean, they can. The Senate can acquit him on these articles.
But typically, a governor would be able to do it.
But this is not a criminal trial.
That's what I'm saying. So pardons come in play, but not in impeachments.
Yeah, that was just an interesting question because. You just never have seen anything like this, and we haven't had an impeachment trial since the 70s. I got to go back to my notes because I don't trust my memory. I believe it was 1976.
Remember, Governor Abbott is the prior Attorney General.
Right.
So I think that's another reason you're not going to hear from him, because he would be commenting on a position that he held. So no good of it will come from it.
There's no good. I mean, even and you're correct, but if he could benefit from commenting on a position that he previously held, he would comment.
Sure.
So, because that's what the politics is all about. How does it benefit me? Right. And in this instance, it does not benefit Abbott at all.
Before we take a break for lunch, any takeaways y'all want to leave folks with?
Well, we're coming up on opening statements, and so I think this is where we're going to really see
This is where the show starts.
This is where the show starts.
Well, not only that. Well, but not only because it is about politics. Politics is, you can never bet on it, or you shouldn't, and you never know when it's going to change on you.
You know, I took a lot of political classes in college because I was fascinated by it. And I remember one of my professors said that he always would talk about the politics make strange bedfellows. And I feel like we're in that world right now.
Yes.
So.
No permanent enemies, no permanent friends, only permanent issues.
Oh, Bernadine, you're great.
No, that came from Kissinger.
Oh, well,
yes.
Okay, so we're gonna break till 12:50. We're gonna come back at 10 till. When we come back at 12:50, we'll give a recap, and then opening statements are gonna start at 1 o'clock. So we'll see you back here at 12:50. Tanya Iser, I'm an investigative reporter here at Channel 8. I want to introduce my guest, Star Telegram political columnist.
Star Telegram. Thank you,
did you
Tanya.
realize that? I mean, like you got changed from the jobs and everything. But anyway, Star Telegram columnist Bud Kennedy joining us, who the absolute expert on all things political.
Good to see you. Did a great job this morning.
Thank you. Matt Yarbrough, former federal prosecutor, also worked in the Attorney General's office under John Cornyn, so you really are familiar with this office. Now I just want to give a recap. So folks, this morning we went through 15, 16 motions that the senators voted on. Every single one of them voted down. This trial will proceed. They will hear all the evidence. You had 6 senators who voted yay on all of them, and then you had occasionally other senators that would join in voting yay. But for the most part, it was these main 6, and then we can talk about that in a minute with Bud. And then we saw from there Attorney General Ken Paxton's teams. They read the articles of impeachment. They went one by one with his attorney. Okay, hold on. Rusty Hardin going through one by one and saying not guilty, but then adding his own little bit of exposition that ultimately led to an objection, and then Dan Patrick sustaining it. So, Bud, we haven't yet heard from you. What do you think about what we've heard so far today?
Well, I think we ought to know all the senators by now. They went through them all, introduced them. It was like the starting lineup at the game or something, where they have each one stand up and swear on the so-called Sam Houston Bible, which is kind of a capital myth. It's a story that's been passed down that's Sam Houston's Bible. But they tried to set a tone of seriousness for everything. Then they got down to work, hearing the motions, and it was really interesting how many senators voted, not just how many voted for which motion, but it was interesting how close they all were. There were 5 senators, I think, who voted for some of the motions to dismiss, but not all of them. The House, the prosecutors, need 21 votes in order to impeach him on these articles, and so some of the votes passed, but didn't pass by 21 votes. So we'll see when it gets down to the articles, we'll see who votes for which, and where some of these conservative senators fall. That kind of senators like Brian Hughes and Brian Birdwell, who very much aligned with Lieutenant Governor Patrick's team, who voted for some but not all of the motions, and we'll see where they fall.
Did anybody surprise you?
I think those two surprised me. I think that if you just sorted the Senate by faith and values conservative and business conservative, certainly Brian Birdwell and Brian Hughes would certainly be on the same church team with Ken Paxton, but not on the same justice team with him today.
Interesting. It was very fascinating, and there were 6 senators who primarily voted yay, wanting to kick these things out. Colcourse, Betancourt, Creighton, Campbell, Parker, and Hall.
And of course, there we have the closest senators to Lieutenant Governor Patrick. Hughes voting against some, but Betancourt, who's like Patrick's, he does everything Patrick wants done to the Senate, voting the other way. And either he believes strongly that all this should be done away with, or maybe he felt like those were safe votes that he could cast and go back to the voters and say, hey, I tried to put a stop to all this.
Interesting. So, Matt, we're about to hear opening statements, and all these attorneys, these are well-known Houston attorneys, and I think that's why I keep messing up their names, is because I'm a Dallas reporter, and so I've not really covered these guys. I mean, I know who they are, but they're not from up around in our area. But these are really well-known attorneys on both sides, kind of show horses. What are you expecting to hear? We kind of did this earlier, but I want to do it again. What are you expecting to hear from the defense team?
Well, we're about to hear each an hour opening statement from both sides. So the House managers will go first. They're the plaintiff in the case. They're bringing the evidence. They're the ones that have the burden of proof beyond a reasonable doubt. Now remember, that's the highest standard we have in the law of proving evidence in a case. So if they make any of these articles stick, and remember, it only takes one, if they meet their burden of beyond a reasonable doubt, then Paxton cannot remain in his position as Attorney General. I believe with both Rusty Hardin and Dick DeGuerin, both being fantastic trial lawyers. Rusty Hardin does more, I would say, civil litigation, and Dick DeGuerin does more criminal work. I think they're going to be fantastic. I think they're going to come out with a theme that they're going to want to interweave throughout their opening, throughout each piece of evidence, a witness they put up on the stand, so they get to closing.
They're going to tell a story.
They're going to tell a story, and they're going to start painting a picture. Today, you're going to hear a lot more, I think, to start off with. The evidence will show, you will hear. I think they'll start building a story around who the witnesses that will be appearing, what will they be saying. That way, the jurors can begin to identify where the evidence is going to come from and from what person. On the defense side, I think we're going to hear a lot of this, that this has all been looked at by the voters. They've approved it. They voted on this. But remember, that's also contrary to one of the counts or one of the articles in which the House managers say that Attorney General Paxton concealed a lot of the information in the whistleblower case for the $3.3 million payment and did not have that information put before the voters before the 2020 vote took place. So I think we're going to see some competing themes going back and forth, back and forth.
That was one of the articles where the vote was a little closer, I think, was on that one. Do you think it's interesting, and you brought it up, that they have to find him guilty beyond a shadow of a doubt, beyond a reasonable doubt? That was a choice they made in their own rules. They could have chosen to set the threshold as a preponderance of guilt or something like that. Do you think it's interesting they set this higher threshold?
I think it's good from the standpoint that if the House managers win on those articles, I think it's going to show that they brought a fantastic case of direct and even overwhelming circumstantial evidence. If anything, if it does turn out that he is convicted, I think it shows that he was given every benefit of the doubt, for his own protection.
And Tanya, that shows the politics of this,
right,
that they have to go back to the voters and say, look, this was proven beyond a reasonable doubt. We set the highest possible rules for this.
Did you ever think we'd get here, Bud?
Oh, I thought he would have resigned long ago, and I thought that
at what point?
As they keep tightening the net around him by scheduling the Houston trial so close to this, and then all of a sudden the FBI grand jury is convened in San Antonio, and it just seems like that everything's just drawing tighter and tighter. But what you have is a Ken Paxton can't quit, because if he quits, he can't raise any more money for his defense. And so he's in the same situation of a certain presidential candidate, that he can't.
Does he kind of remind you?
He can't step out because he has to keep raising money to pay his legal team. And
it's kind of that ethos of basically never admitting that you've done anything wrong.
Doubling down. Just keep doubling down.
And that's something about this, that all the his own believers and his own faith and values argument would say that he needs to seek forgiveness, and that he needs to apologize and just seek redemption. But instead, he's just doubled down on everything and bowled forward.
When they asked the legislature to approve that settlement back in, I believe it was February, did you foresee that we would be here?
I thought we would be here. I didn't know if we would be here more than one day, Tanya. I thought, at the time, it would be a knockdown that these articles would be dismissed this morning. I didn't think we would be here more than one day. The fact that we are here for more than one day now, I think it really is is a historic moment for the state of Texas.
Okay.
I think that that's really, and here we go.
Okay. Let's take a listen.
You may be seated. Mr. Harden, I am going to take your suggestion into consideration on exhibits if time is spent from your side.
Thank you very much.
Okay. This time, opening statement by the managers.
Mr. Presiding Officer, the Attorney General would like to be heard on one housekeeping matter before that.
Yes.
The Attorney General seeks a ruling from this court that to the extent privileges, attorney-client privilege, executive privilege, et cetera, may apply, those are held by the Attorney General. Now, we're not asking the court to rule that any particular statement or any particular document is privileged at this time, but for purposes of the manager's opening statement and going forward in this case, we ask that this court rule that those privileges, which all attached during the time at which the Attorney General was the actual acting, serving, duly elected Attorney General, attached to him. There were conversations he had with his subordinates, conversations involved with other parties, where he was the client seeking legal advice from subordinates and essentially directing his official functions. And to the extent that those are implicated, we seek a ruling from this court initially that those privileges, if they exist at all, belong to the Attorney General.
Mr. Harden, do you have a response?
Yes, Your Honor. I do want the record to reflect, in light of the court's earlier analogy to a criminal case, I want the record to reflect that the Attorney General apparently is not here. Maybe he's coming at some time today, but I think if we're going to talk about this analogously being a criminal case, that the defendant ought to be ordered to appear throughout this just as everyone else. That's number one. But number two is we're prepared to address this issue. There is a motion to, I think one of the third parties had a motion on the attorney-client issue that they were trying to raise. But I would have thought we would have dealt with this before now, it's just as we were getting ready to do opening statements. They've known they had this issue all along. If the court wants to hear argument on it now, Mr. Garber was always prepared to do it on our side. We'll be glad to engage in argument, but I think it's totally discretionary to the court as you're ready to proceed.
And under the rule, the Attorney General Paxton was required to be here addressing that first point throughout the trial. I'm still thinking of your motion. I want to clarify under, I believe it was Resolution 36, he was required to be here today, but not all day. So let me clarify that. Yes.
As per the rule, he was here at 9 as required. I didn't see anything else in the rule that required him to be here any other time.
You're right, correct.
I was just wondering. It's the only way I can tell too.
That's how Paxton was able to win the motion that he could not be subpoenaed by the House prosecutors to take the stand. And in any criminal trial, this is what Rusty Hardin is arguing on behalf of the House managers, is that this is a criminal trial. The defendant has to be in the chair at all times. But there's a rule out there already that the parties have agreed to that he doesn't have to be there. So it appears to me that everyone is making this up on the fly. They don't really know what's going to happen. And it looks like they're searching for him right now to bring him back to the courtroom. The other wrinkle in this is that Dan Cogden for Paxton's defense team just got up and started arguing that that there's attorney-client privilege and confidentiality with regards to the Attorney General holding the privilege. And so if he went to a fellow prosecutor within the AG's office and said, hey, would you give me some legal advice here? They're arguing that that's privileged and confidential and cannot be brought in as evidence against him. Well, anytime you're talking about attorney-client privilege, it's the client who holds the privilege. Well, if the client ain't in the courtroom, I don't know how you assert the privilege.
Right. Well, let me take a second here to introduce our guest, Matt Yarborough. He is a former federal prosecutor, and he also worked in the Attorney General's office during John Cornyn's tenure, so you're very familiar with the Attorney General's office and how it should function. And then, of course, Star Telegram political columnist Bud Kennedy, who just knows everything there is to know about politics. But we know one thing about this, what we're seeing is what is similar to a criminal trial is just the moment that you think everything is going to go the way it's supposed to, then it doesn't.
So we have the first little elbow bumping between
Right.
Hardin and Busby here, of who's going to get their way and who's going to manipulate Dan Patrick, who isn't a judge. And so he's not a lawyer. He admitted that right up front. So he's getting advice on how to proceed.
Well, and Lana Myers, who is sat on the appeals court. She was previously a district judge, so they've got her there to offer that legal advice. And do you know her pretty well, Matt?
No, I don't, because a lot of the work that I've done has been federal trial work, prosecution. But I mean, it's good that he has someone there as an advisor, that he can talk to. But a lot of these issues should have been raised either on pretrial motions, and a district court judge who's experienced would have said, we just took up 20 motions here. You should have raised this back then. We're doing opening statement now. You can assert that as the evidence, as we begin the evidence portion of the case.
And what we see, Tanya, is that this is not a criminal trial, but we have lawyers who are involved with criminal trials, a judge who's involved with criminal trials, and so they're going to continue to push it. It's in Tony Busby's advantage to push the idea that this has to be run like a criminal trial. It's not. It's laid out in the Constitution. The committee wrote the rules. That's all you have to go by. You don't have to go by any other criminal law.
Well, if it's a criminal trial, Dan Paxton would be in that courtroom.
Right.
Okay. So Matt, let's talk about what you're expecting to see once we do have opening statements.
Well, again, any great trial lawyer, and we've got some great ones here, especially with Rusty Hardin, Dick DeGuerin, and so is Busby and Cogden. They're going to come out with a theme, and watch that first 15 to 30 seconds. Having taught trial advocacy at SMU Law School and the Department of Justice, that's the first thing you teach any student.
Okay, so we're going to go back. Dan Patrick's gaveling in. Let's take a listen.
When we're meeting at the bench, the jury. And members of the jury, I want to remind you that statements made in the opening statement is not evidence, and it's an outline of what they're going to present. With that, Mr. Murr? Yes.
Having a hard time hearing. Those mics are lower. I don't think they were intended maybe for them to be standing at the table talking. That if you could make sure that for those of us who have a hard time hearing in this chamber, that they try to be closer to the microphone.
Yes, Senator. The requirement was to be sitting at the mics at the table, not standing. So when you come to the podium, you can stand, but be sure you get into the mic, because the echoes in here are very difficult. Thank you. Mr. Murr, you have 60 minutes.
Mr. President, Senators, today is an important day. On this day in 1836, Sam Houston, whose Bible you used for your oaths today, was elected President of the Republic of Texas. Today is also an important day because we begin this impeachment trial. While impeachment is rare, the drafters of our state constitution recognized that there are times when this extraordinary remedy is needed to protect the state and its citizens from a public office holder who has abused the power of his office by putting self-interest above that of the people of Texas. The drafters concluded that this great deliberative body, the Texas Senate, is best positioned to determine when this remedy is appropriate. Earlier this year, Mr. Paxton came to the legislature seeking $3.3 million in taxpayer money to settle a whistleblower lawsuit. Mr. Paxton would not answer any questions about the underlying claims. He had successfully blocked any discovery in the case for almost 2 years, and he refused to justify the settlement. The House investigated the serious allegations raised by the whistleblowers. The House uncovered egregious misconduct and abuse of office by the Attorney General of the state of Texas and voted overwhelmingly to prefer articles of impeachment to the Senate. This is why we are here. The allegations in the articles reveal that the state's top lawyer engaged in conduct designed to advance the economic interests and legal positions of a friend and donor to the detriment of innocent Texans. Mr. Paxton turned the keys of the Office of Attorney General over to Nate Paul so that Mr. Paul could use the awesome power of the People's Law Firm to punish and harass perceived enemies. I was raised in rural Texas, where a person's honor is more important than money, where integrity matters, by a family deeply affected by political corruption. This is precisely the type of grave official wrong that our Texas Supreme Court has said warrants impeachment. My grandfather, who was privileged to serve the state of Texas for many years, had a favorite quote from Abraham Lincoln. Nearly all men can stand adversity, but if you really want to test a man's character, give him power. Mr. Paxton has been entrusted with great power. Unfortunately, rather than rise to the occasion, he has revealed his true character. And as the overwhelming evidence will show, he is not fit to be the Attorney General for the state of Texas. Mr. Paxton argues that the Senate should not exercise its constitutional duty to decide whether his conduct merits impeachment, because voters were aware of the allegations and still reelected him. He claims that the Senate should abide by the alleged will of the voters. However, this ignores the intent of our framers of the Constitution. Impeachment was included in the Constitution after the Founding Fathers debated and rejected the idea that elections could singularly protect the public against abusive office holders. In other words, drafters agreed that impeachment was and is necessary to protect against abusive officials because it was simply too easy for them to use the powers of their office to conceal the truth until after the next election. The concept of the forgiveness doctrine is not in our Constitution and does not apply here. The courts have made that very clear. And even if it did, the doctrine presumes that voters know all the facts. The voters did not and do not know the whole truth. Mr. Paxton went to great lengths to hide his misconduct from the public. The evidence will show that he used massive resources of his office to prepare and issue a sham report that allegedly exonerated him. The evidence will show that this report contains false and misleading information about the allegations against him and about the whistleblowers themselves. And he also lied about the independent nature of this investigation. Documents will show that he played a key role in drafting that report. The Constitution says the Senate has the power and the duty to decide this case and to protect the people of Texas from someone who has violated his oath and has shown he does not respect the law. The witnesses and the evidence will show you that Mr. Paxton's conduct merits the exercise of that power. And the witnesses and the evidence will show and prove beyond a reasonable doubt that he should be removed from office and prevented from ever holding a position of trust in the state of Texas again. Mr. Paxton argues that the articles do not allege impeachable conduct because they do not allege that he committed a crime. We do allege that he committed crimes. We have detailed that Mr. Paxton received favors, including home renovations and help in concealing and continuing an extramarital affair, in exchange for the Office of Attorney General punishing Nate Paul's enemies. However, we don't have to show some type of quid pro quo to establish that his conduct should result in impeachment. As the Texas Supreme Court made clear regarding the impeachment of Governor Ferguson 106 years ago, wrongs justifying impeachment don't have to be crimes. Wrongs justifying impeachment are broader than that because they have the purpose of protecting the state, not punishing the offender. Mr. Paxton should be removed from office because he failed to protect the state and instead used the power of his elected office for his own benefit. And this was wrong. The oath of office that we all took to protect the citizens of state and to uphold the laws of this state and this Constitution means something. It isn't just words on paper. It's literally an oath to God. And Mr. Paxton had an obligation not to abuse his office for his own benefit. He betrayed his constituents and the sacred public trust that's been given him. And in Texas, we require more from our public officials than to merely avoid being a criminal. The witnesses you will hear from are remarkable people. Until they refused to follow Mr. Paxton's wrongful demands, they were his most trusted, hand-picked advisors, and they believed in his conservative mission for the office of the Attorney General. The problem isn't that their commitment to conservative governance changed. It is at the end of the day, Mr. Paxton wasn't the man they thought he was. And he wasn't the man he publicly proclaimed to be. His trusted advisors are not rhinos or part of some deep state storyline. They are movement conservatives guided by their faith. These witnesses will explain step by step how they discovered that Mr. Paxton grew increasingly intent and passionate about helping his partner, Nate Paul, escape civil and criminal legal troubles that he was facing. They will describe in chilling detail when they connected the dots of Mr. Paxton's slow creep of corruption. The senior staff were outraged when they discovered that Mr. Paxton had directed a young, inexperienced outside attorney to obtain grand jury subpoenas to harass and interfere with an ongoing criminal investigation. Subpoenas that had been improperly issued to DPS officers, a federal judge, attorneys involved in a civil lawsuit against Nate Paul, and even court staff. And the subpoenas sought intensely personal information, including cell phone and email records. Now, I'm not going to detail in this opening all the allegations against Mr. Paxton. You're aware of many of them. You sit as a unique jury, having known Mr. Paxton and familiar with some of the facts. But even a quick summary of some of the evidence that you're going to hear is shocking. One of Mr. Paxton's many acts of deceit involved a member of this chamber. At a time when the policy of the state was Texas is open for business during COVID, Mr. Paxton directed his staff to issue a legal opinion advising that statewide foreclosure sales not move forward. Mr. Paxton was adamant that the opinion, which came to be known as the midnight opinion, be issued before the end of the weekend, just in time for Nate Paul to use it to avoid a foreclosure sale the following Tuesday. This conduct benefited Nate Paul, and it harmed businesses and people impacted by foreclosure. Mr. Paxton also used the power of this office to harm a charity solely to benefit Nate Paul. The Office of the Attorney General is charged with the responsibility of intervening in lawsuits when it's necessary to assist a charitable organization. As you'll hear, the first and only charitable case Mr. Paxton took a personal interest in was the Mitty Foundation's lawsuit against Nate Paul's entities as an investor. The evidence will show that Mr. Paxton directed his office to intervene in the lawsuit to stay the case and allow the AG's office the opportunity to pressure this charity to accept a lowball settlement offer. This would have saved Nate Paul millions of dollars. The creep of corruption continued when Nate Paul wanted access to confidential investigation materials related to police raids on his home and businesses. In an attempt to learn what the police knew and how they knew it, Mr. Paul submitted multiple open records requests seeking the full police file. Even though no police file may be disclosed due to the well-established law enforcement exception, Mr. Paxton pressured his deputies to authorize the release of this information. Had he succeeded, Mr. Paxton would have created precedent allowing any person under criminal investigation, whether for a violent felony or a sex offense, to obtain confidential information about the investigations of their conduct. Mr. Paxton simply did not care that his request to release information to Nate Paul would have put police and victims across the state at risk. Unfortunately, the House investigation revealed that Mr. Paxton's relationship with Mr. Paul was far more extensive than even his closest advisors knew. Over the course of 3 months, Mr. Paxton personally met with Nate Paul more than 20 times. Many times, Mr. Paxton would ditch his security detail. And Nate Paul even set up a secret Uber account that allowed Mr. Paxton to secretly visit Nate Paul and others. To conceal his efforts, Mr. Paxton communicated in off-the-book ways, using burner phones, encrypted messaging apps, and secret email addresses. Mr. Paxton's brazen abuse of the Criminal Justice Division at the Office of Attorney General is finally what caused 8 of his senior staff to report him to the police. The question that haunts them and should frighten all of us is what would have happened if they had not reported him? How far would Mr. Paxton have gone in using the power of the Attorney General's office to harass and punish his and Nate Paul's perceived enemies and hurt innocent Texans? Mr. Paxton tries to defend his actions by isolating each event and claiming that standing alone they can't support impeachment. You cannot and should not view each act in a vacuum. The evidence will show that they are all connected. They're all connected by Mr. Paxton and his desire to deliver for his partner, Nate Paul. Mr. Paxton will also argue that the acts represent differences of opinion on policy or efforts to help a constituent. But the witnesses will explain to you that Mr. Paxton's actions have nothing to do with implementing conservative policy. And in fact, his efforts violated those very principles. Mr. Paxton's senior advisors were fully aware of the dire consequences of reporting him to law enforcement. They knew retribution would be swift and vicious. The choice they made to report him to the police was one of the hardest of their lives. But they will tell you that there really wasn't a choice at all. Sam Houston, who on this day in 1836 was elected president of a new and free republic, reminded Texans, do right and risk the consequences. Do right and risk the consequences. Doing the right thing is sometimes not easy. Sometimes we must do the right thing in the face of enormous pressure to remain silent. The witnesses felt this pressure. The House felt this pressure. And the Senate is feeling this pressure. It's unfair and it's wrong. But despite the forces that seek to intimidate the Senate, you have taken the first steps toward the truth by giving the people who did the right thing a chance to testify. Despite the attacks that they know will continue to come, the witnesses will do the right thing once more. And they will take this witness stand and they will provide the clarity that the Senate needs and that the public deserves to find out what was really happening behind closed doors. As chair, I resolutely give this statement with the support of and on behalf of the Board of Managers and on behalf of the Texas House. You all provided us with an hour to make an opening statement, but we prefer to yield back the rest of that time to the most important folks that will show up in this room, the witnesses. The same witnesses that Mr. Paxton has been so desperate to discredit and intimidate and to silence. We are honored to be able to give them their day in this honored and rare court where we simply seek justice on behalf of the people of Texas. Thank you, Mr. President.
Does the defense wish to make an opening statement?
We do, Your Honor. I think we have 15 minutes to break. Is that what was in the rules?
You're up right now.
May it please the court. I stand in this hallowed chamber in this historic proceeding on behalf of the duly elected Attorney General of the state of Texas. The prosecution and the press, and I'm sure here, will tell a whopping story. It's a tale full of sound and fury. It signifies nothing. And you may wonder why I say that. Because when we are done, I believe that no matter your party affiliation, and no matter where you stand now, you will conclude what I have concluded, that there is nothing to this. Ken Paxton gave nothing of significance to Nate Paul. Nate Paul received nothing of significance from Ken Paxton. This whole case is a whole lot of nothing. I make my living trying cases to Texas juries. Cases are supposed to be decided only upon the evidence. But I do wonder, are we really going to get a fair trial here? Have you already decided based on what is politically expedient or what's best for you personally? Or is it even possible to get a fair hearing? Especially after this case has been tried in the press, Ken Paxton has been convicted in the press based on ignorance, innuendo, and outright lies. So the question is, will you decide based only on the evidence? Because that's your oath. That's what you swore to do, no matter the consequences. And I urge you to do your duty and do it without fear. They say this is the impeachment of a lifetime. But is it? Because depending on what you do here, maybe it will become commonplace. What happens here will have consequences no matter how it turns out. Let's be clear. If this misguided effort is successful, which I feel confident it will not be, the precedent it would set would be perilous for any elected official in the state of Texas. What is being attempted here hasn't happened in our state in 100 years. And unlike other efforts of the past like this one, this scheme was rushed, it was secretive, it was poorly planned, and was wholly unsupported by evidence. Indeed, despite the social media frenzy, the misinformed commentators, the reporters with an agenda, at the end of this, you will come to know what I know, that despite all of us being told that the evidence in this matter is 10 times worse than the public knows, it is instead 100 times less. There is nothing here to support impeachment, nothing. Now, there's been a gag order in this case. That gag order put our team at a distinct disadvantage. That gag order prevented us from rebutting this false narrative created by a frenzied press. The gag order, of course, didn't stop those media members with agendas or those media outlets aligned with the House managers. and they were calling for Ken Paxton's head. We've heard in the media about burner phones. There are no burner phones, but we couldn't respond. We've heard about secret email addresses. It's so secret that every person on Ken Paxton's staff used the same type of email address because they were traveling to China. There's no secret email address, but we couldn't respond. We've heard about Uber rides for Ken Paxton in Vegas, Chicago, or to even nightclubs. Those were manufactured lies, but we couldn't respond. We've even heard from the press about cakes from H-E-B, stolen pens, pilfered sport coats, outright foolishness, but we couldn't respond. We heard about house renovations supposedly paid for by the manipulating boogeyman, Nate Paul. That never happened. Ken Paxton and Angela Paxton paid for their house renovations, and I'm going to show that absolutely 100%. They know it, but yet they still stood up here and repeated that lie. Let's talk a little bit about some background. In 2015, Ken Paxton ran against the anointed candidate for Attorney General Dan Branch. Branch represented Highland Park and the political elites. Dan Branch was the establishment candidate. Ken Paxton beat him soundly. Almost immediately after that win, Ken Paxton was on the receiving end of a clearly political indictment at the hands of rivals within his own party. That saga continues to this day with a pair of unelected special prosecutors nudging it forward year after year with the expectation and hope that someday they will get paid. Nevertheless, despite being indicted and despite a very public lawsuit that makes the exact same allegations that are being made here, Ken Paxton easily won his last primary, as he has in every election. In fact, Ken Paxton thumped the establishment candidate, who this last time happened to be a Bush. And it wasn't even close. Ken Paxton won 68% to 32% in the primary. Now think about that. General Paxton trounced the establishment candidate, a member of the Bush dynasty, and beat him badly. And incidentally, as an aside, did you realize that the day before the vote for this impeachment was had, that same Bush applied to renew his law license? Let's put this proceeding in context. Almost 30 million people live in the state of Texas. Texans chose at the voting booth who they wanted to be their attorney general, despite the same baseless allegations that are being made here. But because of what this House has done, only 30 people out of almost 30 million will decide whether Ken Paxton is allowed to serve in the office he was voted into. That's not how it's supposed to work. That's not democratic. What could be less democratic than 30 people deciding who serves as the Attorney General of Texas instead of the 4.2 million people who voted to put him there? Every election season we hear, your vote is your voice. It's important to go vote to be a good member of society. We hear about the sanctity of the right to vote. We hear that people fought and died for the right to vote. We hear every vote should count. Yet to get here, Texas House took away the votes of over 4 million Texans who voted for Ken Paxton, and they did it in only a 4-hour hearing. There is a right way for Texas voters to remove someone from office. It's called vote against them. Who the people want, who the people have voted for should matter. Let me give you some names. George P. Bush, Eva Guzman, Louis Gohmert, Dan Branch, Barry Smitherman, Joe Jaworski, Rochelle Garza, Justin Nelson. Those are just some of the people that Texans decided they did not want to be their attorney general. The people chose General Paxton. Do their votes matter? People are watching. The will of those Texans should not be subverted. And people of Texas, let me say this. I am very happy that these proceedings are being live streamed. I think it is good that Texas voters can hear every bit of evidence or the complete lack of evidence that supports this from both sides. I'm sure that the more than 4.2 million people who voted for Ken Paxton will want to hear why. 30 people are deciding his fate. And through all of this, we must not forget, Ken Paxton, for the last 8 years, has operated the most aggressive, effective litigation apparatus of any attorney general's office in the country. According to the pundits, Ken Paxton was never supposed to be serving in statewide office. But Ken Paxton is very much serving. Look at his record. Under his leadership, the AG's office has won major cases for Texas on immigration, the lives of the unborn, religious freedom, and the continuous overreach by the federal government on our everyday lives. Under his direction, the AG's office has sued the Obama and Biden administrations more than any other AG office in the country. Even CNN has called Texas a legal graveyard for Biden's policies. And under his watch, and with his personal involvement, the Attorney General's office has recovered billions of dollars for Texas taxpayers, including $3 billion against Big Pharma as a result of the opioid crisis. It has been said, but I think it's worth repeating. Ken Paxton is the best Attorney General in the country, period. All of this, of course, begs the most pressing question. If Ken Paxton is so good at his job and routinely defeats his political opponents at the ballot box, then what the devil are we doing here? We know this entire process took less than 2 months with fewer than 15 witnesses, none of which were ever put under oath. Shouldn't this investigation, if done right, have taken a whole lot longer? After all, this historic procedure took an entire year the last time it was used, with sworn testimony taken by the committee, in open hearings, giving the respondent an opportunity to be heard, to confront his accusers. So why was it so short this time? Why did it happen when it did? What was the rush? Because if they had taken their time and done it right, we wouldn't be here. We wouldn't hear about burner phones. We wouldn't hear about house renovations. We wouldn't hear about secret Uber rides. We wouldn't hear any of that foolishness because they would have delved into it and saw that it was all false. So why? I'll tell you why. On May 19th, 2023, Speaker Dade Phelan was so drunk while running House business, he could barely even hold the gavel. And that drunkenness was on video and was on the internet for the entire world to see. I'm sure you've seen the video as well. 4 days later, on May 23rd, Ken Paxton issued a statement and called for Dade Phelan to resign. In response, the committee hurriedly met the very next day, conducted a 4-hour hearing, and recommended impeachment the day after that. Because of the rush, the House didn't bother to vet this foolishness, and now they've put it right in your lap for you to do the work that they failed to do. This impeachment was the perfect marriage of a group of representatives fueled by a powerful lobbyist and led by a drunken speaker seeking political vengeance. It was also a result of a group of uninformed civil litigants and their attorneys who are motivated by money. The House's General Investigating Committee proceeded in a rush, in secret, so secret, in fact, that the only people who could have testified and brought actual evidence and exonerated Ken Paxton were not even called. I hope you will look at the evidence. I hope you'll really look at the evidence. I have faith in this body that you will actually see the evidence and make an informed decision. I want to focus just on a few of the impeachment articles. There's so many of them, I wouldn't have time to go through every one. But I think one that you might be interested in is Article 10. That's the article where the House managers have argued that Ken Paxton's house renovations were paid for by Nate Paul. And you've heard that lie repeated over and over and over again in the press, and it's false. The House managers adopted this lie about a non-existent bribe and repeated it with no evidence, nothing. The news media endlessly amplified this lie without ever documenting it. And then it's been repeated over and over, and even repeated by my colleague today. Hear this, press corps. Ken Paxton and Angela Paxton paid for their house renovations. Period. You will see in this case a STEAM team estimate. The Paxton's house in Terrytown had some water damage. STEAM team came out to correct the water damage. We're going to show you those documents where USAA claim was made to pay for that. You will see that the Paxtons had fits with the insurance company, just like all of us have at one time or another, trying to get that claim paid. You will see that Angela Paxton specifically was involved in talking through some of the repairs they were going to do as part of that process. They were going to do some upgrades, and you'll see mind-numbing pictures of Angela and Ken Paxton at Home Depot, at Lowe's, pricing stoves, pricing countertops, trying to get the best buy, and ultimately deciding that despite what you hear about granite, with all due respect, Senator Paxton, their countertops are just old ratty tile. And they didn't get a new stove. And they didn't get to change out their cabinets. But that's not what you've heard in the press. I'm going to show you the USAA docs. I'm going to show you that on September 16th of 2020, USAA made its final determination of what they would pay. They paid for Steam Clean, the original contractor, and the second contractor was Cupertino Builders. And you've heard, that's a foul. Busby in the press conference, he showed Cupertino Builders invoice. That company didn't exist. Well, guess what? It did. It absolutely did. I'm going to show you the documents, and you're going to see that this article is false, just like every other one. You're going to see the USAA determination. You're going to see that USAA knew that they had another contractor. You're going to see a text from the trustee back and forth between Ken Paxton, where Ken Paxton says, I have this invoice, I have to pay it. You're going to see all that, and you're going to see the wire come from the Paxton's bank account and go into Cupertino Builders' bank account. You're going to see the front side of the transaction and the back side of the transaction, and you're going to conclude, like I've concluded, like everybody has to conclude, that these folks were pinching pennies. They were trying to update and renovate their house, and there were a lot of things they just couldn't afford. I'm going to show you pictures ad nauseum of their house, and you will conclude what I've concluded is the Paxtons have been defamed over and over in the press and by the House. Now, the second so-called bribe, Nate Paul, the boogeyman Nate Paul gave Ken Paxton $25,000. Oh, goodness gracious. You know when he gave that money? October 2018. Years before any of these allegations ever existed. Years before any of the acts allegedly that occurred ever occurred. Think about their theory. Their theory is Nate Paul in October of 2018 was thinking, he was so manipulative and so smart that he knew at sometime years in the future, he may be needing something from Ken Paxton. Here's the problem with that. He gave money to people in this very chamber as well. Ken Paxton wasn't the only recipient of a campaign donation, but let's focus on campaign donations. Incidentally, in 2018, Ken Paxton raised millions upon millions of dollars, a $25,000 donation, although it sounds like a lot of money. Ken Paxton is a great fundraiser. He raises a lot of money, and that donation ain't even a blip on the radar screen. But let's think about that. Campaign donations can't be bribes. They are not bribes. Do any of us believe that a campaign donation in here is a bribe? You know how often I get calls for campaign donations? A lot. Are those bribes? No. If campaign donations were bribes, everybody in this town would be impeached. Just line up. Once we finish Ken Paxton, we'll start impeaching everybody else. I want to shift our focus from the time I have and address what could be the elephant in the room. There's been some salacious allegations made about Ken Paxton. The argument is that Nate Paul provided a job for a woman named Laura Olson. It doesn't hold any water. Laura Olson applied for a job. Laura Olson got a job. You're going to see the employment contract. You're going to see what her salary was. You're going to see her pay stubs. You're going to hear about the work that she did. And you're also going to hear that she continues to do that work today. Today. That was not a bribe. That was a job sought out and received, and she's doing real work today. You'll see the pay stubs and you'll see the employment application. Now, you've heard so much. My colleague talked about how Ken Paxton turned over the keys to the AG's office to Nate Paul. Remember hearing that? Totally false. One of the things you're going to see in this case is that Ken Paxton got nothing from Nate Paul, and Nate Paul got nothing from Ken Paxton. Let's look at what Nate Paul got from the AG's office. Nate Paul believed that the feds had targeted him. He believed that the feds had violated his civil rights. He believed that an affidavit, a warrant for the search of his home and businesses had been altered. He believed it, still believes it today. He didn't know where to go. He went to Ken Paxton. Ken Paxton sent him to the Travis County District Attorney's office, who then turned around and referred it back because of conflicts. There were conflicts. But what did Nate Paul get from that? No bankruptcies were averted. No foreclosures were stopped. No FBI agents were indicted. No FBI agents had to respond to any subpoena. Nothing. Nate Paul got nothing. If that was an attempted bribe, that was the least effective one in the history of the United States. You're going to see Nate Paul got nothing. In fact, you will also see email after email after email of Nate Paul and his lawyers sending letters to the AG's office, madder than a hornet's nest. You're not doing your job. You're not doing your job. You're not doing what you're supposed to do. We're going to sue the AG's office. Does that sound like somebody who has the keys to the AG's office? It sounds like somebody who might be a little entitled and thinks that public officials should jump when he says jump, maybe jump and hope he jumps high enough. But one thing is clear, Nate Paul got nothing, and he was very unhappy about it. He did not think the AG's office was doing its job, and he sent email after email, letter after letter, culminating in a letter where he threatened a lawsuit against the AG's office. You never saw those emails, did you? You never saw those letters, did you? You never even heard about them. The press knows about them. They didn't report that, did they? This idea that the AG's office harmed the Mitty Foundation. Do you know who the Mitty Foundation is? Do you know their history? Do you know who the first AG was that had issue with the Mitty Foundation? Greg Abbott. Greg Abbott. Greg Abbott sued the Mitty Foundation for all kinds of foolishness. They had one person indicted. They had another person who allegedly beat their wife and child. There was like a lot of turnover. And in this particular instance, you will see why the AG's office decided to intervene. There's a memo that lays out the tortured history of the Mitty Foundation and the decision-making matrix. And every single person in the chain of command signed off, including these so-called whistleblowers, to intervene in the Mitty Foundation case. Not to protect charity. See, this is the misconception. The AG's office is not there to protect charities, as has been alleged. The AG's office is there to protect the public's interest in charity. In other words, those are donated funds, and the charity better take care of its P's and Q's. And the Mitty Foundation was not. And Nate Paul was so mad that the AG's office wasn't doing more. The AG's office intervened. The intervention lasted 3 months, and the AG's office dropped the case once they saw what was going on. And remember this, you'll see the memo where not only did the entire chain of command decide to intervene in the Mitty Foundation litigation, but also decided to open an investigation of the Mitty Foundation. Have you heard that in the press? This is what we're up against. We are trying a case not here in front of you, honorable members. We're trying a case where we're getting prosecuted in the press. And so here we are, the baseless allegations thrown at us, shotgun approach, throw it against the wall, see what will stick, and make them respond. That's what this is. That's what this is, and that's what it has been. There's a reason my colleague did not go through any facts to support this, because there are no facts to support this. And let's also talk briefly about this so-called midnight opinion. Again, utter foolishness. Did you know on the very day that the informal guidance was issued, they issued another one the very same time frame, like the very same day? You want to know how many foreclosures were stopped by the informal guidance? 0. They didn't report that either, did they? And you didn't hear that either, did you? Many of these articles, I would respectfully suggest, if you look at what's alleged and you look at the evidence, you'll dismiss it out of hand. This is a good one. They claim that this was an AG's opinion, this so-called midnight opinion. On the very face of the document, it says this is informal guidance. It's not a 402 legal opinion. That should have been the reason that should have been dismissed. But we will show that to you. We will prove that to you, and that article should be disposed of in short work. Now, finally, let me talk about these ex-employees. One of the facts that I find to be the most egregious with regard to these ex-employees is that they made assumptions about their boss, but they did not raise those assumptions with their boss. Many of the issues in this particular case, most of those so-called whistleblowers participated in and signed off on. You know what the genesis of all this is? Remember I talked about the referral to from the district attorney's office to the AG's office? They were unaware that the district attorney's office had done a second referral that did not go through the AG's office. It went directly to this young man, Brandon Kamek. And so when the attorney's office had done a second referral that did not go through the AG's office, it went directly to this young man, Brandon Kamek. And so when they saw that Brandon Kamek had gotten subpoenas that went to some financial institutions, their heads almost exploded. And rather than asking the questions, calling the DA's office, finding out what was going on, they just assumed that this young man, this young lawyer who was being paid $300 an hour, because that was the rate, and that's why we got somebody like Brandon Kamek. But they assumed that he was off doing something untoward. And they never asked the questions, why would you be subpoenaing a financial institution? Because it was a second referral from the DA's office. A second referral that gave him the authority to investigate bid rigging. We all know there was bid rigging going on in Austin. That was what the DA referred to the AG's office to investigate. Not prosecute, investigate. They assumed the worst. And instead of asking their boss, you know what they did instead? They sent a letter to the FBI saying that Brandon Kamek had appeared in front of a grand jury. He never appeared in front of any grand jury. The subpoenas were prepared by the DA's office. All he did was DocuSign them. They sent that letter to the FBI. They came and met with some of the governor's staff. They came and may have met with some of you even. instead of meeting with their boss that they claimed they were loyal to. And you want to know what's most egregious? They sent letters and they took Ken Paxton's name off the letterhead. Now you think about that for a minute. Oh, these people were retaliated against and fired. Ken Paxton was trying to hide something. Let me just ask you point blank. If one of your staff, your chief of staff, decided that he disagreed or she disagreed with one of your actions, and decided when you were out of the office in Ohio trying to put together the Google case with a bunch of other AGs to recover monies for the state of Texas while you're gone, they get together, they send everybody home, and 8 of them meet, and they take Ken Paxton's name off the letterhead and start sending correspondence without his name. Imagine if your chief of staff did that, you would fire them on the spot. If you're a subordinate and you disagree with your boss's course of action, you raise it with her or him, and if there's still a disagreement, you resign. That's how it works. What you don't do is try to hijack the office, wage a coup, or all the other things that did. Sabotage grants. You know, they tried to sabotage the grants that the AG's office would receive. Millions of dollars of grants. They tried to sabotage the office. You're going to hear a much different story when you hear the evidence. A much different story. And let me finish with this. There's a young man named Drew Wicker. He's been all over the news. You remember who I'm talking about? I think my colleague made it clear, and we all know that you guys read. I mean, obviously you pay attention to what's going on. That's part of your job. There's a young man named Drew Wicker, a good young man. He was interviewed by the House investigators. I want you to watch and listen to that interview, because they asked him, did you ever deliver anything to Nate Paul? No, never happened. They came back 5 minutes later. When you delivered things to Nate Paul, how many things did you deliver? This is how they did this young man, who feels like he's in between a rock and a hard place. He's friends with some of the people that quit or were fired, and he still says that Angela and Ken Paxton are like family to him. And they squeezed him. And they squeezed him. He's the one, you may recall, that said, I was there in the kitchen, and Angela had expressed that she wanted granite countertops, and Ken Paxton was there with me, and Kevin Wood, the contractor, says, let me check with Nate. And then we heard about $20,000 granite countertops. I don't know where those are, Senator Paxton. I don't know where those are. What you'll see instead is I have the samples that when they went to Home Depot and Lowe's, and they sampled and they priced it and they decided they couldn't afford it. Nate Paul had nothing whatever to do with it, and Drew Wicker knows that is true as well. We look forward to putting on this case, and we hope you'll listen to all the evidence. We hope that you'll make a decision not based on political expediency, but based on the evidence you're going to hear. And remember, the burden of proof. It's not we throw out allegations and you say, oh, that sounds sexy, I'm voting for impeachment. They have to prove their case by the numbers beyond a reasonable doubt. They won't be able to do that. And on that point, I'm going to turn it over to my colleague for my time remaining, Dan Cogdell, who has some points he'd like to make. Dan?
A monitor up there. May I deliver from here, Your Honor? I'm sorry for the format, but can I at least see off this? Wonderful. Afternoon.
I'm sorry, sir.
Counselor, you're going to have to stay at the mic.
Yes, sir. I'll do my best. Good afternoon. My name is Bo. Getting off to a great start. My name is Dan Cogdell. Anthony Oso and I are two of the lawyers that are helping Ken Paxton. You know, when you get ready for a case like this, There's some things that you know, and there's some things that you don't know. Well, in this case, when I was preparing, I knew I was going to know most of the lawyers. I know my opposing counsel, known them most of my life. They're friends. I'm not going to say anything negative about them. It should give you some pause, though, because if they're friends with me, you know their judgment is a little bit askew. That having been said, I know some of the witnesses. I know Mr. Penley. I know Mr. Maxwell. Most of these people are good people. I have no problem with their character, generally speaking. I have a big problem with some of the things that they did. I don't mind sharing with you that my wife is going through a significant medical issue. And wasn't the best time for me to come here. But she said, no, you go. This is bigger than me. This is bigger than you. And this is bigger than Ken Paxton. No offense, Ken. She's not your biggest fan. But what she meant by that is we are living on the wet end of democracy right now. Is it up to the voters or is it up to politicians to see who stays in office? Your decision is much bigger than Ken Paxton. Your decision is literally about democracy in this state. I appreciate Mr. Murr's comments. I also appreciate the focus on the bigger picture and what's happening in here. One of the things that's intimidating, even I've been doing this for a long time, 42 years. Sometimes I don't recognize that dude in the mirror when I walk in the mornings. But I wondered to myself, how do I begin a case like this? This is a case of enormous consequences. I wanted the press. I wanted the sound bites. I wanted the cute things, right? As a side note, this may be one moment I get to relish because I'm not automatically the biggest ego of the lawyers involved. Not automatically. I have some competition. The significance of this case is titanic, as I mentioned. And I wondered, what am I going to do? What am I going to say? Oh my God, I need the hook. I need the line. I need the pop. And it occurred to me, I don't need that. It occurred to me that I have the truth. It occurred to me that the reason we're here, how did we get here? This is the very room where General Paxton has been sworn in again and again. This is the very room, as I understand it, where one of his daughters got married. How do we go from that to here? I'll tell you how. Because people assumed things that weren't true. They assumed that Paxton was involved in an illegal relationship with Nate Paul. They assumed that Paxton's actions were intended to get the records to Nate Paul. They assumed that Paxton gave the DPS records to Nate Paul. They assumed that Paxton hired Kamek illegally. All of those things are false. All of those things are false. Even Einstein said assumptions are made and most assumptions are wrong. A man much lesser, perhaps, than Einstein, but it's important to me, my dad, he told me when I was a young kid, you know, son, you can't spell assume without making an ass out of you and me. And he's right. And that's exactly what happened in this case. The reality is, this is not a trial where you can assume anything. This is a trial that requires proof beyond a reasonable doubt. Spoiler alert, it's the same amount of proof that's required in a death penalty case. I'm a visual learner. I like to see things to help me learn. So I'm going to offer these next slides to you. They're not the law, but they're an explanation. We deal with different standards. A lot of you are lawyers. A lot of you know these things, but a lot of you have never dealt with proof beyond a reasonable doubt. So let me suggest probable cause. If probable cause were a house, probable cause might look like that. Probable cause is the same standard by which the House had to, quote, indict or return the articles of impeachment. That is the quantum of proof that was required. Preponderance of the evidence. That is the standard that Mr. Busby uses in his cases. Those are in 50 versus 50 and a half versus 40, any slight more, any little bit more. That's a preponderance. Clear and convincing evidence. That is the same quantum of proof that is required in a situation where CPS wants to take your child away. Proof beyond a reasonable doubt, if it was a house, it would look like that. It would look like Mr. DeGuerin's house. It would look like a big house. Sorry, Dick. My point is a pretty simple one. There is a huge difference between the quantum of proof that the House based its decision on and what you are required by law to base your decision on. It's night and day. I'm going to go through the articles quickly. Judge, how much time do I have left?
21 minutes.
Oh, good.
21 minutes.
I may give a couple of those back. We'll see. Here's the allegation that Paxton directed employees at his office to act contrary to law by refusing to render a proper decision relating to a public information request for records held by the DPS, by issuing a decision involving another public information request, which is a mouthful, that was contrary to law and applicable legal precedent. That's the allegation. Here are the facts. Fact number one is that Paxton is the Attorney General. Paxton, as the Attorney General, can decide how his office responds to these inquiries. He's the Attorney General. Fact number two, Paxton did not order the release of the records. That's kind of been lost in the wash here. There's all these suggestions that Paxton ordered the release of the records that ostensibly were favorable to Nate Paul. No, he didn't. He did not order the release of those records, period, full stop. What he did was had his office take no position on whether or not the records should be released. That's a different color of horse. Fact number four, that no records were released to Nate Paul as a result of the actions of Ken Paxton. Let me repeat that. Nate Paul got not a single record based upon the action of Ken Paxton. Fact five, there were other records that were released to Nate Paul and his lawyers, but they had nothing to do with any action by Ken Paxton. You follow me? Other records were released, but not at Paxton's direction, suggestion, interference, what have you. Misuse of official information. The allegation, specifically Paxton improperly obtained access to information held by his office that had not been properly disclosed for the purpose of providing that information to the benefit of Nate Paul. That's the allegation. The facts are a little different. Fact number one, Paxton did not illegally access any records. Let me repeat that. Despite what the allegation is, he never accessed any record illegally. It didn't happen. As the Attorney General, Paxton had every right legally to access those records. Fact three, there's no evidence that Paxton copied those records. I'm kind of getting into the weeds with you here, but bear with me. There's a fellow named Vassar that you'll hear about. He had the file and is responsible for maintaining that file. He gave those files to Mr. Wicker, who Mr. Busby talked to you about. Mr. Wicker is an aide that works with Ken. Wicker says he was never asked to copy the file. I think the evidence is going to be pretty overwhelmingly that Ken Paxton may be more technologically challenged than me. So if anybody was going to copy those files, it wouldn't be Ken Paxton. I'm not even sure he had the code to the copy machine. Paxton gives the file back to Wicker after Wicker gave it to him. Wicker gives it back to Vassar. And there's no evidence that Paxton gave those documents to Mr. Paul. There's this big kerfuffle. And look, you're going to hear from a fellow by the name of Dave Maxwell. Dave is 6'6". Without the Stetson, you call Central Casting and ask them to send you a Texas Ranger, and by God, they send you Dave Maxwell. I'm a fan of Dave Maxwell, generally speaking, but Dave Maxwell did some things and said some things that weren't true. While he was being interviewed by the House, he said, and I quote, Ken Paxton gave the file to Drew Wicker and he delivered it to Nate Paxton in an alley in the dark of the night. That's absolutely false. Maybe Dave was just comfortable in his own skin and thought he could stretch out his credibility. It's either a mistake or a lie. I don't care. Whatever it was wrong. That never happened. Months later, Wicker gives an envelope to Nate Paul, an envelope, but there's no evidence that that envelope contained these celebrated documents, and I suggest to you that these documents would have been several inches thick, not 2 or 3 pages, and it was, I'll skip past that, but at the time, or really after the time, when the Board of Managers is claiming that Nate Paul surreptitiously had these documents, his lawyers are still suing in court to get the documents. That makes no sense. Why would his lawyers still be pursuing civil remedies, which they're entitled to do, to get these documents if he already had the documents and if he'd gotten those documents from Ken Paxton? That is dumber than a bucket of hair. It makes no sense. They're just wrong. Maybe they had good intentions. Maybe this was their belief for the moment, but they're wrong. 5th allegation, disregard of official duty, the engagement of Brandon Kamek. It is, while holding as office as Attorney General, Ken Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro term or pro tem. We'll get into that. And Paxton engaged Brandon Kamek, a licensed attorney, to conduct an investigation into a baseless complaint. That's the allegation. During which Kamek issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul. Whatever. Here are the facts. Fact number 1 is Paxton has every legal right to hire Brandon Kamek. We're going to get into the why, but he's got that right under the government code. You're going to hear a bunch of kerfuffle about one of my favorite terms, the EAM, the Executive Action Memorandum. Sorry, but only in state government could we come up with a phrase like the Executive Action Memorandum. What it really is, it's policy. It's not the law. It's an internal policy within the Attorney General's office. It is not the law. Fact 2, Kamek was not an attorney pro tem. Maybe that's a distinction without a difference, but that's what they've alleged. And you would think that these lawyers and the investigative committee and the committee are full of lawyers, most of which, or many of which, are ex-DAs. An attorney pro tem is appointed when the entire office has been disqualified. This had nothing to do with that. Brandon Kamek was hired, as the documents say, as an outside counsel, but they've alleged in their complaint he was an attorney pro tem. He was not. Fact 3, a baseless complaint. Here's the funny thing about being a baseless complaint. They forgot to tell Brandon Kamek about that. And we've got a lot of people that have been hurt by these allegations and the investigations, and I guess it depends on your viewfinder on whose ox is getting gored, and whether you like Brandon Kamek or not. He got absolutely skewered in the press. He was vilified by the press. He was just taken to the woodshed. He was beat like a rented mule by the press. And all that young man was trying to do was doing an investigation that the people who worked for Ken Paxton wouldn't do. And guess what? No one bothered to tell Mr. Kamek that it's a baseless investigation. In fact, he was told by Ken Paxton the same thing that Mark Penley was told by Ken Paxton, who parenthetically, I know and I like, but he didn't do anything. But more importantly, the direction given to Penley, the direction given to Kamek was the same. Find the truth. Let me repeat that. The direction that Paxton gave him in this corrupt, invasive, corrosive, bribery, kickback, horrible scheme, the direction he gave Mark Penley, who worked for him, was exactly the same direction he gave Brandon Kamek. Find the truth. We're going to impeach a sitting attorney general for giving the direction, find the truth. Not one person, not one piece of evidence will you hear where they say lie, where Ken Paxton told him to lie, cheat, steal, shade, do whatever it takes. That didn't happen. That didn't happen. And yet here we sit with 31 of you, with 15 of us and 15 or more of them. Here we sit when the allegation is it's corrupt, when the truth is, he said, go find the truth, for God's sakes. What are we doing here? Oh yeah, this baseless complaint that Mr. Murr, nice to meet you, sir, that Mr. Murr referred to, it wasn't a baseless complaint. The Travis County DA's office referred it to the AG's office, and ultimately a second one to Brandon Kamek. It may not be the greatest, sexiest complaint ever, but it wasn't baseless. Fact 4, no one bothered to tell Brandon Kamek. I think I've got a bit histrionical about that. And another one of my friends, Johnny Sutton, former United States attorney, worked under W. Great lawyer, fine fella. But these same folks, the whistleblowers that are carping so much about Ken Paxton and going outside counsel and doing all these ultra-virus things when hiring another lawyer, they were trying to hire Johnny Sutton, who, last I checked, was an outside lawyer. Now, you got to be asking yourself, why is it that Paxton hired Kamek? Number one, Paxton believed in good faith that there had been misconduct. Number two, he asked his deputies to investigate it. His direction was simple: seek the truth. His staff did little to nothing in terms of an actual investigation. He asked again, nothing really happened. No one seemed to be interested in it at any of it. For 2 months, it just sat there. The one time where Ken Paxton comes to Mark Penley and says, hey man, I'd like you to look at this, he does nothing. He does absolutely nothing. Frustrated, he interviews outside lawyers and decided on Kamek. And again, he gave Kamek the same investigation, or same instruction he gave Mark Penley: find the truth. At no time did Paxton ever seek to impede, impair, obstruct. Here's one of my favorite vignettes that you're going to see. Dave Maxwell, this 6'6" Texas Ranger, iconic figure. He's going to come in and say he was asked to participate in an illegal investigation. Really, Ranger? It's an illegal investigation, and on video, according to you, if your worldview is right, they ask you right there on videotape to participate in an illegal investigation, and you just sat there like a bump on the log. You didn't arrest anybody, you didn't make a note, you didn't cause their engine to file. It was illegal, and you were asked to participate in it, and literally, there you sat. This is our legendary one riot, one ranger in action, doing nothing? Really? Paxton just wanted it investigated. Mr. Busby stole a little bit of my thunder on these letterhead issues, but the point might be worth stating again. Who in the world do these people think they are? Honest to God, if your chief of staff came in and scraped your name off the letterhead and sent it out, how much longer do you think they'd be working for you? They wouldn't be, and they shouldn't be. Who in the world gave these people that idea? Who in the world told these people it was going to be okay? I bet you the evidence is no one. They took it upon themselves. They deputized themselves and were some sort of Power Ranger team where they could just do whatever they wanted, scrape Ken Paxton's name off the letterhead and send these letters out. Mr. Busby also talked to you about Michael Wynn's letter to Paxton, but I think it bears repeating. Under their worldview, Wynn, who represents Nate Paul, writes a letter to Ken Paxton, his supposed co-conspirator, threatens to sue his co-conspirator, threatens to sue the Office of the Attorney General, alleging false statements made by Ken Paxton to damaging Mr. Paul's reputation, claiming inappropriate coordination to undermine the investigation, alleging obstruction to prevent the Mitty Foundation investigation, literally bringing suit against one of his, what in the real world would be a co-conspirator. What's next? A hired hitman suing for breach of contract when he doesn't get paid for the kill? Are you kidding me? This makes absolutely no sense. None. And the reason it makes no sense is because there was no illegal relationship between Paxton and Paul. Look, I get it. I understand why there's some eye rolls about Paxton doing things that most of you would think, I don't know about that. I don't know about that. But here's why Paxton was a little different. These claims with Ken Paxton that Nate Paul was making, they resonated with him. I hear you. They very well may not have resonated with you, but I'll suggest to you, luckily, you haven't gone through what Ken Paxton has gone through for the last 8 years. Let me repeat that, 8 years. How do I know 8 years? Because I have been by his side on that Texas state securities fraud case. In that case, Paxton believed he had been the target of a wrongful prosecution. And here's why. Number one, it had been pending for 6 years at that point, back in 2020 when all the fur was hitting the fan.
Counselor, you have 4 minutes left.
Yes, sir, thank you. Number two, the judge that presided over the grand jury.
Excuse me, objection. I believe the court has said all 4 of those counts are out of this trial. He doesn't get to start talking about the merits of it.
I get to talk about his mindset.
My objection is he shouldn't be talking about this at all based on the court's ruling in the past.
I'm talking about his mindset.
We're not allowed to talk about it. How can he get up there in opening and give his version of it?
I'm talking about General Paxton's mindset as to why these claims were resonating with him.
All right. He started talking about a judge. He's talking about the facts. I object.
Sustained. Continue.
Let me put it this way. Ken Paxton was viewing things from a much different viewfinder than you or I might have been viewing those things through. And there's a reason why he was viewing things differently through a different viewfinder than you and I, because of what he had experienced. And it wasn't what you and I have experienced for the last 8 years. Let me get this through so I don't offend Mr. Harden any further. Sorry, Rusty. Here's the difference between what the House did and what you have to do. What you cannot do is assume anything. What you must do is look through the viewfinder of beyond a reasonable doubt. Again, that is a much different process than what the House did. Is there proof beyond all reasonable doubt for you to convict Ken Paxton? And I suggest to you, it is crystal clear that there is not evidence beyond a reasonable doubt. I have one simple ask. Do the right thing. I think the senator that led us in prayer asked for the Lord's help on that. Literally, do the right thing. And the right thing is to vote not guilty. Thank y'all for your time.
Okay, so we just heard from Andrew Murr, who was House. We just heard from Andrew Murr, who was the House.
For the
impeachment
record, House managers, you have 42 minutes and 34 seconds returned to you. And you have 1 minute and 17 seconds returned to you.
My mic is on. Okay. Okay, so we just heard from Dan Cogdill and Tony Busby, who are representing Ken Paxton, and also Andrew Murr with the House impeachment managers. Andrew Murr saying that Ken Paxton had effectively turned the keys of the Attorney General's office over to Nate Paul, and that he is not fit to be the Attorney General of the state of Texas, and also saying that these whistleblowers were movement conservatives who had acted on their ethics and their principles to come forward. And Tony Busby quoting William Shakespeare, saying this was the tale of sound and fury signifying nothing, and saying this was all political retribution, and that essentially, effectively a coup by members of his office that had led to this. And basically they're saying that Ken Paxton did nothing wrong, and that he had good reason to feel that way.
Take your break now while we're handling
this. Okay, so they're taking a
motion.
break.
Be back at 10.
Okay, so Matt, just tell me, well, first of all, let me introduce my guest here. I got Matt Yarbrough. You are a former federal prosecutor, and you also worked in the Attorney General's office, and we have Star Telegram political columnist Bud Kennedy, who knows everything there is to know about Texas politics. I want to start with Matt. I want to get your reaction to these opening statements.
The opening statement by Andrew Murr, Representative Murr from the House managers, I thought was fantastic. I thought it was a great strategy. They did not let the outside lawyers do the opening statement, which I think brought a lot of credibility to the case that they were bringing. They're saying, hey, as your fellow congressman, this is us speaking. We're not having two outside paid mouthpieces, lawyers who are fantastic lawyers, get up here and do the opening statement. So not only one was it the House managers coming to the Senate saying, we are your fellow representatives. We're here to present this case to you. We're not having someone paid to come in here and present this case. I thought it was a great strategy. It really brought a lot of credibility to what they were doing. Two, they kept it short. I thought that was fantastic. They basically said, we're going to let the evidence do the ultimate arguing in this case. We're here with no bias. We're going to put the evidence in front of you that we saw. So doing a short opening like that, I think you could see the juxtaposition that when once Busby got up with Cogden, they exhausted all of their time, and it became very repetitive and somewhat bombastic. And, sometimes I always say, if you have to shout it too much, then maybe your evidence is not as good as you think it is. So I thought it was a fantastic strategy from the House managers of coming out and making sure that they were the ones delivering the message, and two, they kept it short.
Bud, what'd you think?
Well, you're looking at the jury of the Texas Senate that, about half of whom are lawyers, a half not. The half who are lawyers might see it Matthew's way, that the low-key fellow member of the legislature coming over very calmly, factual, speaking in ways that Sam Houston would think was honorable, But then the other half, who aren't lawyers, might be impressed by all the bombast and dramatics. Right. And so you have to look at who's the jury in this case. The second go-round with the defense, was full of a lot of fury. It seemed like they almost hadn't coordinated. They went over so much of the same material. It seemed like they hadn't even talked to each other first. But you have the lines thrown out like drunken speaker and old ratty tile and things like that they kept talking about, trying to make everything sound over the top. I go back to Murr. Murr kept saying that you don't have to find him guilty of a crime. You're not here to try Ken Paxton, you're here to protect the people of Texas. Right. And that's the purpose of an impeachment trial, is to decide whether you need to protect the people of Texas. That's a key message in this trial, that it's not a criminal trial. It's not about finding Ken Paxton guilty of a crime. It's about protecting the people. That's the Senate's job. He also made a subtle reference to resisting the forces that want to intimidate the Senate. And you know that the senators are sitting there feeling that, as they see the threats, as they hear the threats of political retribution if any of them votes in a way that the West Texas oil money disapproves of, then they'll get retribution. So he really appealed to them as fellow lawmakers. The defense attorneys came out like they were talking to a normal defense jury with a lot of spectacle, and they really, there were some details of things that they thought were inaccurate, but they started out just by saying, this is all a bad trial and you shouldn't be trying somebody like this. And the line that this is making it sound like this is a slippery slope, right. Making it like the consequences of this trial. Like, oh my gosh, if we have an impeachment trial every 60 years in Texas, is this really a slippery slope we're going down? They made it sound like this was horrible, that this whole thing was happening.
Yeah, Cogdill said it. Is it up to the voters or is it up to the politicians to see who stays in office? Your decision is bigger than Ken Paxton. Your decision is about democracy in this state. I wrote that down because it was, essentially trying to make this argument that you need to acquit him largely because this is about democracy. Now, let's talk about this. So what if Ken Paxton's team can show that some of these impeachment articles are just flat untrue? Does that hurt the rest of the case?
I don't think so, because again, they only have to find on one article in order to bar him from being Attorney General. And I thought Murr did a very good job about setting what the real standard is here, because defense counsel really wanted to make this about the election. It's the voters who have it. But Murr did a great job of setting out that our Texas Constitution is based on the U.S. Constitution. It has the same clause in there, and that impeachment is a mechanism that's there for a reason. It's not for the voters to remove the person. It's for if there's high crimes and misdemeanors or actions taken by that political officer, that they can be removed. And it's broader. If you remember what Representative Murr mentioned was, it includes things that are broader than crimes as well, like abuse of power.
It's about ethics and standards and the way you do your job and you conduct yourself.
Or influencing an investigation or taking the power of the Attorney General's office and trying to insert it into a federal investigation on behalf of a donor.
How extraordinary was that? I mean, what they're describing that happened?
Well, I look at it this way. I mean, you heard Busby demean Mr. Kamek's $300 rate, kind of rate shame him. My theory is the reason they went and hired Kamek is because he was a young lawyer. He didn't know any better. There's no lawyer that I know of who would have taken this case and said, you want me to go insert myself and send a subpoena to a federal judge, the FBI, go to banks under federal law and try to discover what an ongoing criminal investigation under 60 rules of confidentiality. That's just something is absolutely unheard of. But and the other point you'll want to make here is the standard of beyond reasonable doubt being the basis. When I was a prosecutor, and you'll hear this in every prosecution trial, when the judge defines the law of that standard, it's that it's not beyond all reasonable doubt. It's not like it is a 99% or 100% proof standard. So while Cogden was using the House analogy of his slides there, is that it's just a standard that they see that by based upon direct evidence and circumstantial evidence, they can easily find that article was met based upon the evidence that was presented.
Well, and about 2 weeks before this began, there was about 3,700 pages of documents and videos that were released. I mean, just a staggering amount of material. And one of the things that I found surprising, because I've been covering criminal justice for a long time, I hate to say how long, but a long time, and was that the attorney for Nate Paul was with Brandon Kamek in a couple of these cases delivering subpoenas to bank people, which that seems like right, if you're conducting kind of a separate, let's go find the truth investigation, that feels very odd to me.
It's not above board. Not one thing about it.
Yeah.
It's above board.
No.
And it just raises the question, who was this for? Was this for the people of Texas, or was it for Nate Paul?
Right. Well, and I think those are the questions we're going to be hearing, or the evidence we're going to be hearing a whole lot of for the next couple of weeks. And one thing I want to bring up, we were talking while we were listening to this, that Andrew Murr is the grandson of Coke Stevenson. Talk a little bit about Coke Stevenson.
Right, and of course he said his own family had been touched by corruption. He has a personal indignation about corruption. Well, what he means by that is that his grandfather, Coke Stevenson, lost the famous Texas U.S. Senate race to LBJ with the Jim Wells, the Box 13, where Coke Stevenson had won Box 13, was going to be the nominee for Senate, but suddenly, like I think 6 days after the election judge in Jim Wells County came up and said, wait a minute, I found 202 more votes actually. 200 were for Lyndon Johnson, 2 were for Coke Stevenson. Lyndon Johnson went to the U.S. Senate and began his career.
Right, and that was a very famous case of actual vote rigging.
Yes.
So,
But and so he can stand here and say, look, I know something about corruption. Let me talk to you about it.
well, I find him to be a very impressive guy. I watched actually twice that hearing, the 3-hour hearing where they initially laid out those charges, and that was. He's very it was the first time I had been introduced to him. I want to mention also that Ken Paxton was here at the beginning of the day, as he was ordered to be, but he has not been here for opening statements. I want to get y'all's thoughts on that.
I found it interesting because does that mean he'll reappear when witnesses are now on the stand? And so, especially people that worked for him. So I find it interesting him not being there. I don't think it's going to be good in the eyes of some of maybe the jurors that he was not present for these opening statements. And the other thing too is I think Murr's authenticity, his delivery was just spot on. I thought that was a just fantastic strategy.
It's a West Texas lawyer against Houston lawyer.
Well, and those Houston lawyers are known for being dramatic. And the attorneys
sensational.
And sensational, yes.
Yeah.
So.
And by the way, I'll point out the question about Ken. His wife is there. She can tell him what happened.
Right. Well, that's true.
Yeah.
But do you think it doesn't go over well with the senators that he didn't stick around?
I think so. I think it, especially those people that may be on the fence, is that if you felt like you did anything wrong, that you did nothing wrong, that you would be there in person to face this.
Okay.
One of his defense attorneys even alluded to the House investigator and said he has a right to confront his accusers. You'd look around and say, well, dude, we're here.
Right. Well,
The very line is with his failure to appear before the House committee.
Right. Which is part of what landed us here today.
Complain about, yeah.
Yeah. So, Bud, Matt, thank you. We're going to be continuing here on live on YouTube and on our website and other platforms. So please take a listen to what we're doing right now. And also, I'm going to send it over to Matt Howerton.
Okay, thank you so much, Tanya, Mr. Kennedy, and Mr. Yarborough. There is a lot going on. The impeachment trial for the suspended Attorney General Ken Paxton underway. And if you're just parachuting in on all of this, you need to know more. We have an entire section on our website dedicated to this case and all the background that you need to know. Just go to WFAA.com/Paxton. And of course, we will be here day in and day out, keeping you updated. Thanks for being with us. Let's get back to GMT Extra.
Okay, Matt and Bud, we were Just did our little live hit on TV, and now we're back to regular programming on the live stream.
Yeah.
So, what's next? Who do they put on the stand? I mean, who do you put up first?
Well, again, you probably want to build your evidence from a chronological timeline. And that'll be interesting to see as they go forward, is how they build that timeline out. And where do they start, with this? I'm assuming that it would probably be with the whistleblowers or the other assistant attorney generals who saw the action taking place at the very beginning. And so, this whole thing about a search for the truth, and that's what apparently Paxton was claiming that he was doing on behalf of Paul, but he wasn't doing for anyone else, I don't think will play very well for him. And remember, those assistant AGs, why were they concerned?
Right.
And they'll be able to point out those facts. I think that's probably, maybe the first witnesses we may hear from.
Well, and I just think that you can't emphasize enough that these were hand-picked members of his office. In a number of cases, these former members of the AG's office who brought these whistleblower complaints now work for conservative legal organizations. These are not rhinos, these are not liberals, these are not Democrats. These are people he brought into the office who were upset about what they saw and who acted, and so it's interesting to me, the framing of this, what his attorneys have tried, how they've tried to frame him.
Right. Well, one worked for Kelly Shackelford and First Liberty here. Kelly Shackelford was who suggested to Ken Paxton that he should get into politics. And so, they worked for the most conservative law firms in the state. Ken Paxton brought them in, but then they saw that they didn't agree with what he was doing with the office. Now, we did have this moment in the defense that I think it was Cogdell that tried to just present this sweeping defense that I think they'll continue with, is say Paxton is the Attorney General. He can decide to do all these things, that these are all within his
sort of like King's
power.
X?
Yes, these are all within his power and authority to do. That is an argument that some senators may go along, but I think that if you were selling that to an ordinary jury, they might be more likely to go along with that. But the senators who sit there, and particularly you had to hear him ask them for $3 million to pay a settlement, the senators are going to be more leery of accepting that argument.
Right, sort of the idea that he can just do anything he wants because he is the Attorney General. Mm-hmm. Hey, I want to ask Jay Wallace, who you guys can't see, I want to ask him to pull up the story about who is Nate Paul. He's gonna pull that up, and then we'll play it here in a couple moments. Because I think it's gonna help you guys online kind of understand a little bit more about who Nate Paul is. Because we've been talking a lot about Nate Paul, but we really haven't had this explanation about who is Nate Paul. When you worked in under John Cornyn, would John Cornyn have ever had this cozy of a relationship like this that's being described?
Absolutely not. You want to, as the top lawman in the state, or law person, you want to preserve that you're not taking some sort of bias or remuneration or contributions or any other sorts of gifts from a donor of any kind. And so you would want to avoid that. And I don't think, not only is that true for John Cornyn, but that, we didn't hear about these stories with Greg Abbott being Attorney General, or anyone else so far today. So, yes, very, very unusual. And I think that's what you're going to hear from a lot of the whistleblower group is that they didn't understand why he wanted to take legal action or investigative action on behalf of Nate Paul. The other thing, too, about Nate Paul is I didn't think it was good that the defense kept calling him the boogeyman, because the boogeymans were close to Ken Paxton, and I don't know how you're going to separate them, the two of them, out.
Well, the idea that the Attorney General, and they didn't try to explain this Uber account, right? The idea that the Attorney General would have a secret Uber account and ditch his security detail to go meet with this person, that's just really odd.
But if you're a defense attorney, you say there's no law against having an anonymous Uber account. A lot of people, probably other members of the House and Senate, have anonymous Uber account.
Well,
I don't.
They
I have
tried
an
to get
Uber
into
account.
this. Cogden tried to get into this a little bit about this sort of. He was fearing his own office, or fearing sort of the Texas deep state, I guess, is the sort of thing that they were trying to play. And that's when he tried to bring up the securities lawsuit or criminal case in Texas, in which Rusty Hard quickly got to his feet, objected, rightfully so, that those were barred from the case, were kind of set aside by a motion, and Cogden was not able to respond to that.
Right.
This manufacturer of the Texas deep state is kind of an after-the-fact invention. I mean, deep state is a term that didn't come into play until a few years ago, and so the whole idea that Ken Paxton was up against the deep state when he was elected.
The deep state that he hired.
Yeah, exactly. In 2012, 2013, is kind of rewriting history.
For sure. Okay, Jay, go ahead and play that.
In July of 2017, Forbes published this article, the story of a Texas tycoon building an empire at 30 years old. The journalist who wrote it called Nate Paul a real estate prodigy. Fast forward about 6 years to June of 2023, a very different headline.
A donor accused of bribing Paxton sits in jail tonight, arrested on an FBI warrant. His name is Nate Paul.
Paul was arrested and charged with 8 felony counts of making false financial reports. To sum it up, this 23-page indictment claims Paul gave reports of having a lot more and owing a lot less money than he actually did when applying for loans from credit unions and mortgage lenders to help fund his real estate investments. In one instance, the indictment accuses Paul of providing documents, quote, reflecting an account value of more than $14 million for an account with a, quote, value of less than $13,000. The government wants him to pay $172 million, the amount of the loans he obtained while allegedly providing false documents. Nate Paul's day in court over these accusations will come. But Ken Paxton's impeachment trial was built on a different but related accusation.
In August of 2019, a search warrant is executed. A criminal search warrant is executed by DPS and the FBI on property belonging to Nate Paul.
This is video from a hearing held by the Texas House Committee that investigated and charged Ken Paxton with impeachment articles, accusing him of interfering with the FBI's investigation of Nate Paul. And this is video of part of a nearly 4,000-page pile of evidence released by that committee, showing Paul is in a meeting with his attorney and one of Paxton's top officials at the time, trying to get information and even pushing back on that investigation.
They sliced all the Wi-Fi lines. They destroyed my camera system. So that happened at all 3 locations.
In it, you can hear David Maxwell, who was the director of criminal law enforcement for the AG's office, standing firm.
The most stuff you're complaining about is certainly within the law.
And then this exchange between Maxwell and Nate Paul's attorney.
I don't think that our raising these kinds of questions, talking to you, talking to Ken, whoever, is any way of obstruction. We're just trying to figure out what happened.
I understand, but they're going to think that that's what we're doing, trying to obstruct a federal investigation.
Now, when Paul was arrested, his attorney released this statement to WFAA, saying his charges have nothing to do with Ken Paxton, nothing whatsoever, and called the impeachment effort weak. But former prosecutor turned UNT Dallas law professor Angela Downs says the prosecutors in the impeachment trial will focus on shutting that down.
The prosecutors on this case will be able to make those connections.
Back in 2018, Paul contributed $25,000 to Paxton's campaign. They were connected, but that's not unusual. But Paxton is accused of misusing his position as Attorney General to do favors for Nate Paul and his business in exchange for favors of his own. In addition to accusations that he used his office to help Paul get info on his own federal investigation, the articles also claim Paul hired a woman Ken Paxton was having an affair with, and in exchange for his legal help, Nate Paul hooked Paxton up with some home renovations.
Nate Paul admitted that she worked for one of his companies. However, he did not know how much she was paid and could not identify a single specific project that she worked on.
The evidence released by the impeachment committee actually includes this employment contract, showing that the woman worked for Paul. There are also records from Uber showing fake accounts allegedly created by Paxton using the service to visit Nate Paul and his alleged mistress.
This is almost uncharted territory. To have someone whose name, Mr. Paul's name, being part of the conversation, being connected to so many particulars of the case, really puts you on notice.
And many legal experts believe that Paul's current legal issues could prime him to switch his stance.
He's really in a position where he's got to start thinking about his defense and how he can protect himself. And so this might put him in a very vulnerable position where he might be willing to, to speak against the Attorney General.
And as for Nate Paul's own legal woes, trial is set for July of 2024, an undoubtedly much different story than the one told back in July of 2017. In North Texas, I'm Morgan Young.
With some history on Nate Paul, how surprising is it that you would have an Attorney General that would be tied so tight with this guy who's now under federal indictment? I mean, he alleged of all kinds of financial crimes.
It's too many touch points. I mean, I think that's what as you have witness after witness, you introduce all this evidence. Again, the question's going to come up. Did Paxton take this sort of action for other Texas residents, especially Texas residents who didn't give him donations?
Right. Well, and also having filed many open records requests in my career, I cannot ever recall, whenever they've had the law enforcement exception, the Attorney General's office taking no position. That does not happen. They invariably, in every case, even in cases where I felt like it was, unwarranted, where the law enforcement agency was claiming the law enforcement exemption, but it really wasn't warranted, because sometimes they'll do that, shockingly enough, or not shockingly. And the AG's office always upholds it because they don't look under the underlying facts to try to determine if it's a legitimate request or not.
Right. I mean, this is basically whether it's the Texas AG office or you'll run into this at the federal level, with especially if it's something that has to do with national security. Basically, the exception, they'll say they will block the request for the freedom of information, for the release of that information, saying that we have to preserve our investigative advantage. It's an ongoing criminal investigation, and many times they don't have to have any reason to block you. It can be that we think we're going to do an investigation, but I've never seen a situation whether the Attorney General or the Department of Justice said, we're just going to be neutral
That
here.
doesn't happen.
It doesn't happen. We're not going to take a position at all in this case.
But?
Well, one of the points of this that they keep, coming back to and that they just hammered away at is, well, these campaign contributions, it's just a campaign contribution. All y'all have taken campaign contributions. There's nothing illegal about campaign contributions. Everybody in here would be in prison. All this. Well, there is a point where it is illegal to take a campaign contribution. And Matthew, do you want to give that detail?
Well, especially if you're getting a benefit in exchange for that, something of value. You've heard it called a quid pro quo. But in this case, whether it's trying to stop an investigation like obstruction or using the powers and abuse those powers of your office to protect a donor, they are getting something in value in exchange for you using your governmental powers paid for by the Texas, residents and taxpayers.
Well, and these whistleblowers that came forward, they were stunned by this constant intercession on Nate Paul's behalf. This opinion that was issued over the foreclosure situation at a time when Texas Republicans were pushing to open the state. You had the AG's office issue this, I guess, unofficial opinion that said that no foreclosure sales could go forward. So it's kind of just didn't make a whole lot of sense.
And of course, really, an AG's opinion is just an opinion. I mean,
right.
You can always challenge an AG's opinion.
But just all very odd behavior. And then Brandon Kamek, and let's talk a little bit about that. So Brandon Kamek is this attorney. He'd had maybe 4 years of experience. He had no prosecutorial experience when he gets picked. And as I mentioned earlier, he goes along, the attorney representing Nate Paul goes along with him in a couple of the cases, and because I heard the audio myself, to deliver these subpoenas. And I find that just really odd, and it doesn't make a whole lot of sense. If the idea is we're going to just go find the truth.
Well, I mean, I'm sure you're going to hear argument from the House Representatives impeachment team is going to be that he was probably chosen, or at least this is what I would argue, is that he was chosen because Paxton thought he was someone he could control and have him do his bidding for him, because he knew that asking anyone within his office to do this, another assistant attorney general, is he would get a flat no or a why.
When he was getting a lot of no's and a whole lot of whys.
Yeah, exactly, and I'm sure that's why he ended up landing on Kamek, because he thought, I need to move this all outside or I'm going to have some troubles with my team.
And the defense is going to respond and say, well, you can't convict Paxton on what you think he thought. You have to look at it and say he is the elected attorney general. He can choose whoever he wants and he can make that decision. And he's been endowed with that power under the Constitution by the people of Texas.
Well, and the claim is that Kamek, that he identified himself as a special prosecutor for the AG's office, and the whistleblowers allege that he was not a special prosecutor and had no legal authority to be going to a grand jury and getting these subpoenas issued. So it'll be interesting to see how that plays out as we listen to the evidence.
That's right.
How much do you think we're going to hear about Laura Olson, and will we hear from her?
I think it was a great decision on the House impeachment team to make sure not to bring it up, that Murr stayed away from it.
Why do you say that?
Because one, she's in the chamber. I think it was respectful. I think it showed an air of respect for a fellow member of the Senate or the House. And I think it comes back to that they really wanted to focus their case on the more important parts, is that this is a breach of the Texas Constitution. This is abuse of power. This guy has used his powers in his office to, if anything, affect everyday citizens or other law enforcement. And I come back to we've got the top law enforcement person, violating laws left and right. And it's going to be interesting, I think, as they move into it. I think they'll just let the evidence speak for itself with regards to her.
Of course, Laura Olson is Senator Donna Campbell's aide, who
currently?
Yeah, not currently. She's working for Nate Paul.
But but previously,
at one point, previously had been Senator Donna Campbell's aide, who had been working in San Antonio. And this is part of what the prosecutors are going to allege was the quid pro quo, was that she had a relationship with Ken Paxton, and that instead of working for, first of all, that Senator Campbell knew about it. There are photos of her in the Senate chamber. There were photos on Twitter of her with quite a few state officials, and so everybody seemed to know that she was around. But that she actually left Senator Campbell's office and was hired by Nate Paul in Austin, and that the prosecutors will say so that she could be closer to General Paxton. So this will be part of the quid pro quo that they're trying to argue. I think we probably will hear from her in a careful, very gently handled way, but I think they probably will put her on the stand.
That will be very interesting. We went pretty much straight to opening statements, so we didn't really get to talk about this morning much. But I want to hear your thoughts on this morning's event. So we went through all these motions.
Well, of course, you and Bernadine covered those very well. I think the main impression I had was that everybody just wanted to get on with it. But the most important thing to note was the votes themselves. We had all the motions. They were all, they were obviously a majority vote to proceed with the trial, proceed with all the articles, but if you were looking at the 2/3 vote, and what's needed to remove General Paxton, then all those were close votes. A couple of them, you got 21 senators, but more of them you got more like 20, and there were not enough to remove Paxton on some of those articles. We'll look and see if the articles where there were 21 or 22 stand up. Everything was fascinating about that all the votes were close, and that senators would flip from one side to the other, and some would go vote on with the defense, and then others would go vote with the prosecution. It seemed to be almost unpredictable about who would vote where. Obviously, all the Democrats voted with the prosecution, but the Republicans seemed to flip back and forth. But obviously, it is a close. It's a close vote at this point. I said on Inside Texas Politics, I've said before that I thought they had the votes to remove him, but not the votes to ban him from seeking office.
You still feel that way?
I think it's probably closer. I think there are a couple of swing votes and people I'm looking at for how they vote and where this goes. But I think that, and it's been interesting to watch and see what kind of attention people are paying, and to see in the crowd whose ears perk up and who seems to be zoned in and zoned out in the jury. But I think that it's very close. I think it's within a senator or two, and I think that it's some of the key senators. The swing votes might be North Texas senators.
Which ones?
Well, I think you have to look at Kelly Hancock has voted all the time with the prosecution. I think you have to look at the senators who are pressured in their districts. I think you have to look at Senator Drew Springer, who's from Munster but represents Parker County and Weatherford, and all of his Red River district is sprawling as this giant district that's bigger than Connecticut probably. It's this gigantic district. I think you have to look at, and then you look at Tan Parker, who's been on Paxton's side all along. But then you look at Brian Birdwell, who represents Waco, but his district comes up into Mansfield in Arlington. And you look at Brian, you look at him, he was the chairman of the committee that wrote the rules, but he voted with the prosecution on some of these. And of course,
actually, for the most part.
Yeah, and of course you definitely look at Brian Hughes, and you look at Brian Hughes, his district starts in Dallas and goes into deep East Texas, and who has been the author of abortion bills, all sorts of child protection bills, all the conservative legislation that's come out of the Senate almost. The greatest controversies have been Brian Hughes' bills, and you look at him that he voted with the prosecution on several of these cases.
Well, and it also should be mentioned that Brian Hughes was that when they sought this foreclosure opinion,
he was
the one that they put his name on it,
right?
Because they didn't really have anybody that actually had asked for this opinion, so they got Brian Hughes to be the straw man on this thing.
And now he's he's obviously in the middle of this, and he didn't vote with the prosecution on every case, but he did on some, and it's just indicative that there are some independent, I'll say this on behalf of everybody on both sides, there are obviously some independent thinkers in the Texas Senate. There are a lot of senators today who did not vote the way that we expected. It'll be interesting to see how this proceeds.
That's for sure. I want to play a story. I think this will help folks understand a little bit about Paxton's North Texas connections. So let's take a listen to this. Okay, sorry folks, Jay's going to have to work on figuring out why we don't have sound with that story. It's the vagaries of technology. We can't live with it, and we cannot live without it.
And we'll get to see that, but basically Paxton, is not a Texan. He was born in North Dakota and was an Army brat who moved around to bases all over the country, graduated from high school in Lawton, Oklahoma, and eventually wound up going to Baylor Law School and settling here and marrying Senator Angela Paxton, Angela Allen at the time, was from Mansfield, played basketball for the Mansfield Tigers, and so married a local girl in the Retta Baptist Church, which is kind of on the Tarrant-Johnson County line. in this little bitty Baptist church down between Burleson and Mansfield. And so then he was going, I think, to Prestonwood Baptist Church at the time that Kelly Shackelford recommended him and said, you know, you'd be good to run for office. He was not a criminal attorney. He was handling a lot of financial affairs and just a small civil practice at the time, and ran for the House and then moved up the ladder in the House as kind of a champion of conservative causes. Eventually moved over to the Senate, where he sat at desks right beside many of these members of the jury.
As in many ways, he's being judged.
Definitely being judged by his peers.
And I thought that was great that Representative Murr brought that in, referring to the whistleblowers, that these were conservative people. These were people that had conservative values. The way he highlighted that.
Movement conservatives.
And he really wanted the senators and the jury to know that point well, that Paxton didn't represent the values. And you could also see that sort of religious bent, kind of woven into that theme as well, is that it doesn't stand for the values, which I think was a nod towards Christian values.
And it's been interesting to see the split over this in that faction of the party. You have, of course, you have the West Texas Oil Christian Libertarian effort, the Empower Texans group, where a lot of the money comes from and a lot of support and a lot of the pressure campaign has been financed. But then you have some of the other conservative groups. You have former Senator Connie Burton in Tarrant County, and you have a lot of the other very strong conservatives. And then you have some other groups that are known as your strong religious conservatives in Texas who've been silent and have not taken a side, but they're not jumping on board with Ken Paxton, and they're a little offended at the things they see and appear to have been true.
Do you, when y'all heard originally about the $3.3 million settlement, what did you think was going to happen?
I mean, the first thing my thought was is who's paying for this? And I just was wondering, whose desk was this going to land on eventually? And I don't think that it played out the way Paxton thought it was going to play out.
Oh, I think that's very true.
That is one of the things that has made this whole case. Had he paid it out of his wealthy campaign account, then we wouldn't even be here. But he felt like the people of Texas should pay it. And the argument on his side is that whenever any officer of the state makes any kind of mistake or has to pay a civil settlement, the people of Texas are the ones who pay it. That he's not unique in this regard. But when he sent the bill over in his budget, that was when the senators called him in and said, what is this here we've got to pay? And then they went over to the House and they said, wait a minute, what is this we've got to pay? We ought to look into this. And that's why that's why the House was able to investigate it. That's why we're here, is because he sent the bill to the people of Texas.
Well, and I remember when, because I reported on the settlement and had gotten wind that it was coming, and I remember thinking that there is no way that the state legislature is going to approve this. I just, now what I didn't, the crystal ball wasn't working. What I didn't see was that it was going to trigger a snowball, and that the snowball was going to build up steam, and it was going to go down that hill, and it was going to land us where we're at today, or Ken Paxton where he is today.
Well, when that bill came to the Senate in the Senate committee, who questioned him the hardest on it? Senator Schwertner and Senator Middleton. Well, Senator Middleton was a solid vote against Paxton all day today, but Senator Schwertner actually
went back and forth.
And so he was considered to be a solid against vote, but he voted with Paxton on several questions. So there may be that they may have settled on, like you said, and we all said, they only need one article. So they may feel like that some of the 16 are better than others, and that some really don't deserve to be upheld.
Well, and that's, that is what you want with a jury. You do want a jury that does look at each count and makes, of course, we talked about this morning, Matt. What happened this morning with the quote-unquote jury voting on motions does not happen in a regular trial.
You don't get a preview like that.
That's right, and you don't get to basically be judge and jury and dismiss full counts or articles. You have to listen to the evidence first. And I thought it was interesting that the evidence instruction didn't come until all of this was done. That should have been first and foremost. And I don't think the senators should have been allowed to vote on those. But
because you're effectively voting on the evidence, but
before you've seen it.
Yeah, they were supposed to have read their homework and know what they were voting on.
Right. So definitely different that you don't see that every day.
Someone's saying that Angela Paxton is from Rendon.
Angela is from, Rendon is an unincorporated community between Mansfield and Burleson. She is from Rendon and went to Burleson High School. Rendon, and people in Dallas County probably don't even know where Rendon is. Rendon,
I've heard the name.
Rendon has a few taverns and a beer joint, but Rendon is also where about the same time that Ken and Angela got married, there was a teenage cocktail waitress who woke up in her house one morning. Actually, she was awakened by her friends throwing rocks at her window saying, "You've got to get up and go down to that singing tryout. You're supposed to go down to that singing tryout." And if they hadn't awakened her in her Rendon home, Kelly Clarkson wouldn't be the American Idol star.
Oh, wow.
Had nothing to do with the
now
case.
that is some
just
like
a little Rendon note.
Little Rendon thread.
Well, I do live on the Tarrant County side, so I am familiar with Rendon. So I do know a bit about that particular area. So the 6 senators that I noted that consistently voted yes: Campbell, Colcourse, Betancourt, Creighton, Parker, and Hall. Those were the 6 consistent votes to get rid of all this, and let's be done with it.
Bob Hall is considered, the most hardline member of the Senate. He, as we used to joke, is to the right of Attila the Hun, and would consider Trump a flaming lip. So, Hall's no surprise. Some of the rest are religious allies, faith conservatives. Some of the rest are supported by the West Texas oil money, the Ferris Wilks, Tim Dunn oil money that pours millions of dollars into these races. It's given millions of dollars to both Ken Paxton and Dan Patrick. So some of those are in that. And then you have Lois Colcourse, who's interesting, who's an ambitious senator from Brenham. Went to TCU and has hopes for higher office, and she's obviously hoping for statewide support.
Okay, Bo, we got to take a listen to what's going on here in the Senate chamber.
All right, Jeff Mateer. Oh gosh, sorry.
Y'all got to focus on this. I can't
monitor
the live feed too.
I am 57.
All right, Mr. Mateer, you're somewhat a victim of my wanting you to try to speak up when we're talking privately, so I think the microphones have taken care of that, okay?
Yes.
And where do you live now?
I live in Rockwall.
I'm going to ask you, in the interest of time, if you would just give us maybe a minute and a half or so, a little bit about your background, where you grew up, family, professional career to where you got.
Yeah, actually grew up in central Pennsylvania, and then I met a girl from Fort Worth, and we were in D.C. together when I was working on the Hill.
You can go down a little bit, I think.
I'll pull back a little bit about
that's
that.
Good. All right.
I was working on the Hill for first Tom DeLay and then Dick Armey. Met my wife. Our relationship was going to continue, it made it clear that our relationship was going to continue in Texas. And so I went to SMU Law School. I graduated from SMU Law School, and then after law school went to Carrington Coleman for the first part of my career.
Carrington Coleman is a Dallas law firm.
It's a large Dallas law firm, about 100 lawyers when I was there. And that was approximately, well, not approximately, it was 1990.
Stop there, and then I'll try to do a question answer now. When you were at Carrington and Coleman, Were you also involved in any kind of outside activities at that time?
Yeah, I'd always, since college, had always been involved in Republican politics. And so I started, did that in college. I was vice president and treasurer of college Republicans. And then even though, anybody that's been an associate at a law firm knows at a large law firm, you don't have a lot of time, especially if you have a family, because I had a young family, but I still stayed involved. And then I began to volunteer on religious liberty cases.
All right. Now, I'm going to ask you, we're going to try to do kind of short answers, and I'll try to jump in. You're aware, as every witness is, that we're working on a time clock here.
Yeah, I'll do my best.
That's just my fault. That's my job. Don't you worry about it. Yeah. So, were there any particular organizations from the time of college or law school on that you belonged to?
Yeah, I was a member of Christian Little Society starting in law school, and then in law school also became a member of the Federalist Society.
And very briefly, Federalist Society, how would you describe it and what it is?
Federalist Society is predominantly conservative and libertarian lawyers or law students who care about the rule of law and conservative and libertarian policies.
In addition to your political views on legal issues and others, without getting into much detail about it, how would you describe your life and your religion?
Yeah, I would describe myself as an evangelical Christian.
And do you belong to a particular denomination?
I'm a member of a Baptist church.
Okay. Are you a rhino?
Am I a rhino?
Are you a rhino? Do you know? Wait, slow down. You understand the term, do you not?
Republican in name only is the term.
Would you give the jury a benefit of your background, of your political views?
Well, I'm certainly far from right of center. I was nominated by President Trump to be a federal judge.
And your nomination wasn't approved?
My nomination was not successful after there was opposition from, some liberal Republicans and all Democrats.
And the relevance here I want to ask you about, have you heard the suggestion that this impeachment is really the product of rhinos, liberals, Democrats, people that are opposed to the true conservative views? Have you heard that, have you not?
Yeah, I've heard that said, yes.
All right. How would you apply that description to yourself?
That doesn't describe the men and women that I worked with on the 8th floor at the Office of Attorney General.
We're going to get to that in a moment, but as far as you yourself were concerned, was one of the issues that defeated your nomination comments that whether you made or didn't make that had to do with transgender politics?
Yeah, and the comments involved me speaking at a Baptist assembly in which I was alleged to make comments that people on the left perceived to be anti-transgender.
Right. Now, at the
I should say I didn't make the comments that they said that I made, but that was the allegation.
What I'm really after, Mr. Mature, in your life, how would you, when you went to the Attorney General's office, how would you describe what you believed in your politics, the mission of the Attorney General's office, and the profession you had chosen?
Well, look, I've always been, since law school and throughout my career, I believe wholeheartedly in the rule of law. That's something that the Federalist Society, I think, instills in people who are members, but I believe in the rule of law, and I believe in conservative policies and conservative practice.
And have you always been conservative without going into specific this issue or that issue? Have you viewed yourself very conservative on social? You have to wait me finish. You have to let me finish.
Sorry.
It's okay. It's not often that people like me get a chance to.
Well, I'm in a different.
Wait a second. You have to wait. Not often people like myself get a chance to correct people who've been a chief of staff of some organization. So I'm taking the liberties with it, okay? And I'll stop you if you volunteer. Just let me finish and I'll try to let you finish. I'm really, in terms of social issues in the political world of today, on a scale of 1 to 10, how would you rank yourself?
10 or 11.
Okay. Now, did you go somewhere else after Carrington Coleman in Dallas?
Yeah, after Carrington Coleman, a group of us who were Carrington Coleman lawyers formed our own law firm called Rosenthal, Reynolds, Mateer, and Schaefer.
Where are you practicing now?
where am I practicing now? First Liberty Institute.
And what is First Liberty Institute?
It's a national religious liberty law firm. It's actually the largest religious liberty law firm in America that's dedicated to defending religious liberty.
And indeed, since at some time recently, have you participated in several Supreme Court cases?
Yeah, since I've been back, I came back in October of 2020. We've had 4 Supreme Court cases, including 3 very important precedent-setting cases.
Well, were all of those cases oriented toward what one might say the religious right?
Yeah, I mean, probably the most infamous or famous one is Coach Joe Kennedy, the praying football coach, who the school district up in Washington fired him because he was kneeling at the 50-yard line after a game. That case took 8 years. We just celebrated him returning to the football field this last Friday.
Now, I want to ask you, why did you, and were you at First Liberty at the time you joined the Attorney General's office?
I was. I started at First Liberty in 2010. I started at the Office of Attorney General in March of 2016.
What was your job when you started with the Attorney General's office?
I was First Assistant Attorney General.
Have you heard of, when did you first meet Ken Paxton?
And I was trying to, I've been thinking about that. I would have met Mr. Paxton sometime prior to probably starting at First Liberty, and I would have been introduced by Kelly Shackelford.
And at the time that you began with the office, what calendar year was it?
What time of year?
What year?
It was March of 2016.
And by that time, how long had you known Mr. Paxton before you began?
I would guess it would have been probably almost 10 years, certainly of him. I didn't know him well, but I would have known of him those 10 years.
Who hired you?
Mr. Paxton.
In what way? Did you meet with him? Did he call you? How did it happen?
Yeah, he actually approached me a few months before March and had asked me if I would consider coming to Austin. I told him I didn't want to come to Austin. Quite frankly, I had my dream job of being general counsel at First Liberty. Today, I have my dream job.
So is the answer he asked you to join him in Austin?
He did.
Okay.
Well, and I went home and I agree. He asked me to pray about it. And my wife and I did pray about it. And we felt like we were supposed to come down here.
All right. And then, have you ever heard him suggest in public announcements and descriptions and defenses of his charges and so that he hardly knew you guys?
That he what?
That he hardly knew you. If he were to say that he hardly knew you, would that be accurate or inaccurate?
I think
you always have to let me finish.
I'm sorry.
That's okay. Would that be accurate or inaccurate?
It would be inaccurate. I think he knew me very well.
Now, after he hired you, when you went on, I'm going to be wanting to talk to you about the senior staff at the Attorney General's office. Right? And I have a diagram here I want to put up, and I want to try to do this briefly. And that is a diagram of would you put the exhibit up for me, please? Thank you. All right, you give the other side. I'll give the other side. Thank you. Now, I'm going to try to go real quickly through this.
Counselor.
But what I'm after here is...
Counselor.
Excuse me.
Are you offering this as an exhibit?
As a demonstrative.
To put into evidence?
Excuse me, just as a demonstrative exhibit for him to just talk about. If you could, would you tell the jury, and I want to try to do this briefly and move pretty quickly, okay? If you could tell the jury how this describes what the roles of each were. And I'm going to go, for instance, your immediate below you was who?
Well, below me, not to the side.
All right.
Below me are the deputies.
Yes.
So the way the Office of Attorney General was organized when I was there and when I came in is there were divisions. So it starts on the left with Ruth Ann Thornton, who would have been Director of Child Support. And it goes all the way across to Darren McCarty, who would have been the Deputy Attorney General for Civil Litigation. And everybody in between, Lacey Mays, Deputy for administration, Mark Penley, Deputy for Criminal Justice.
I think it'll be important to understand your testimony as we go along. Do each of these divisions heads have particular responsibilities of their own?
They do. I mean, they run a division in the Attorney General. Don't forget, the Attorney General's office is 4,200 employees, approximately 800 lawyers. And so spread out on this chart that's before us are the various divisions of the office.
All right, thank you. So over to the right, or your left as we look at this chart, but to the right on the chart, Mr. Bangert, what was his responsibility?
So Ryan Bangert was the Deputy First Assistant. So
Now, let me ask you this. If one were to describe where he comes down on the political scale, liberal, moderate, conservative, obviously each of these are Republican, are they not?
As far as I know, each of them are Republicans, yes.
All right. And Mr. Bangert, how would you describe his background and his views in terms of the way he dealt with issues that affect people in this country?
Mr. Bangert has similar views to mine.
All right.
He's a person of faith who's also a very, very good lawyer. He worked for Josh Hawley in Missouri. He had been a partner at Baker Botts. Very much aligns with me and quite frankly, all of our leadership.
And then if you go to the right of you on the chart, to the left of us as we look at it, who is that?
That's Missy Carey, and she's a career OAG. Actually, her father was a Deputy Attorney General, and the joke was Missy grew up at the Office of Attorney General.
Do you have any evidence that she's a member of the Deep State?
She's not a member of the Deep State. She cares deeply about the Office of Attorney General in the state of Texas.
Now, if we look at the different persons here, there's been a lot of talk about the whistleblowers. Obviously, you would be one, are you not?
I'm one of the 8 who signed the letter.
However, when we hear about the whistleblower lawsuit, did you file a lawsuit?
I did not file a lawsuit.
So as you sit there now, do you have any litigation pending against the Attorney General's office?
I do not.
Okay. Do you know whether Mr. Bangert filed a lawsuit?
He did not.
Are both of you among the 8 that sent a letter to the Attorney General announcing that what you had done, and after you had been to the FBI on September the 30th of 2020?
Yes.
Pardon me?
Yes.
Okay. Now, as we go forward real quick, what's the background of Mr. Brickman?
Yeah, so Mr. Brickman, he served as Deputy AG for Policy and Strategic Initiatives. The Attorney General and I recruited him into the office. He had been Chief of Staff for Governor Bevin, who was the Republican governor in Kentucky, and he had lost.
And widely known as a very conservative governor in Kentucky.
Governor Bevin was one of the most conservative governors in the country.
All right, go ahead.
And I had met Blake the first time I'd mentioned Federalist Society. One of the things that Federalist Society did is they brought together leadership from governor's offices and AG's offices.
And Mr. Mateer, were each of you very active, not just in your states, but nationally in conservative Republican politics, many of which considered the evangelical movement?
Yes, we were.
All right. And then who hired Mr. Brickman?
Well, ultimately, the Attorney General hired Mr. Brickman, but on my recommendation.
All right. And then if we go further, we have Mr. Maxwell there. Mr. Maxwell was there when you got there, correct?
Yeah, Mr. Maxwell, the way deputies is on the 8th floor, there's a conference room. Mr. Maxwell would sit to my right. He was the director of law enforcement.
And he actually had been there quite some time and had a career before you ever arrived, correct?
Yeah, I think he approaches 50 years of law enforcement. He's actually in the Texas Ranger Hall of Fame.
Mark Penley, who is he?
So Mark Penley came in after I came in. We had an opening for Deputy Attorney General of Criminal, and we interviewed several people. Mr. Penley had known Mr. Paxton for years. I think they'd been friends for over 20 years. They actually practiced together at a Dallas law firm known as Strasburger and Price.
Mr. Penley was also a career federal prosecutor.
He was. After he was I think he was an associate at Strasburger and Price, and then he went to the U.S. Attorney's Office in Dallas.
On the scale of 1 to 10, where would you yourself rank Mr. Penley in terms of conservative versus moderate?
I mean, again, I put him with the same as me and Bangert. I mean, he's at the end of the spectrum.
Mr. Maxwell, we talked about, is one of the ones who filed a lawsuit, correct?
Right.
And then Mr. Pendley is one who did file a lawsuit, correct?
That's my understanding, yes.
So thus far, and Mr. Brinkman filed a lawsuit, right?
Yes.
We've talked about 5 of the whistleblowers so far, 2 who did not file a lawsuit, and 3 who did. Is that correct?
That's correct.
And then to the right of Mr. Pendley, who is that?
That's to my left. You're Ryan Vassar.
All right. And what do you know about the background of Mr. Vassar?
Ryan Vassar was a protege of Brantley Starr, now Judge Brantley Starr. Mr. Vassar had clerked for Don Willett and came to the Office of Attorney General after his clerkship. And he really, Brantley, Judge Starr, took him under his wing. And he quickly established himself as one of the smartest, go-to, hardworking young lawyers in the agency.
And then Leslie Mays?
Yeah, Lacey is another person. She actually, I think, started as a elementary school teacher and then went to law school. She was identified by the former deputy for civil litigation, Jim Davis, as a rising star.
And she had also did not join the lawsuit?
She did not file a lawsuit, no.
All right.
She's currently Deputy Attorney General of Tennessee.
She's the number 2 person in the state of Tennessee now, is she not, in the Tennessee Attorney General's office?
She is, sir, yes.
Okay. After this all over, were you aware she could not find a job anywhere in government in Texas?
I'd heard that, yes.
All right. So to finish up on this particular subject, now that we've looked at who everyone was, to your knowledge, when each of these people joined the Attorney General's office here in the state of Texas, how would you describe their mission in terms of their devotion to the same things the Attorney General spoke very broadly and widely about?
Yeah, with all these individuals have in common, again, I told you I'm a Baptist, so I think of 3 C's. Okay, and the 3 C's are calling, character, and competence.
And what is calling? What do you mean?
Calling, and I know that.
Wait.
Sorry.
I actually had just 2 more words if you had just waited just another few seconds. All right. But what do you mean by calling?
Okay. I know calling sounds like a spiritual term, but for me, it's really mission and it's commitment to the mission. And so when you're looking for people, certainly in leadership positions, whether it's at the Office of Attorney General, my current job at First Liberty, first thing I want in someone is someone committed to the mission. They're passionate about the mission.
And what were you committed to about serving as the first assistant for Ken Paxton's Attorney General's office?
We are committed to the rule of law and to conservative governance.
What's the second C?
The second C is competence. So it's one thing to be passionate, like I'm passionate about baseball, but I could never have played in the major leagues, right? But I'm passionate about it, but I'm not confident. So in addition to having passion, you've got to have competence. You've got to be the best. And I always felt like, whether it's at First Liberty, I want the best. At the Office of Attorney General, in senior leadership, you want lawyers who are skilled, people who are the best in their profession.
So the third C?
Is character. Because of the responsibilities, you have to have men and women who have integrity. And I actually would share this with new employees at the office, because this is what we wanted. In someone at the Office of Attorney General, you wanted passion, you wanted competence, excel, and you wanted character.
Mr. Mateer, in 2015, when you joined the Texas Attorney General's office, 2017, 2018, did you feel that office was in sync with the views you've just been expressing?
I think it was.
And then really 2018, 2019, did you think that office was in sync with the values that you've been describing?
I believe so, yes.
At that time, did you believe in Ken Paxton and all he was saying?
Absolutely, and I believe that General Paxton also possessed these characteristics. I wouldn't have come to Austin had I not believed he was a true believer.
All right. Did you ultimately change your opinion? And all I want is a yes or no.
I did.
All right. Let's take you on that road. When is the first time that you ever met? You're going to find me doing that a lot.
Yeah.
I'm not used to it, but I'm going to do it a lot. When is the first time you met Nate Paul?
I've never met Nate Paul.
Oh, never?
Never.
When's the first time you heard his name?
Yeah, I've been trying to think about that. It had to have been sometime in 2020.
Do you have any reason to believe when it was?
Well, I've recently seen an email highlighting a public information request that I believe was sent at the end of 2019. It's possible that in early 2020, I heard the name the first time, but sitting here, my best recollection is I don't recall hearing his name until probably sometime in the spring of 2020.
So there was I think no one's going to quarrel with the idea that on August the 14th of 2019, this man that you still never met, Nate Paul, had a search warrant executed on his house and business, 4 different locations, by a combined task force of different agencies, Department of Public Safety, Securities, FBI, all on his house. And I don't think there's going to be any question that he strongly objected and vociferously opposed what had happened and what he contended was the way. Do you have any, or did you have any memory of noticing anything about that in the year 2019?
I do not remember noticing that, no, sir.
So let's go then to the circumstance in which you would have first, if I could, if I could, I moved to introduce Exhibit 628. Do you have the ability to show it to the president and the legal advisor? If not, you can give a hard copy. Before I move to introduce it, I'm going to ask if you would look at it and see. Yeah, you don't have it, so I'm going to move it to you.
Yeah, I don't have one.
May I give him a copy of this, Your Honor?
Yes,
Let me look at.
Mm-hmm.
Just look at hard copy. I'm trying to.
Any objection?
I want you to look at it and see. Do you receive fundraising emails from the Attorney General?
You know, I actually am on, I think my personal email does get emails from Mr. Paxton.
I want you to look at this very quickly and see if you have received a fundraiser email like this.
I believe I have, yes.
Right. I move to introduce 628, Your Honor.
Your Honor, this is it appears to be an email from Ken Paxton in June of 2023, which would have no relevance to this proceeding.
Well, I think we're now in the month of September, so it's in the past, and it's relevant as to who he says is behind all of while we're right here, right this moment. And I just simply want to ask this witness if he feels that that this would accurately describe him as somebody that is here testifying about the Attorney General.
Again, Your Honor, this man left the office in October of 2020. This is years later, has no relevance.
Sustained.
Excuse me.
I sustained his objection.
Okay. You can put that aside. Thank you. Now, let me ask you this. Are you imposed of a radical transgender agenda?
Your Honor, objection from reading from a document you just said was not to go into evidence.
I'm just simply asking about a phrase. It is free. I got it from it, but I can put this down and do it.
Be best you put it down.
Thank you very much. Or do you find yourself an advocate one way or the other of a radical transgender agenda?
I mean, we represented people at First Liberty who've been persecuted because they had views that are described as being anti-transgender.
All right. Now, at the end of that, I want to go now to January of 2020. Did you receive at that time, I want to show Exhibit 559, I move to introduce.
Your Honor, I think this tees up the privilege issue right here. We're going to have to decide it at some point.
I have no idea what that objection meant.
Objection privilege. I mean, this is communications in the office between lawyers, and the privilege is held by the Attorney General.
I would suggest it has nothing to do with legal advice in any way. It doesn't become magically a privilege just by the fact that two lawyers are on the email.
Actually, Your Honor, if you look carefully at the document, it's absolutely related to the legal advice, reconsideration of some sort of opinion.
Your Honor,
That's right in the strike zone of what legal advice is.
Excuse me. Is he tendering an objection, I may ask, on behalf of the Attorney General's office? This was an exhibit submitted to us by them.
Objection overruled. Continue.
All right, now, if you would, tell the court real quickly what this is. It should be on.
I'm not seeing it. Oh, now I see it.
Yeah.
Yes. This is an email that was sent from me to Ryan Bangert, unfortunately on January 1st, 2020 at 9:01 a.m.
Yeah, is that y'all's normal practice there when you were there to be working on the first day of the year at 9 in the morning?
You know.
Yes or no?
Yes.
Okay. Now, did he have a little bit more restraint and wait to respond to you the next day?
Yes.
Okay. Now, in this particular email, did you do anything with this afterwards? Did you just simply forward to him and that was it?
The issue apparently was highlighted to me as something we need to take a look at, and I would have sent it on to Mr. Bangert for him to deal with.
Do you know now from looking at what the issue was?
I mean, I do know the issue had to do with a public information request made by Mr. Paul and or his attorneys.
All right. And so but had you been involved in that at all, or would Mr. Bangert be the better person to discuss that with?
Mr. Bangert would be the better person.
As you sit there now, was this something at that time that you got involved in one way or the other?
It was not on, no.
Had the issue of the public information request having to do with law enforcement exceptions, had that worked its way to your desk yet at that time?
Not that I recall. I think this is the first time.
All right. So who would be, at that time, who would have been responsible in the Attorney General's office for the issue of public information request?
Justin Gordon.
Pardon me? Justin Gordon?
Justin Gordon.
And then if we went up the chain, who was above him? Do you recall?
Above him would have been, I believe it goes to, memory test. I believe it goes to, for me, it would have been Ryan Bangert ultimately, who was overseeing it.
And indeed, so when you got that request, when it says Aaron Borden, were you able to determine who that was? In terms of her position or context of why you sent the email?
Well, what I would have is Meadows Collier, and based upon the statement that I've made, we've been asked to take a closer look at this one. That means someone asked me to take a closer look at this one.
All right. And did you ultimately determine it had to do with a public information request by attorneys on behalf of Mr. Paul? Nate Paul. All right. Now, is all you did was just send it on to Ryan Bangert, and is that all you did with it?
That's all I did.
Does that help explain in your mind why you don't really remember anything about it?
Until seeing this and getting ready for today, I don't recall.
Okay. All right. Now, when is the next time that you remember ever hearing the name Nate Paul?
I really think it was June of 2020.
All right. So we're in June of 2020, are we? And what was the circumstance in which you did that?
I think that's when is the first time I was introduced to an entity called the Minty Foundation. I think that's the name, Minty Foundation.
All right. Now, I'm going to move to introduce at this time, Your Honor, Exhibit 62.
Before you do that, I want to admit Exhibit 559 that I rolled on into
Thank you very
the
much.
evidence.
No objection to this document.
Now,
it will be admitted into evidence.
Thank you, Your Honor. What do you, could you tell the jury very briefly what this document is?
Okay, this is an executive approval memo regarding, and I think I can't move it, but I think it's regarding there we go. It's regarding a request to intervene into a legal matter.
All right. Now, let's we'll try to move through this quickly. Can you very briefly describe the process for a particular, that would call for a litigation memorandum like this?
Yeah, so anytime we're going to approve some sort of action, if it's filing a lawsuit or it's intervening into a lawsuit, we had in place a process in which a lawyer in a division, so in this case, it looks like Mary Henderson, who it's from, would request an action. And in this action, we want to intervene into this lawsuit. So this memo sets forth the reasons why the Office of Attorney General should intervene into a matter. It then goes up the chain of command. So it goes up to her division chief, which in this case would have been Josh Godbee, who was chief of, I think it was financial trusts or financial transactions and charitable trusts.
And then it goes up to who?
And then it goes up to the deputy over civil litigation, who's over all the divisions of litigation, and then ultimately it would go up to me. And the way the DocuSign system works is Mary signs it, then it goes to Mr. Godbee. Mr. Godbee doesn't sign it, Mr. McCarty doesn't see it. Once Mr. Godbee signs, it goes to McCarty. Once McCarty signs, it would come to me.
All right, so this is important, Mr. Materi, and I want to, because there'll be another occasion for this same process. How is the decision made as to who all is own this executive memorandum?
Yeah, we had to actually have a signature matrix, and depending on what the issue was,
okay,
we had to, and these were in place when I came in. And my understanding is they date back to at least when Governor Abbott was Attorney General, maybe even further back.
All right, so this process that requires everybody in the division and then up to you to pass off on it is designed to do what?
Well, I mean, the policies and procedures are there to actually protect us all and ultimately protect the agency and also protect the Attorney General.
All right, so in this particular case, if Ms. Henderson is recommending the intervention in a lawsuit, is that right?
That's correct.
And and lawsuit says the public interest in a charity, correct?
That's right.
In that recommendation, what would have happened if Joshua Godbee, the person right above her in the DocuSign matrix, if he said no, does that kill it?
If he says no, it kills it, and I would only hear about it if someone brought it to me.
So are we to understand that if Mary Henderson sent this recommendation above and it got to Joshua Godbee, and if he said yes, then it would go to Mr. McCarty, but if he said no, that's it?
That's correct.
Okay. So in some actions that are being recommended, how many people was your system designed to work through before it got to you for approval?
Well, in this case, 3. In some other situations, it's even more people.
Okay. We're going to get to one that has to do with hiring outside counsel in a while. That had a lot more people that had to go through there, correct?
That's correct, because we were spending money.
All right. And that's what added people?
Yes. I mean, one of the reasons, yes.
And would it also add people if it crossed 2 different divisions' jurisdiction?
Correct.
All right. So here on this one, at the time of this one, you signed off and approved it, did you not?
I did.
So your approval on here meant your people were given permission to do what? In a lawsuit involving this charity?
It gave permission for them to intervene into that lawsuit on behalf of the charity.
At this moment, on June 6th, or is that 8? I didn't put my glasses on. Is that 6/8?
I think it looks like the 8th.
All right. At that time, on June 8th of 2020, what was the extent of your knowledge about the particular issue, a lawsuit that you were approving an intervention on?
It is possible that Mr. McCarty had told me about it, and sometimes deputies would give me heads up that something was coming. And so what best recollection is I probably have gotten that heads up. Yeah, I would have gotten a heads up.
Would you be aware that the line people in the past had waived intervention and made an affirmative decision not to intervene in that lawsuit?
I don't think I was aware of that at this time.
All right. Were you aware that the lawsuit was a lawsuit between the charity and an entity controlled by Nate Paul?
You know, I don't know if I don't remember.
At this time, in June of 2020, had you become aware at any level of consciousness in your mind of Nate Paul?
Not in early June, I don't think so.
So we can safely rest assured that whatever you're going to tell this jury today is based on information that you got after June 8th of 2020.
That's correct.
All right. So were you aware of any issue at the time you proved the intervention yourself at this time that would have clued you to how strongly opposed to this intervention the people who represented the charity were?
I don't recall any of that, no.
All right. Now, you see that this, I don't want to go into it, but you see there are multi-pages here. Do you recall whether or not you would have read through these, or would you since you've relied on the line worker that recommended it?
Well, actually, two answers. I would have relied on the people, but I also did read it.
Okay. Now, what did you think that y'all were doing in this and why you were intervening in this lawsuit?
I thought based upon Ms. Henderson, Mr. Godby, and Mr. McCarty's recommendation, this was in the interest of the state of Texas to intervene into this lawsuit.
Did you have any idea at that time whether Mr. McCarty thought it was a good idea?
I assume since he sent this memo, he did.
Were you aware one way or the other as to whether Mr. Paxton had any input in this decision?
I was not aware, no. That wouldn't be uncommon. Wouldn't be.
That would what?
It would not, I mean, because the Office of Attorney General, when I was there, it was over 30,000 litigation matters, cases, civil matters. So I didn't know about every one, and there's no way the Attorney General could.
So let me ask you, at this time, were you aware one way or the other whether Mr. Paxton was in contact with both Mr. Godby and Mr. McCarty urging this intervention?
In June, I don't think I was aware of that.
Okay. Did you later become aware of that?
In July, I became aware of that.
All right. But at this time, not, correct?
Not in early June, no, I don't believe so.
All right. Now, were you aware, had you ever dealt with the charitable trust to understand what the obligation of the Attorney General's office was toward charitable trust?
I mean, I came to learn of it, yes.
But you had not.
I'm not a charitable trust lawyer.
Okay. And at June 6th or June 8th of 2020, were you familiar with the Mitty Foundation one way or the other?
I don't think so.
Okay. Now let's go, if we can, to Exhibit 67. I move to introduce Exhibit 67, Your Honor.
No objection.
Can you tell us what this is, please?
Admitted into evidence.
Excuse me, I'm sorry, I apologize, I jumped the gun on you.
No problem.
Can you tell us what this exhibit is, please?
It is another executive approval memorandum for civil litigation, and this one is a request to investigate, not the same as intervening, but to investigate a charitable trust, the Mitty Foundation.
Do you have any personal memory or anything about this event or why this one was done?
Other than it has my initials on it, I do not.
And it's a little later, is it not?
That's correct. It's, I think, the next day, June 9th.
Looks like
and I sign it on June 11th.
Okay. Now, did you ultimately, I want to go if I can, and were you having contact? You've talked about Darren McCarty, or we have, Joshua McGodwey. Were you at this time having any contacts with the line lawyers on this case?
Not with the line lawyers. My contacts would have been with Mr. McCarty. He had a one-on-one every week with me.
All right. Now, what was Mr. McCarty's primary duties at this time in the overall scheme of the office?
I mean, he was in charge of all the civil litigation. So all those 30,000 cases, they would be at Darren. However, his number one job, in addition to leading that, was we had two major pieces of litigation. One against Google and one that was a big litigation against the opioid manufacturers and distributors.
All right. And how much money potentially was involved in that?
Oh, billions of dollars.
All right. So let me ask you this. Mr. McCarty, how much of his time would you estimate he was spending on the Google case?
I mean, a fair amount of his time. I would say over 50%, because that was a major piece of litigation for the office.
Ordinarily, would he be pulled in to managing or doing anything of a lawsuit this size?
You can't, we have 30,000 cases. I can't be involved in every case. The deputy for civil litigation, one that is not, I mean, obviously significant to the parties, but in the scheme of things for the state of Texas, that's very unusual.
Did you have any idea at that time why Mr. McCarty kept getting involved in this case?
I mean, in June, no.
All right. When did you become aware?
Mid-July.
All right. At this time, we haven't really mentioned the fact that we're talking about the era of COVID, are we not?
We are.
We're in the month of June. COVID was roughly, as far as the governor's proclamation and everybody running around on it, trying to figure out policy, that was the middle of March, right?
Yeah, I mean, the whole COVID effort took a lot of my time and Mr. Bangert's time and Mr. Vassar's time, quite frankly.
Do you have any explanation as to why people such as he and y'all were being involved in this kind of case?
I mean, we just normally wouldn't have been involved in this type of case.
All right. Now, I want, if I can, to go to Exhibit 147.
Any objection?
I move to introduce. I'm sorry, Your Honor.
No objection.
All right.
Admit Exhibit 147 into evidence.
It's up on your screen now. What is this?
Yeah, this is an email exchange between me and Mr. Nate Paul.
Well, how did it come about that you and Mr. Nate Paul were having email exchanges about?
I don't know, because it came out of the blue. He's in this email, he's asking to meet with me in person. As I testified to earlier, I had never met Mr. Paul. I've never talked to him on the phone. At some point in July, I became aware of him. That must have been through the Attorney General, who would have alerted to me about him.
All right. So now this is dated on July the 17th, is it not?
It is.
You have any idea why Mr. Paul would feel so comfy asking you for an appointment that he's calling you Jeff, if neither one of you have ever met each other?
I can only speculate.
Were you aware by that time he was friends with the Attorney General?
I don't know if I knew what the extent of the relationship was. I knew they had a relationship by then, I think.
And so this idea that you would talk to him on the 17th, what was your three-word answer?
Remember, I'm Baptist, so it was, I'm not available.
All right. And why did you say you were not available?
Well, I knew at this time that there was litigation involving Mr. Paul. I mean, I would have known that, and it would not be my practice to meet with someone who's represented by counsel who is, I mean, they're not, it's an opposing party. It's just, they're involved in litigation that the state is involved in. That would just, I mean, beyond that, as a lawyer, you just don't do things like that.
Well, to put it another way, you guys were in litigation with Mr. Paul as one of the parties. Would you ever meet with him without his lawyer?
Well, we had intervened into a lawsuit.
Right.
And so we were in the middle of the V, so to speak.
All right. So is that why you told him you would not talk to him?
That is right.
All right. Now, I want, if I can, I'm going to, well, let's go now, if we can, to Exhibit 87. This last one we just looked at was July the 18th, right? You remember that?
July 17th and 18th,
Any
correct.
objection?
Right.
Hearsay, Your Honor. This document is hearsay.
Well, I wasn't filled with the question. Let's just. I haven't asked him. I haven't asked to admit it yet. I will.
Well, I just thought he had forgotten, but
So
it's hearsay.
the two documents are, one is July 18th, and the one you're being shown now is July 22nd. Is that correct?
I'm not seeing it yet, but I do know I did
That's
a
a
memo
good
to the
point.
file on July
All right.
22nd.
Let me just walk up with you, show you the hard copy to identify it. It's not in evidence yet, so don't testify from it. Okay. But without testifying to the contents, tell me whether you recognize that as a memo of yours.
Mr. Hardy, give me a moment. I want to look through this. Just 1 second.
Sir?
Give me a moment. I want to read through this on his
Sure.
objection. Are you submitting it?
Not yet.
Okay.
I will, but not yet, if that's okay. Did the court have something on your mind you wanted to?
Move on.
Thank you. I want to ask you now, back on that earlier email, Mr. Paul asked you for a meeting on a particular date, did he not?
Right. I think he wanted to meet the following week, that Monday.
Well, let's do for the record and the court real quickly. July 17th, let's go back if we could to 147, Stacy.
Yeah, I've seen it.
That memo says, does it not? Or go ahead and read it out loud for the jury.
Yeah, it says, I hope all is well. Are you available for an in-person meeting on Monday, which would have been the 20th, I believe.
Well, that's what I want to do. Let's figure out the dates for the jury. Up above, we know when you said I'm not available, it was July 18th on Saturday, correct? So Monday would have been the 20th of July, is that correct?
That is correct.
Did you later discover there was any significance to meeting on Monday in terms of anything else that was supposed to happen that week?
Well, I found out on the morning of July 22nd that there was a hearing involving the Mitty Foundation case.
And on July the 22nd, that would have been a Wednesday, would it not?
That would have been Wednesday, yes, sir.
What time that day did you find out that there was a hearing scheduled for that day?
It must have been pretty early because I normally arrived at the office 7:15. And I got a call that morning before I'd left for the office from Darren McCarty.
Did you later go back, Mr. Mateer, and figure out that the meeting Mr. Paul wanted on Monday the 20th concerned this hearing on the 22nd?
I believe that was the case.
All right. But not having met with him on the 20th, until you got to the office that morning or whenever you were contacted, were you aware before the morning of the 22nd that there was a hearing scheduled for that day?
I was not aware.
How did you become aware of that hearing?
Yeah, Mr. McCarty, the deputy for civil litigation, called me. And I remember being at my condo in downtown Austin. Again, had to have been sometime in the 6 o'clock hour. And he had advised me.
Objection, hearsay.
Yeah, he's certainly right. It is. So after, what did you and the others become concerned about what was about to happen, what was about to be proposed that morning?
I was concerned that the Attorney General was going to appear in Travis County District Court and argue a motion on behalf of the Office of Attorney General.
Well, why would that concern you?
Well, I mean, at the time, I couldn't remember a sitting Attorney General actually going into a district court to argue anything. I mean, the last one was probably Dan Morales.
What was your fear?
I mean, General Paxton has some wonderful qualities, but he is not a litigator. And to think that he would go into court arguing a motion just made absolutely no sense, and especially on a matter, I mean, this isn't the Google case. This wasn't a Supreme Court argument. This was, with all respect to those who practice in Travis County District Court, it was Travis County District Court.
All right. Mr. Mateer, as a result of your concern, did you organize a meeting?
I did organize a meeting that morning.
That's all I'm asking right now. All right. And who all did you have at that meeting?
Well, I had Mr. Paxton, and I had Blake Brickman, and I had Mark Rylander, who was the Deputy of Communications.
Okay. And at that
Director
meeting,
of Communications.
what was your intent for that meeting initially?
I mean, I wanted to find out what Mr. Paxton was thinking, because, I mean, it was inconceivable to me that he would want to go to district court to argue something.
Did you know at that time on whose behalf the argument would have in effect been?
I think, Mr. McCarty, I would have known.
And who was that?
Well, it would have been in the Mitty Foundation at the urging of Mr. Paul.
All right. And when you had the meeting, before you started talking about other things with the Attorney General, what did you discover in terms of whether somebody had changed his mind?
Well, I did learn that actually Mr. McCarty was successful in having the Attorney General not go to that hearing. He was persuaded not to go.
So then what did you move that meeting of July the 22nd? What subject did you move it to?
It had to involve Nate Paul. I mean, just that the Attorney General being involved in matters like the Mitty Foundation, things, again, that were not significant litigation matters at the Office of Attorney General.
By that time, and by talking to other deputies and information, had you become concerned about the Attorney General's relationship with Nate Paul?
I was starting to become concerned.
So during that meeting, did you take any position and urge him in any way concerning Nate Paul?
Objection, hearsay. And also it's privileged, Your Honor.
I think what we're
Sustained.
about to have, yes.
Move on.
What I'm about to offer, Your Honor, is party admissions by a party opponent. Comments that Mr. Paxton made in that meeting is the reason for it. And I think that comes in under admission by the party opponent.
Move on.
Sure. You say move on?
Move on.
Okay. Now, in that meeting, did you yourself make any particular urging of the Attorney General?
Objection, hearsay, and also privilege.
Object on both grounds. I haven't asked him for the statement.
Overruled.
Thank you. Did you?
I did.
And what did you urge him as it regarding Nate Paul?
Again, Your Honor, this is hearsay, and also it's him advising the Attorney General, which is privileged communication.
First of all, the Attorney General is not here, and he doesn't have the right to claim an attorney-client privilege. There is no personal attorney-client privilege for him. The only question would be as to whether the Attorney General's office had the right to invoke it, and I respectfully suggest they do not.
Overruled. Move along.
Thank you. So, what did you urge him?
I urged him not to have any further dealings with Nate Paul, to let the lawyers, the professionals in the Office of Attorney General, handle these matters as they saw fit.
What was the Attorney General's response?
He committed to that.
Objection, hearsay. Also, it's a communication, Your Honor.
I think this comes under the party admission, Your Honor. This is, I think, clearly admissible. In terms of the Attorney General, he's the party, and this is the admission being offered as admission by him.
Overruled.
Go ahead.
The Attorney General committed to me with Mr. Rylander and Mr. Brickman in the room that he would have no further dealings, that he would allow the office, the professionals in the office, to handle the matter.
How long was this meeting that y'all were in?
I guess 30 minutes or so, maybe 45 minutes.
Now I'm asking you demeanor and manner as opposed to actual words. How would you describe how insistent you were in your urging of him to have no more contact with Mr. Paul?
It was very troubling to me that the Attorney General would be willing to appear in Travis County District Court. So I was very concerned that why he would want to do that when we have, again, 800 attorneys at the Office of Attorney General who are very capable.
My question is, how insistent were you?
I was pretty insistent.
Obviously, you recognize he had the right to talk to anybody or help anybody, you thought, right?
Well, and I wanted in this meeting, that's why I had Mark Rylander there. Because Mark Rylander, his title was Director of Communications, but the joke in the office was I was first assistant and he was first friend.
All right. So in this meeting, how would you describe the demeanor or earnestness or lack of or whatever the Attorney General's outward response when he told you he would not do it anymore?
He seemed sincere to me.
When you left that meeting, what did you believe in terms of the Attorney General's conduct in the future or contact or attempts to help Mr. Paul?
I was hopeful that he would allow the professionals in the Office of Attorney General to do their jobs and he wouldn't be involved anymore.
All right. Were you surprised to discover later that the very next day he's contacting other assistants on other matters to help Mr. Paul?
Surprised and disappointed, yes.
All right. During the time from July the 22nd, from then on, after his assurance that he would have nothing more to do with Mr. Paul, did you become aware that his contacts with Mr. Paul had become even more frequent?
I did.
Did you become aware that those contacts that were much more frequent also touched a broader variety of activities?
I did.
Than
Yes.
just charity?
Yes.
Okay. At this time, Your Honor, I will move to introduce what my number was. I don't have it here. The number of the last exhibit. Can I
Set
have
number 87. Exhibit 87. Admit it.
We object, first off, hearsay, Your Honor. Second off, it's clearly, he even expressed concern for the Attorney General. That was his client. This talks about communications between client and lawyer. This is a privilege issue, square and away.
I already admitted 87. Overruled.
Now, if I could, I want to ask you to move on to another exhibit, but let me ask you something before I go there. That meeting was on the 22nd, and I apologize. I think when you were talking, I may be dropping my voice some here. I'm hoping people in the back can still hear, but let me make sure they can at this tone of voice. And did you ultimately respond to back where you and I were before, to anyone about the particular request that had been made of you by Mr. Paul to meet back on that Monday? Remember, on the 17th, he asked to meet you on the 20th, correct?
I think at some point, Mr. Paul's lawyers send me either a letter or an email, which I respond to, again, I think by email.
All right. What I want to do is, if I may step over briefly, if I may have your permission to get the number. Ask you, I'm going to come up and give you a copy of it so that you can look. Let's see. Thank you. I've been corrected by somebody who knows much more than I. I really should be talking about 161. It's the same document, but I gave it the wrong number in my questions. Now.
You have it?
Stella, excuse me, did we give him one? Army, if we can just find one in another book. I'll give him mine until we get it. But,
Mr. Harden, you want? I've looked at it if you need it. I think I remember it.
Here's what I'm asking. Now that you've had a chance to look at 161, does that refresh your memory as to when you then responded to his request to have met back on the 20th?
Yes, it does.
All right. And when did you, we've gone through the meeting on July 22nd. You've had the conversation we heard about with the Attorney General. And then now you've moved back to July 24th, 2 days after the meeting with the Attorney General, correct?
Correct.
And so then did you sit down and draft a memo and respond, rather, to whom?
Well, to Mr. Paul's lawyers. And actually, I didn't really know who they were at this time. And so I was asking for information so I could adequately respond.
Yeah, I got it. Yeah. All right. So here's what I wanted to do. The reason I stopped without giving the name, I wanted you to give it. At the time you received a letter from Mr. Paul, did you even know who his lawyer was?
I did not or didn't remember.
All right. So then when you checked around, did you become familiar with whom you were going to be talking to?
I did.
And who was that?
Well, sitting here, I don't remember. I know Mr. Wynn was one of his lawyers.
All right. Well, actually, let me just ask you and focus on that. Did you become aware that a Mr. Michael Wynn was representing him in some matters?
I did during that time period.
And regardless of who he was, had you, by the time of the 24th, looked at the history of correspondence with Mr. Paul in terms of the way he talked to your people?
I mean, he attached in his email to me, he attached.
Is this the email? Excuse me. Is this the email back on the 17th?
I think it's a later email.
All right. And what did he attach for you?
He attached correspondence that he had with primarily Mr. Godby, and in which he's complaining to Mr. Godby.
Exactly. Was he complaining about the treatment he was getting in the Mitty Foundation lawsuit from Mr. Godby?
Yes.
Was he complaining that he kept writing Mr. Godby, he, the party, writing the lawyer for the other side? Was he complaining in constant emails about Mr. Godby?
That's exactly what he was doing, yes, sir.
And Mr. Godby, because he's not supposed to talk to a represented person, had done what?
He had not responded, which would be what any lawyer would do. You don't respond to the client or of the potential opposing party, you respond to their lawyers.
When you looked at the letter, actually when you were getting ready to write him on the 24th, did you have occasion to review that correspondence?
I did, yes.
And that's why I moved, if I could, Your Honor, to 161. I moved to introduce 161.
Any objection?
Yes, Your Honor. This privilege issue keeps coming up. As you can see on the document itself, it says this is attorney work product communication regarding a pending litigation matter. I mean, it's labeled as such. And I would suggest to the court that all of these types of emails are, in fact, work product or attorney-client privilege communications, and the only individual in that office who holds that privilege and who can waive that privilege is the elected Attorney General.
I'm sorry for laughing. I have to, so this is when sometimes we might take positions that come back to bite us. This is actually his exhibit that we agreed to pre-admit. And so I am offering an exhibit that was pre-admitted by us to him because it was one of his exhibits. Well, hold on. I'm not quite sure how he can now turn around and make a bunch of objections to an exhibit that he agreed to pre-admit. That we agreed to pre-admit and he accepted. It's his pre-admitted exhibit. It's in evidence, is my point.
I'm very confused because that was very confusing, but I would suggest this to the court. They put 161 on this as if it was their exhibit and moved it into evidence, and you asked for my objection.
Yes.
161 on their exhibit list is not this. So, I mean, I'm trying to, first, I guess we need to figure out what exhibit he's actually trying to offer. And if he's really trying to offer this, it ain't the right number. And if he's offering something that's already in evidence, then obviously I wouldn't object to it. But I'm very confused about what he's trying to do.
The court is very confused too.
I suggest he talk to, like I did, talk to someone on his side that knows more than he does about this. If he notices that exhibit that we introduced is AG 161. That's the Attorney General 161. I think if he checks with his people, he's going to find that's their exhibit that we agreed to pre-admit.
I didn't have any discussions with Mr. Harden. I mean, I know he's accused me of being recalcitrant. I haven't had any discussions about the exhibits, but my colleague, Dan Cogdell, has. As I understood it, they weren't going to object to any exhibits that we offered. They have no objections, but we had exhibits on our list that we may not offer. So I think that's probably what the dilemma we have, but I'm going to turn it, if you don't mind, since I didn't talk to Mr. Harden personally, maybe Mr. Cogdell can enlighten me.
I again suggest he talks to someone who knows something about the subject. I've just been handed my Ms. Jarris, and I'll be glad to tender to the court, where they have written down their exhibit number on this. 61.
That might be true, but you need to let us know you're offering our exhibit. I mean, when you say 161, that presupposes you're offering your exhibit 161. That's why we looked on your list, and this ain't your exhibit 161. Now, with regard to whether these were pre-admitted or not, I would turn it on to Mr. Cogdell.
In light of him objecting to us at this extended time, this may be the first time I'm asking the court to take that in consideration. They've been objecting to their own exhibit.
Mr. Cogdell.
Judge, in my conversations with Ms. Bravorka, both.
Speak into the microphone, please.
Yes, sir. In my conversations, and I understand Mr. Harden's heartburn that he didn't object to ours and we're objecting to his. I get that. That notwithstanding, in my conversations, both orally and in email exchanges with Ms. Bravorka, I very clearly stated that while I appreciate their not objecting, we did not intend to offer all of our exhibits. Many of our exhibits were marked for identification purposes only, for impeachment, for whatever. So I never said, just because you didn't object to them, we want to offer them all. That never happened.
I think we may be raising gamemanship to a new level. The fact is, it is their exhibit. They asked if we would agree to pre-admit. We agreed to pre-admit. That put it in evidence. It's as simple as that.
No, it doesn't. Just because they didn't object to it, somebody has to offer it. We never said all our exhibits that we marked are coming in. We never said that. I never said that. I get his heartburn, but I'm happy to pull the email up in my exchange with Ms. Bravorka, but I clearly said in there, we do not intend to offer all of our exhibits that have been marked.
I'm glad we don't have to poll the kids in the upstairs as to what they think about this exchange. We've now used about 8 or 9 minutes, I think, on them objecting to their own exhibit. I tender 161.
I'm sorry, I couldn't hear Mr. Harden. I couldn't hear the last part, Rusty.
I'm sorry. I said, I'm glad that we do not have to poll the kids in the balcony as to whether this exchange makes any sense. I think we've taken about 8 or 9 minutes now on something where y'all are objecting to your own pre-admitted exhibit.
Again, they're not pre-admitted. They haven't been offered. We never said, if y'all don't object to them, we're offering all of them. To the contrary.
I'm going to take a 5-minute break.
Thank you.
I'm sorry. Can I just? Okay, thank you.
Mateer. He was the former first assistant attorney general. That's the second in command of the office, so very high ranking in that office. You can't be much higher than that, except for the attorney general. And then this whole, they started off with this really laying out Mateer's conservative bona fides, right? That he worked for Tom DeLay and Dick Armey, and that he was a member of the Federal, and he was part of the First Liberty Institute, and when he ranked himself on the scale of, how conservative is he, he was a 10 or 11, that's so. And then there was some discussion about the other people and how they're conservative bona fides. But this testimony has gone into this whole description of Ken Paxton wanting to go argue motions in district court in this lawsuit involving the Mitty Foundation. The Mitty Foundation was this charitable organization, and Nate Paul had done there was an argument over real estate. Mitty Foundation had invested with Nate Paul, and when the time came to pay for Nate Paul to pay them, he didn't pay. And so then there's a whole lawsuit lasted for years. And so my understanding is that the AG's office represents the interests of the charitable foundation because that's nonprofit funds. So what Mateer is saying is that it was extraordinary for the AG to want to go argue a motion.
That's right. That's not common. When I was an assistant United States attorney with the Department of Justice, I think in the 8 years that my U.S. attorney was there, he argued one case, and it was a very important case. It was a 3 strikes case. When I was, at the Attorney General's office, special counsel to John Cornyn, that's the reason you have those frontline prosecutors. That's the reason you have those frontline AUSAs or assistant AGs. They're the ones down there doing the argument. So this is one incredibly strange for a very small case in the sense of being in a district court, as the witness said, as Mateer said. The other thing too is not only is that Paxton wants to go argue it, but it involves a case of his donor who's on the other side of the charity. So he's supposed to.
There should be a firewall.
He should be entering the case on behalf of the charity, not on behalf of Paul. And it would have been interesting to see if he had ever actually gone into the courtroom. Was he there to basically argue that the foundation didn't deserve to recover its funds and investment when they felt they were defrauded by Paul? So that would have been interesting to definitely see. But you can see for Mateer, not only is he just out, discombobulated by this, flabbergasted. He thinks this is just shocking.
He's just trying to figure out
why are you wanting to do this? And he's just met Paul. He understands the relationship is very close with Paul, and then he brings in really his fellow assistant AG, Rylander, who he hopes is a good friend to Paxton, is going to be able to talk him out of doing this. And they think they've cured the problem, that he's not going to do this. They only to find out the next day that he's talking to other prosecutors about getting involved, and that he's increased his
So the problem is not
communications.
cured.
It's not cured, and there's more and more communications with Paul. And when Mateer's told him basically, don't get near this guy, he's kryptonite. There's
red flags
he's
everywhere.
Nuclear. Let's not be talking to him. We should be talking to the opposing counsel in a litigation in which we're supposed to be representing the charity, and clearly Paxton can't give him an answer and an explanation as to why this is so important that he appear in person.
So Matt, talk to Bud and I. We're not attorneys.
Yeah.
This whole back and forth about executive privilege, and just talk to us a little bit about your thoughts on that whole mess.
This is a red herring, and we've seen this privilege argument in the cases that came out of the Trump administration, whether it's with the Mueller report, January 6th, or Congress bringing it. Typically, what you'll see is the witness say, "Oh, this is executive privilege." Here, they're trying to make that same argument by saying that Paxton, in his role, has some sort of privilege. But remember, he doesn't personally hold the privilege as an individual. The office might hold that privilege.
Right.
And guess who's not in the chambers right now?
Right.
Ken Paxton. So if Busby and Cogdell are going to allege this, and he somehow individually, magically has his own privilege that is bequeathed to him somehow from the taxpayers in his role as an executive function for the state, one, he should be in the room asserting it, because the privilege, those communications are supposed to be confidential between a lawyer and their client. And in this case, it's got to be Pax who says, I'm the client, okay? I was asking for advice from my other lawyers. Well, one, that doesn't exist. And that's what you heard Rusty Hardin say. That's not a thing. That's not a thing. He doesn't have a privilege. So if the Attorney General's office has a privilege, then someone needs to be able to assert that. And this should have happened far before anyone walked in today. This subject matter should have been taken up. And I think Rusty Hardin really highlighted this, because when you talk about privilege, the confidentiality between communications or work product between a lawyer and their client, it has to be for advice. I get this question a lot of times from corporate folks, in-house people and executives. They think if they CC on an email their in-house lawyer, they have somehow established legal privilege. You're not seeking legal advice. So it has to be that you're going to a lawyer and saying, I need your advice, and that's what I'm seeking. Here it sounds like Paxton was just wanting to appear. He didn't really want any advice. And then furthermore, a bigger issue is the waiver. You'll hear this a lot in many cases, is that, and Hardin pointed to this, they produced all these documents. Paxton's office had sent all these documents over. If they truly thought they were privileged, they should have been stamped conspicuously with a red big old stamp on the front of them saying attorney-client privilege. They should have built out what's called a privilege log, indexing each document in each section. Then they should have provided that in camera to the court, to Patrick, and said, we believe these documents cannot come in.
So they make a mistake here?
They've waived. I don't know how you can, this might be the greatest case of waiver I've ever seen, is if you wanted to establish the objection and block it from coming in, that was weeks ago that you could do that. And I think that's where Hardin is doing a great job. He's doing a very good job of not trying to embarrass Patrick, that he's not been a judge before, this is his first time. He's doing a good job of laying the foundation and the predicate of saying, well, Your Honor, this isn't legal advice, one. Two, Paxton's not here, so if he does have a privilege, which I don't think he does, he can't assert it because he doesn't have an individual in his own individual capacity, the ability to do that. And three, is this someone asserting it on behalf of the Attorney General's office? Who is that person?
Right.
They're not in the room either. And then foremost importantly, they already sent it to us. This is already in an exhibit. It's already been marked. And if they thought this was privileged, they should have said something long ago. It seems to me like this is something that they have kind of come up with recently, because as you notice,
is this grasping at straws?
They threw it out at the very beginning, right after they completed all the motions this morning, and it was like right before opening statement, said, "Oh, well, we got this privilege issue," and I wonder if this came up in the last couple of days. Well, that's the thing about privilege issues. You got to start them early on, and you got to be vociferous and loud about it, and you got to make clear guardrails. These documents aren't coming in. Here's why we think there's a privilege issue there. And at some point in time, I'm hoping, whether it's the assistant judge with Patrick, will say, we're ruling that none of this stuff is privileged and everything is coming in. And that's something they should probably take up at the end of the day, if not first thing in the morning, and just say, we're giving a ruling from the bench that,
that
if
it's
you
all
think there's
coming
anything
in.
privileged, you need to raise it right now. We'll take a look at it tonight, but the ways and steps in which you protect those documents have not been done. Somebody whiffed at this ball somewhere along the way, and because this is classic waiver.
But
my layman's understanding of this is basically that all state agencies, departments have lawyers. The comptroller has lawyers, as Scott Braddock's pointed out on Twitter. The land commissioner has lawyers, but they work. Their client is the people of Texas, or the state of Texas. It's not the elected official personally, and so so the elected official personally can't assert that kind of attorney-client privilege.
That's exactly right. That's a great point.
Okay. So really, the lawyers work for the people.
Right.
And so Paxton can't claim they're his lawyers. Obviously, he has some other lawyers.
Well, he has some lawyers right now that work for the state of Texas and are on temporary leave working on his defense team, which, as we talked about earlier, is extraordinary. Well, actually, and whenever they show a picture of his defense team, one of those lawyers, a couple of those lawyers sitting right there, are two attorneys that work for the Texas Attorney General's office that are on temporary leave right now, which I think is just, again, extraordinary.
Which is really amazing, because, I mean, if I think Hardin really wanted to mess with them, it would be great to just look over there and say, hey, are you going to assert the privilege for your office since you're here in the room?
Well, they're on temporary leave, so I don't know if they can do that. I don't know if you can have it both ways, but I guess you could try.
And so what's the dynamic right now between Lieutenant Governor Patrick and the judge who's assisting him? Should she be more assertive? Are they really trying to confuse him?
I think they're doing a good job of it. That's what they're there to do, to advocate for their client and mess up Rusty Hardin's direct as much as possible. Make it disjointed. Don't let him be able to just, I was going to say great directs are like watching Fred Astaire and Ginger Rogers. It's just magical. It's the testimony is going back and forth from the questioner to the witness. And I think Rusty's doing a very good job about that. So I think they'll continue to try to throw these objections out there. And there'll be compound objections. It's privileged. Oh, it's hearsay. And I'm sure some point we'll get some other ones too that'll come along. But that's to try to break up
the rhythm,
break up the cadence of what Rusty's trying to get in a groove with this witness to get the story out.
And you raised a point about hearsay off mic here that's important too. That if it's if it's Paxton himself, that it's not hearsay. Is that what you said?
That's right. So when I was teaching trial advocacy at SMU, every baby lawyer learns this in evidence. Law students know this for a fact, that the defendant, there's an exception to the hearsay rule, and it's any statement by the defendant. And so anything that Paxton says, it's admissible.
Right.
And as I also mentioned earlier, it's one of the reasons why I believe one of the articles in here is conspiracy, is because any statements by your conspirator, and they could be an unindicted or unimpeached conspirator. We've heard about this in other cases, unindicted co-conspirator number one.
Right.
So basically those statements by that person to the defendant also are admissible and meet the hearsay exception and are admissible. So it would be great if on one of these next breaks, if Patrick and the judge could sit down and knock out these two important issues, the hearsay rule, that everyone's in agreement on that, and what their ruling is, and then also on the privilege issue. It'd make this whole thing go much smoother.
What do you think so there's a discussion, okay, you can see it now. They've
typically,
what do you think's going on up at the bench right now?
Typically we call these sidebar conferences.
Right.
You'd have counsel from both sides get up there. Lots of times these are not on the record, so I'm interested to see if there is a court reporter actually taking it. If they are really talking about a specific document in this picture here, portions of that they want to get in the record, that typically will be taken by the stenographer or court reporter and recorded. So it could be specific testimony, it could be about a privilege that they've asserted, or it could be about an exact exhibit. Sometimes what you'll hear in these sidebar conferences when judges will rule, I'm going to let you talk about the first two paragraphs of this document, but I want you to talk about the next two paragraphs of the document. Unless the witness opens the door, they mention it, especially if it's an opposing witness, or that issue has now come about to where those facts are in play and allows you to get back into that document.
I thought this whole back and forth between Busby and Hardin was kind of funny, actually, where there's this argument about whether or not these exhibits are pre-admitted or not. What do you think about that?
Well, it comes back to in a real court of law, under evidence rules with a federal district court judge or a state district court judge, these exhibits, especially in civil cases, typically all the exhibits have been agreed to and they've all been ruled upon as admissible before you even get to the courthouse. That's not so much true in criminal cases, and so this is a little bit more common with the standard we have here beyond a reasonable doubt. And so But a lot of these should have been agreed to or not agreed to. And as you saw early this morning, when they got through all the motions, Rusty Hardin was the first person to hit his feet and say, we have said everything's admissible, and we just found out last night that they're saying they won't agree to a single document as admissible. And that's something that should have been taken up, because what happens is pre-trial, the judge can then make, they're the referee, they're the goaltender. I'm going to let in documents 1 through 15. I'm going to hold out, 16 through 20. Unless you can build a foundation to that, prosecutor or counsel, then I'll let that document in.
But do you think that Paxton's his legal team was caught flat-footed, that they really thought some of this would be dismissed?
Well, I think that they have planned this, their defense is to, knock the prosecutors off balance and to just kind of boggle everything, to just, the old phrase about if you baffle them, I think is the term that's used. And in particular, this tactic with Hardin of saying, well, I don't know, with Busby saying, well, I don't know, I can't find that. Where is that again? I can't find, what's that number again? Just pretending to obfuscate the whole discussion. It seems to be strategy.
Yeah, that's the reason why I really wish they had these exhibits to be posted to the public so the public could follow along. But that was one of the great things that the January 6th committee did, is they were able to post the demonstratives, the documents, and the evidence for everyone to see, whether it was the courtroom or on cameras.
And we
I do have an interesting point, though, I think, or at least looking at this picture. Tanya, if you notice, I think it is two of the counsel who are on leave from the Texas Attorney General's office are up there arguing sidebar conference.
Right, if you right over there behind Rusty Hardin, the bald guy with the beard, that's Christopher Hilton.
And so it's interesting, he's up there at the bench making some sort of sidebar argument, and I wonder if what they're really arguing up here is the privilege.
Yeah, I don't see Judge Stone, and I don't necessarily know what all the other attorneys look like. But that is definitely Chris Hilton.
And of course, it was Chris Hilton who came into the House Impeachment Committee hearing,
right.
Claiming that he wanted to testify to the committee. But when he came into the committee hearing, he went directly to the media and wanted to start making statements to the media. He didn't go in and say, "I want to give testimony."
Well, he was also the one that when they were heading, I believe it was the day before impeachment. Remember when they had the press conference? It's Chris Hilton that spoke. Mm-hmm. Came out and basically called this whole thing a witch hunt, and then Judge Stone has been actively very involved in fighting the whistleblower case. In his role in the Attorney General's office. But this is all very interesting. But I suspect with a guy like Rusty Hardin that you don't really knock Rusty Hardin off his pace.
Right. He's also got a pretty good, extensive team there too. Dick DeGuerin. He's got other lawyers.
He knows what he's doing.
That's one of them arguing right now. Typically, what I would do in a case like this, especially if I'm the lead trial lawyer, I would make sure one of the people on my team was the go-to person. I bet that's who's up there arguing for Rusty right now, is who's running point on the privilege issue, confidentiality, and especially someone's got to make sure this hearsay thing doesn't keep coming up.
Is this desperation?
I think this is throwing
strategy.
I think it's throwing monkey wrench. That's what you want to do. Is you want to disrupt the other side's cadence, and they're doing exactly what they should do with Busby and Cogdell, because this is the first day. This is their first witness.
Right.
It's an important witness, and let's see if we can slow him down. Let's see if we can make it so disjointed it's not very understandable. We don't want them getting on a roll.
We should explain to viewers too. I think we found out why we're not getting to see the exhibits.
Oh yeah, so I was going to talk about that. Yeah. So I texted one of our photojournalists who's in the chamber, who got one of the tickets to get in today, because there's a very limited number of tickets, and so the senators, the exhibits are showing on their iPads, but the cameras, the pool cameras, are not allowed to show the exhibits.
So they're sitting there looking at exhibits.
Right, but we don't have the ability to see them. It would be very helpful to be able to see them.
Right, and they're looking at, well, actually, right, an iPad.
Yeah, an iPad. Yeah, so that's why we're not seeing them. I don't know if that was part of the.
Up at the sidebar conference is Harriet O'Neill, on the prosecution legal team. I wonder if she's, like I said, typically you want someone on your team that's going to run point on all motions, sidebar conferences, especially. It's not uncommon in some of these sidebar conferences where they might want to take a break and do a little briefing or have both sides research the issue and bring it back to the court.
I wonder if they're going to keep going, or if, they had said before that it was going to be kind of a 9 to 5 thing, and we're almost approaching 5, so I don't know if they'll.
You can see, what's his name? Hilt talking.
Yeah, Chris Hilton is
that's Hilton.
fussing.
Yeah.
He's fussing on the left right now.
Yeah, Hilton is one of the attorneys that took leave. You can see him. He's the kind of bald-headed gentleman.
Out.
Yeah, he stands out. He's the kind of the bald gentleman with the beard, larger man. He's definitely one of those 6 attorneys that took leave to be part of Ken Paxton's defense team.
And I was in that committee room when the committee passed the motion to send it on to the House, and he later claimed that he was not allowed to testify. He came in asking to testify, and they refused to let him testify. Well, of course, when he barged in, he went straight to the reporter's box and started giving statements to reporters. The reporters all huddled around him. I don't think he ever spoke to anyone on the committee at all. He came in.
Did he ask to testify?
No, he came in and started having a press conference. The whole idea that he asked to testify, that anyone from the AG's
and you
office
were
asked
you were standing there.
I was right there. Yeah, the whole idea that he asked to testify was completely made up.
Well, Mateer had some great comments in his direct. One of the ones I wrote down that I thought was fantastic was he is said to Ken Paxton, don't do this, don't go in, don't intervene yourself personally. We've got other lawyers who can handle this. And he thinks they've settled the issue and they're moving on. And Hardin asked him, well, did you find out later that he went and talked to other people, that he only increased the frequency with Paul, and that he wanted the AG's office to step in other cases? And Mateer's response was, I was very surprised and disappointed.
How convincing has Mateer been? Mateer, he has obviously has the credibility and the resume. He's a little bit. He seems to drone on a little bit as a witness. How convincing has he been?
I think he's been quite convincing. I mean, he's certainly got the bona fides of a right-wing, conservative Christian lawyer.
Rejected for a judgeship.
Oh yeah, that's right. I forgot to mention that he had been nominated by Donald Trump.
Yeah.
To be a federal judge, and was rejected because of comments he made about transgender issues.
Right.
And I believe Brantley Starr, he mentioned him, they were working there together, who did go on and was confirmed as a judge. He's a judge here in the Northern District of Texas. But Mateer seems like a very honest, authentic, truth-telling person.
Yeah. I do want to kind of give, for folks who've maybe joined us over the last, who've recently joined us. So where we're at right now is there's a sidebar discussion going on, presumably about these executive privilege issues that Paxton's attorneys are arguing about. We've got the first witness on the stand. It's Jeff Mateer. He is the former first assistant attorney general under Ken Paxton. He was one of the 8 whistleblowers who came forward to complain about what they saw as Ken Paxton's systematic abuse of his office on behalf of Nate Paul, his friend and campaign donor. And then he's testified about how shocked he was, how surprised he was. Okay, I think we may be going back. Let's take a listen.
Members, we're going to, with a couple of issues to deal with. We've worked with both parties. They're going to work on the exhibits this evening, and then we're going to deal with the privilege issue in the morning before we start trial. So we're going to adjourn for the day now. You're to be back here at 9 a.m. tomorrow morning, which means in the dining room at 8:45, ready to walk out at 8:55.
recess for the day to go and hash out these privilege issues, which frankly doesn't really surprise me.
Should it take this long to hash it out? You seem to know right away.
Well, I think Hardin's made great arguments across the board as to the people in the room who do have the privilege aren't asserting the privilege if they do have the privilege to begin with. Because as the point that you made, Bud, is that actually, the privilege may be owned by the citizens of Texas. We're the client.
Not the office holder.
Not the office, the Attorney General. But more importantly, that they raised this issue right before opening statements. The defense did, and they've already sent all their documents. They produced no privilege log to begin with. This, to me, is just classic waiver. You can't assert it now. The cat's out of the bag.
It'd be interesting to see where Patrick falls on this issue because he's not a lawyer.
Well, maybe his son will text him overnight and let him know. But right now they've thrown some bump strips in front of this bus of the trial and to try to at least slow it down or bring it to a halt. And Ken Paxton, who kind of wanted to be in and out this morning by about 9:45 and have all the articles rejected on the first vote, will continue and go to trial another day.
Yeah.
Another thing to consider here too, which might be another argument that Hardin and the House managers might bring up is remember any communications that Paxton has already had, that one, it's admissible as a party opponent, any conspiracy he talks to, or non-indicted co-conspiracies is admissible. But also, if in these emails he has made statements and pushing someone to commit a crime, then there's the crime fraud exception to the attorney-client privilege. So to the extent that he does hold a privilege, that having communications about doing something that's improper, obstruction of justice, abuse of power, that would be admissible.
Matt, how would you kind of sum up the day, how things went for both sides?
I think it got off to a good start. I'm glad that we didn't spend a whole day on the motions. That went very quickly. I thought Patrick handled that very well. Opening statements, if you had to say anything, I think the defense kind of got the most time today. So if you were going just off of time of possession, I would say the defense team won that part of the battle today. But I do think the House managers had a great strategy in saying, we're not really coming here to argue and debate this. We're setting our theme up, and we're not going to take a lot of our time. We really want to put our time into the witnesses and the evidence so you can see that for yourself. I thought that was a great strategy. But, chalk went up for the defense team today. They were able to derail this. But I think if they can get these issues set aside, Rusty Hardin, the talented lawyer he is, that he gets to start off tomorrow morning, and he might be able to start running through witness after witness after witness. This first day, he was able to sort of remove most of these objections, hopefully, for his side.
Kind of shut this, hopefully, ideally.
So ideally, if it works out that they don't have to go through hearsay objections that are obviously not hearsay on their face, it's not saying there won't be other ones that come along here that maybe have to be taken up, but things that Kim Paxton said is 100% admissible.
You think we'll see Kim Paxton tomorrow, Bud?
In court?
Mm-hmm.
I doubt it.
Are you surprised by this?
I'm not surprised. I think he acts like he doesn't even need to be here at all because he's the Attorney General and all this is his privilege. No, I'm not surprised that he hasn't shown up at all. People could interpret it as showing disrespect for the Senate, but I think he is contending that this is his position and that he's acted within his authority.
How do you think that's going to go over with the senators, though?
Well, the question is how it goes over with the public. I think the senators are falling almost the way we thought. I mean, and some of the senators, we have these couple of senators in the bubble, but him not being there, let's face it, Busby is better than Paxton. Paxton is not a good attorney anyway.
And that's what Mateer said. He's
right,
not a litigator.
Yeah, and so Paxton's presence does not make that much difference. It almost works against him. He needs to let Busby be there. As far as the public watching, the lawyers watching, probably think that the prosecution had a good day. The public watching, seeing the entertainment provided by the Houston lawyers and hearing the defense say, well, look at his record and what a great defense. That was supposed to be one of his defense. He's facing these articles of impeachment, and they say, well, look at his conservative record, as if that's a defense, and saying, oh, it's the deep state, they're trying to get him and all that. The general public watching may side with Ken Paxton today.
That's just hard to buy when you look at a guy like Mateer. I mean, we're not talking about a deep stater. We're talking about a very, very conservative person.
We're talking about a certified faith and values, religious conservative who's just unquestioned, conservative strength. And this reflects this split in that faction of the party, which is the governing faction of Texas. And, we have two parties in Texas, but they're both Republican parties. They're the faith and values Republicans and the business establishment Republicans. And so, this is the party that rules Texas, and they're deeply divided on these Ken Paxton questions.
Okay, folks. If y'all have any questions out there in online, if you want to put them in the YouTube chat, we're happy to answer them. We're going to probably go here, I don't know, another 5-10 minutes, and then we'll wrap it up. Matt, if you were Hardin tomorrow, where are you going?
What's that?
Because they're going to, if you're Hardin, and because Mateer is going to be back on the stand, and presumably, right. I mean, we'll know where the executive privilege situation is going to be in the morning. Where are you going next?
Well, I think he's off to a pretty good start here, establishing that, because this is the thing, Mateer was in the office for a long time before Nate Paul came along. Mm-hmm. So it's not till July of 2020, during the height of COVID, that Paul starts appearing in these cases and clearly thinks he has bought something. He's entitled, he's made his donation, and he apparently gets access to the top lawyers at the Attorney General's office, even with access to their email addresses and able to get a hold of them for immediate contact. And so I think that came off very poorly for Paxton. And then, of course, the whole fact pattern starts off with Paxton insisting he's got to be the person arguing in this case. And, I think he knew he had capable lawyers who probably would have gone into this case and said, wait a minute, this is a charity being defrauded. And the last thing he wanted was someone going in there and doing a good job in this. And so tomorrow, I think Rusty's going to come back to Jeff Mateer, and I think he's got a truth teller. He's got somebody with an unimpeachable, right-wing, faith-based gravitas, and I think he's going to be a great witness for Hardin. And it'll be interesting to see what the cross is. Who's going to cross him? Is it going to be Busby or Cogdell? And how are they going to establish that? Because based upon their opening today, what they said, you would think they'd go hard line on some of these people, where they maybe don't go hard line or try to cross them very aggressively and back off. You might hear this argument, well, but Paxton didn't appear, right? So no harm, no foul. He didn't show up. He didn't argue something. And so what if he wanted to continue to handle these, matters and other issues for Nate Paul? In the end, he didn't really get anything.
Right. So we've got some folks ask, people do ask questions when I ask them for questions. They want to know what happens if he's impeached. So if he's impeached, he's removed from office.
He's automatically removed from office. Then they vote again on whether to ban him from seeking future state or local office. So he's been impeached. Let's circle back and say
been impeached.
What happens if he's already been impeached.
Question is removal now.
Impeachment is like an indictment.
It's if he's been found acquitted or guilty.
Right. If he's found, if the articles are sustained, is to use the exact word. If the articles of impeachment are sustained, if any of the articles is sustained, then he is automatically removed from office. He's gone, and then they will vote again on whether to let him run again.
And then somebody asked if, Matt, could you explain this, concept of reasonable doubt and what that means and what that standard is?
Well, I mean, it's not a science. You know, it's in the mind of each juror, and in this case, they would be the senators. But as the team for defense set out, they were trying to show that, look, you know, we have different standards. In civil law, we have a preponderance of the evidence. Lots of people will say that's more likely than not. That's 51%, or, you know, in favor of the plaintiff they're bringing the case. And if they meet their burden, being that. What they were trying to say was the House had brought these impeachment articles based upon that standard, that it's more likely than not that he committed these crimes and misdemeanors. But remember, it can be beyond a crime, and that, I thought Muir did a great job on that this morning, talking about that standard.
The difference.
That goes back to the Ferguson impeachment from 1917 or whatever it was.
Where he did
a long
testify.
time ago.
And so
Did Ferguson testify?
Yes.
Oh, okay.
And so, and you know what? That also came up in the impeachment of Donald Trump. If you remember, Alan Dershowitz showed up to argue that nope, it's got to be a crime. You can't be. You got to meet the elements of the crime. And so, you might see Busby and Cogdell for Paxton go that direction, saying that this is a lot of stuff that may look bad. Yeah, we don't want people to do this. It could be slightly unethical, but you can't impeach him for it. And I wouldn't be surprised if you saw that argument.
Well,
but tomorrow, I see Mateer being the witness, and then I believe they'll begin to hit the other 8.
So somebody asked, could today's confusion over what's an exhibit and what is not have been handled better pre-trial? And then they want to know, is that because the lieutenant governor's not experienced enough?
Yes, this is his first time to call balls and strikes and be in that sort of judicial role. And I think they thought that by having another judge sit next to him, and this is what I can't see on the cameras going back and forth, is, you know, I would really like to see Patrick leaning over and talking to the judge and saying, is that hearsay or not hearsay?
Right.
You know, and so that would be great. But yes, I think if you remember in the federal impeachment trials, we had a Trump. John Roberts sat in that position the first time around, so that we actually had a judge. But even in that case, the evidentiary rules were so lax that everything really came in.
And somebody else wanted to know, who did the best today?
The lawyers or the witnesses, or
I guess they mean either side. Yeah.
I mean, Bud, I mean, what are your thoughts on that?
Well, I mean, I think we expected Tony Busby to come with a lot of flourish and show, and he really has very little else to work with. And so given how little he has to work with, I think he got a lot of mileage out of it.
I come back to Andrew Muir.
He's so impressive.
I thought he was by far the best today, and we'll see if those first witness gets any better, but I think Muir was the best. I thought that was a brilliant strategy to not play your hand, not to be bombastic, and also not to take all your time. I mean, you know, that's one thing that drives jurors and judges crazy. Just because I give you an hour doesn't mean you have to take the whole time,
right.
Especially if you don't have something of value to going to advance your client's case. And saying the same thing 10 or 12 times in a circular fashion doesn't make it so. And remember, too, defense counsel promised a lot today. They promised a lot. And this is the thing that when I'm a prosecutor or plaintiff, lead trial lawyer, I'm writing down every statement the defense counsel says in their opening. And believe you me, when I get to closing, I'm going to say, when Tony Busby said this, where was that?
Right.
Where was that evidence? Did you see that? I didn't see that. But Dan Cogdell said, this is what's going to happen. When he called this thing a box of hair, we not only didn't see a box, we never found any hair. I mean, there was no evidence they put forward whatsoever. So you really want to hang these statements on them. And so, it'll be interesting. Do they really have these selfies? Do they from Lowe's and other places, and what they're going to try to put forward?
And who takes selfies of shopping at Lowe's? That's another question.
More importantly is think about this, because this is the predicament that Busby and Cogdell, and every defense lawyer has this, especially in a criminal case or a case beyond reasonable doubt, and that is that who's your proponent? who's going to take the stand and put the evidence out there?
Right.
So who has these documents? Who's going to be able to factually tell these instances that Busby and Cogdale have promised?
Well, you've promised information about the renovation, so who's going to get on the stand to vouch for the document?
Who's going to talk about the old ratty tile and where it is and what happened to it?
I mean,
We
are we
heard
going
about
to,
it.
Angela Paxton, is she going to get up and testify?
Oh, and by the way, since you mentioned her, I see that the reporters on Senator Paxton's way out asked her for her comment on the asked her for a comment, and she just sighed and shook her head and said, "Day one."
I mean, that's got to be a hard thing to sit through, no matter what.
It will be incredibly difficult for her, but she has stayed devotedly with Ken, going up to this, and so she's able to sit there quietly, and she's the one who doesn't have to worry about voting on this.
But to get back to your question about what reasonable doubt, as I said before, it's not beyond all reason.
Right.
So it's not an impossible standard. In fact, the U.S. Attorney's offices, or DOJ, has a 93% conviction rate in criminal cases. So, prosecutors are pretty good at getting to reasonable doubt, are meeting that burden. And you'll hear it's a heavy burden. But that's the reason we make it a heavy burden. We don't want to put people, whether we want to find them guilty of articles of impeachment, or whether it's a crime that we may put them in jail, we want the prosecutors to have to meet that heavy burden that's there. And to me, you know it. I always say to jurors, use your common sense. No one asks you to check your common sense at the door when you showed up here today or throughout this entire process. And when they start hearing from these witnesses, like Mateer and others, I think they're going to say, okay, that's right. It makes absolutely no sense Kim Paxton would want to go that hearing. It makes absolutely no sense that he would continue to work with Paul on all these matters.
And it's not right. It's not the one thing. It's not that he did one thing on behalf of Paul. It's all the things.
That's right, and that's the reason why I think you'll see as this builds towards the end and we get to closing for Rusty Hardin and Dick DeGuerin when he comes up, is going to be the weight. You're going to want to show that yes, we've not only met our burden, we have brought you in a moving truck and just dumped it right in the middle of the room. And you want to show, like, we corroborated this, we corroborated that fact, we corroborated this, whether it's direct evidence or circumstantial evidence, but most importantly, we have not only met our burden, we've exceeded it, we have brought you a wealth of
Well, they did a dump truck
riches
2
of
weeks
evidence.
ago when they dumped 3,700 pages and a whole bunch of videos. It was just a tremendous amount of material. I can't say I read every single word. I read a lot of it, and it was a lot.
This trouble at the end of the day, this bumpy road for Lieutenant Governor Patrick, is an example of why a lot of people felt like during the run-up to this trial. I mean, here's somebody who, Paxton's campaign owes Dan Patrick's campaign money. He's loaned Paxton's campaign money that won't be paid if Paxton's not in office. It's campaigns, it's not personal, but it's still that money's there. There are so many ties between the two. There are a lot of people running up to this trial who ask, why isn't Justice Hecht presiding at this trial? Why does Dan Patrick personally feel like he has to preside? This is the bumpy road that people expected. What happens tomorrow morning, Matthew, if we go in and Dan Patrick disallows all this as hearsay?
We got a problem. I mean, what
because
do
you're
do?
saying that,
do they
that it's not
appeal
hearsay.
it to the Texas Supreme Court, and we're with Hecht when we should have been with Judge.
But can
Justice
they
Hecht
appeal
before
it?
that.
I don't know.
I believe that's where it would go if there's a deadlock here, that they could potentially go there. But
The
it's
first
a good
place,
question.
the
I don't
first
know.
place it would go is to the Senate. The entire Senate can vote to uphold or revoke any decision of the judge.
Oh, so we could have kind of like we had the vote on the motion.
We could have another roll call and everybody could get reintroduced to the Senate.
Wow.
But I mean, if you're going to exclude all the communications between Paxton and his office amongst themselves, where they're
You
questioning,
kind of have to have that.
I mean, we don't have to me, that would bring a lot of political blowback onto Patrick.
Well, because in order to go through because all these matters relate to the way the office was run. So you're either and the senators voted to keep going.
Mm-hmm.
That's the reality.
And I will tell you, from having done focus groups and also talking with jurors after a jury victory, they become very interested at these sidebar conferences. And if all of a sudden a document doesn't make it in, the first question in their mind is, what are they trying to hide from me? And I think that's where the political blowback could be on Patrick if they exclude these sorts of documents. This is the reason that it was brought. This is what was all considered in, at the House.
Well, and most of these documents that would be at issue would be documents from the office. So it's kind of, I don't see how I don't know how you can really proceed with this if you don't allow them in.
And as Bud pointed out, it's the people's documents.
Right.
The Texas residents.
Okay, so any closing comments before I wrap it up?
Good luck, Tanya.
Well, this is about the 4th or 5th trial I've done. I have never done an impeachment trial, but I have done this with other regular criminal trials, and I always enjoy doing this. I think it's helpful and enlightening for folks out there to have the analysis to try to understand what's happening, because I certainly don't claim that I catch or hear everything or even understand everything, but this is a whole different world than what I've done in the prior criminal trials.
I don't want to over-exaggerate or sound like I'm trying to hype it, but I think we have a little moment of suspense here, I really think it's worth tuning in tomorrow morning.
It is. Well, we'll be back tomorrow. We'll get started. We'll start the live stream around 8:30, and then we'll start talking probably around 8:45 or so, and then they're saying they're going to kick it off promptly at 9. So, and then we'll see how Patrick has ruled. Bud will be back with us. Matt is agreed to be on standby. Should we actually, because they're saying we might have a Saturday in here. My kid has a soccer game that day, so we'll see how that goes. So I'll have to, juggle a bit. But today has been very interesting. We had all the motions. The senators voted to allow everything to proceed. There were 6 senators who voted in favor of eliminating all of it, and then there were a couple others that jumped in and out one way or the other. And then we saw opening statements with Andrew Murr, the House impeachment manager, basically saying that Paxton was not fit for office, and then he didn't use the word kingdom, but that he basically handed the keys of the office to Nate Paul. And then we heard from both Busby and Cogdell arguing that Ken Paxton that he was basically a victim of political retribution and a drunken speaker and all this stuff. But now we've had Jeff Mateer, the former first assistant attorney general, on the stand, and we've heard the recitation of his conservative bona fides. And he'll be back on the stand tomorrow, and we're going to find out how Patrick is going to rule on these matters of executive privilege. Anyway, thank you, both of you, for joining us. And thank Bernadine for having been with us this morning. And we will see you guys again tomorrow.